And it's red, it means it works. But in
Should I
order,
just keep it on the whole time?
no. And you
Council, are you all ready to make a start? Yes?
Yes, we are.
Yes? Whoops. Sick. Okay, just an opportunity to ask council for both sides whether any housekeeping issues occurred to you over the weekend that you would like to raise.
Yes, there's one housekeeping issue on our side. We would kindly ask for a possibility for Mr. Rand to potentially have a short break during the a longer block of cross-examination. He is turning 83 and may have some health issues which require short breaks.
Thank you. I hear for the record that respondents' counsel agree, and certainly the tribunal agrees. And if I forget to mention to Mr. Rand when he's called that he should just indicate if he needs a break, then please remind me and I'll do so. Excuse me. Anything from respondent?
Nothing further, thank you.
No. Okay, just a couple of issues from the tribunal. The first one is, and we haven't made a decision on this, and I'm raising it at this stage so that it will give both parties an opportunity to comment, and that is that the tribunal has reflected on the possibility that we may wish in the Q&A session to be able to ask questions to Mr. Broshko and Mr. Rand. We'll see how the cross-examination goes, and there's obviously and the redirect, and there's obviously time for the tribunal to ask questions. But it may only be after the end of the factual witness evidence during the course of the day that questions occur to us, as both Mr. Rand and Mr. Broshko are party representatives. Then we are assuming that they will be available on the Friday. But as I say, I'll give parties an opportunity to comment. Would you like to, Mr. Pekash?
Thank you, Mr. Chairman. I confirm that both will be here on Friday.
Okay, thank you. Any comments from respondent?
I think we would like to consider this, because I mean, it obviously raises the question of sequestration and how you want to deal with that. I mean, there are witnesses and party representatives, of course. So, I mean, but we hear the tribunal's wishes, and let us reflect on that.
Yes. Well, thank you, Mr. Keller. This, to a large extent, is going to be dependent on your cross-examination, because you may cover all of the ground. There is the issue of sequestration. We don't consider that we can sequester the party representatives for the whole week. But as they are around, we do consider that having regard to issues of weight and prior discussion and all the rest of it, that there may be a need to do so. But excuse me, please do reflect on it and come back. I'll give you an opportunity, perhaps before Mr. Rand is examined, for you to make any further comments. The second point is just to also to put you on notice that the tribunal over the weekend has been through the transcript and identified the key questions, or at least some of the key questions that we put to you on Friday. You no doubt will have done the same. We will review those questions after today, and it is likely that either at the end of today or during the course of tomorrow morning, we will give you a first tranche of questions that we would like you to return to on the Friday. I will also invite you to consider how you think Friday should work. As I said in the pre-hearing conference, unless you give closing statements, it's in effect going to be the tribunal cross-examining counsel for both parties. This is about the umpteenth time when we're saying to you, we're very surprised that you're not taking the opportunity to give closing statements, but we would like you to reflect on how you think Friday afternoon will work in circumstances in which we are going to be giving you lots of questions, and we will expect you to respond to those questions. And indeed, we may almost hot tub counsel for both sides in the sense of asking one a series of questions and then immediately going to the other. So do reflect sort of further on this. Okay, anything else from counsel from either side? Yes.
Thank you. If I may comment on this last point raised by the tribunal,
yes.
I obviously am not insensitive for the fact that this is the third time maybe or fourth that the tribunal is raising closing statements.
Yes.
The reason why we propose not to have closing statements and why we agreed on that is, I believe, the very heavy schedule that we have for this week, and especially on our side, we have the cross-examinations of Serbia's legal experts on Thursday, which means that we could only give you a presentation on Friday with like completely red eyes. And if
I
the
hear
tribunal,
violins in the background.
so if the tribunal would prefer the format of a closing statement, we certainly would not be opposed to having a closing hearing
Well, Mr. Prakash,
at an appropriate time, but this is just a comment.
thank you for that, and we'd rather assume that it's not unusual for there to be a little bit of a red eye on the last night, and we would attempt to accommodate that. But it's also the case that in large measure, the opportunity for closing submissions is for each of you to address the opening submissions of the other side, because candidly, there's a little bit of ships passing in the night at the moment, where claimants in your opening submissions have addressed in large measure, not exclusively of course, but in large measure, your merits claim with a tag on jurisdiction and admissibility, and respondent in large measure, but not exclusively, addressing jurisdiction and admissibility with some elements of merits. And you haven't taken the opportunity, or you haven't had the opportunity to engage with the submissions, the opening submissions of the other side. And from the tribunal's perspective, while these issues are live and fresh in our minds, it would be useful to hear you on what the other side has said, and indeed to draw any issues that come out of the examination of the witnesses to our attention. Now, we do appreciate that the parties have agreed on post-hearing submissions, and there will be post-hearing submissions, but this is an opportunity to address us on those dangling issues. But if you don't, we will inquire of you on those dangling issues. It's just a question of how you would best like to organize it. So do reflect on it and discuss it. We're not going to give directions that are contrary to the parties' agreement as we settled in the excuse me, in PO6 and at the pre-hearing call. But we do wish to get to the bottom of issues that we are not completely informed on. Okay, anything else? No? No? Okay, then let us call Mr. Broshko. I should perhaps just say one more thing before you call him in. And that is to say that I hope that the examination is not going to be an examination which is replete with objections. If there are objections to be made, you'll of course address them to me, and I will rule on those. Anything that is within the broad scope of the witness statements will be admitted. If you, of course, ask a witness what he had for tea, unless you are going to join that to something that's relevant, obviously that's not going to be allowed. But we're going to move this forward expeditiously. Okay, thank you. Morning, Mr. Broshko. Sorry to keep you waiting, but we are sticklers for time, and it's now 9:31. I'm going to, in just a moment, ask you to make your witness declaration. I believe you've got a copy there in front of you. Before I do so, let me say that if at any point you need to take a break, of course, we'll be accommodating, so just let us know. With that said, let me invite you to turn the microphone on and make your witness declaration that is in front of you.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. I think.
Morning, Mr. Broshko.
Good morning.
Mr. Broshko, do you recall submitting 2 witness statements in this arbitration?
I do.
Do you have the witness statements in front of you?
I do.
Could you please go to the last page of each of your witness statements and confirm the authenticity of your signature there?
Yes, that is my signature.
On both of them.
Correct.
Thank you. Mr. Broshko, could you please describe briefly to the tribunal how you got involved in Obnova?
Sure. In my career started in the legal field. So I was a corporate and securities lawyer with a large Vancouver law firm for about 7 years. I practiced also quite a bit of transactional law. And while I was practicing law, I did an MBA at the University of British Columbia. And when I finished that, I kind of left at least the private practice of law. And I went and ran a public biotech company for 7 years. And when that finished, I was wondering what I was going to do. And I was talking to friends, and one friend in common, who also used to be a lawyer and was in the business world, said, you know, I think you got to sit down with my friend Bill. And I certainly knew of Bill. He's very well known in Vancouver. And so I met with Bill, and we had a number of meetings, and we were actually looking at resource companies, and nothing came to fruition. And then we had lunch at Hotel Vancouver, and he said, how'd you like to go to? And I thought he said Siberia. And so I thought, Siberia? And he says, no, Serbia. And I was trying to picture where Serbia was on the map and whether it was on the water. And so he explained that he'd acquired a number of companies in Serbia out of the privatization process. He kind of told me what that was all about, because I'd never had any experience in that. And he said they were operating companies. And so he gave me a kind of very high level description of what they were. With respect to Obnova, he said it was a scrap metal that was small, wasn't making a lot of money. He says, but it was a real estate investment. And he told me, he says, it's got some land by the river, it's in the city. And he said, but look, why don't you think about it? It's a big ask. Talk to your wife, who was on maternity leave at the time with our second boy. We know it's three. We have three, and she was game. And so within 7 weeks, we moved to Belgrade. Our littlest one was 2 months old at the time, and we lived there for 6 months. And so he had tasked me effectively with understanding the companies, trying to understand the Serbian system, which is very different from Canada's, and to report back to him on operational issues, report back to him on kind of HR issues, whether or not we need to change managers or supplement them. And so as time went on, I did that, and that's how I got involved and knowledgeable about Obnova.
Thank you, Mr. Broshko. Did you inquire about the rights that Obnova had to its buildings and land?
Yeah, I found out the rights that Obnova had more kind of indirectly. It's not that I was going there to determine what are Obnova's rights, because when somebody tells me we own the company, as a Canadian, you just kind of assume they own the company, they own the land, they can develop it. And that's kind of where my mind was at the very beginning. But as part of my understanding each company, having it explained to me, we engaged PricewaterhouseCoopers in Belgrade, and we had worked with them in terms of having them explain to me kind of the nuances of each company. What were some of the issues and so forth. And it was at that point where they explained to me what Obnova's kind of circumstance was. And they had explained to me, they said, look, this is a bit different than Canada. And so I was on the site a number of times. They said, those buildings there, Obnova owns these buildings. I said, okay. But they only have this, what's called a right to use the land. And I was, okay, well, can you explain that to me? So they explained that further, and they said, but, they have this opportunity to convert it in ownership. But this was 2012. And they said, but, the cost of doing that is not insignificant. So they kind of explained the general system to me. And I was like, okay, so I think I had a pretty good understanding at that point. And then we moved to Kranovic and Nikolic. That was kind of, I guess, about 2 months or 2.5 months after we'd engaged Price Waterhouse. I thought Price Waterhouse did a good job, but I just wanted a more established and larger law firm because we had HR issues that we wanted to deal with, and PwC wasn't in a position to deal with that. And they basically confirmed the advice that we had gotten with respect to the explanation of Obnova.
Mr. Prakash, can I just draw your attention to 23A of PO6, which provides that a factual witness may be briefly examined for purpose of asking introductory questions, including about corrections to be made to the witness statement and of addressing matters which have arisen after the witness statement was signed. Now, the tribunal has, of course, read Mr. Broshko's witness evidence very closely. It seems to me that you're taking him through his witness evidence rather than asking for corrections or post-signing issues. Let it go, but I don't think it would be appropriate for you to go on too long on that.
I apologize, Mr. President. That was my understanding of introductory, but I take that. So in that extent, we will maybe just one question. Could you please describe very briefly how Mr. Rand, Mr. Markicevic, and you work together?
Sure. I would describe Bill as the owner. And so when I use that term, that also includes ownership that ultimately was moved to the benefit of his children. So Bill is the owner, Bill is the investor. Bill is at 60,000 feet. He makes the high level strategic decisions. I'm like at 30,000 feet where I am his representative in terms of providing oversight of his assets. I'm not in any way management. I just provide this oversight on behalf of Mr. Rand. And Igor is our guy on the ground, both in Serbia and I'll say on the ground. I mean, he's been to Cyprus, but he's been on the ground and deals with the Cypriot matters along with our people in Cyprus. And it's kind of moved. I think it's evolved over the last 13 years in the sense that as Igor and I have become increasingly familiar with the assets that we're overseeing, and as Mr. Rand has gotten older, he's now approaching 83, we bring to him those things that he needs to decide upon. We don't burden him with details. He wouldn't be interested in that anymore. There's a time when he'd review a 20-page agreement. He doesn't do that anymore. He delegates those tasks to us, and he's given us, I think, trust in knowing that we bring to him the decisions that he has to make. And I think that fits in with this time of his life and the fact that we have a pretty good grasp of the assets we have and what we need to do.
Thank you. That concludes the direct examination.
Thank you very much. For the respondent, who's going to be taking the cross? Mr. Keller, over to
It's
you.
going to be me. Good morning, Mr. Broshko.
Good morning.
My name is Moritz Keller. I'm the counsel to Serbia in these proceedings. I will ask you a few questions about your witness statement. I mean, I would appreciate if you keep your questions, your answers clear and concise. I try to keep the questions clear and concise so that we can move through this in an efficient and expedient manner. I'd like to start by just really establishing context, the basics, and I think you touched upon that now. On questions from claimant's counsel already. So you're saying you started out as a lawyer, essentially, securities corporate lawyer, but then you also moved on to management functions. And I think there was a biotech company. Is that correct?
That's correct. I was CEO, and then I was and a director, corporate director, and then I was executive chairman after that, and no longer CEO.
And you're still a lawyer, though? And
I'm still a practicing lawyer. That's correct.
Still a lawyer. Then, of course, I mean, you also in your first witness statement, I'm sure you know that, you've said that since the beginning of 2012, you've been the managing director of Rand Investments. And then the following sentence, you've repeated that again, that you're the managing director of Rand Investments. Could you explain to us, please, I mean, what does managing director mean?
Sure. The term and managing director is in the world of private equity and investment banking and finance is being a managerial term. So managing director, the way we came to the title is when I started working with Bill, we kind of had a brief discussion of, okay, well, what should your title be? Because I was here to represent his interests. And at some point you want to go and you want to be able to say, I represent Mr. Rand. And I suggested the term, well, managing director seemed to be appropriate because it was a managerial concept that people in the private equity world would understand. And so that's how we came to it. And I think it's fair to say it's a very well understood managerial term in that context.
Okay, but so just to be very clear, you've never been a senior executive of Rand Investments.
What's your definition of senior executive?
You've never employed by Rand Investments.
Well, I've never been employed by Rand Investments. I'm engaged through consulting agreements. I've never been an officer of the company. I've never been a director of, like, in the corporate sense of the company. I've been a manager, like a senior manager of the company. Like, I think we found one news article where it said Goldman Sachs a couple of years ago had appointed 609 managing directors. So in this world, a managing director is a managerial position.
Now you said manager, but just to be very clear, and I think you said that you've never been an employee, you've never had any specific corporate function, you've never been an official representative sitting on the board or otherwise of Rand Investments. Is that correct?
I think you have to be more
We
clear,
can take it
if you don't mind, because I mean, an
Let's
official
break it
representative, I
down.
mean, like, there's a lot to unpack there. So
Let's break
can
it
we-
down.
yeah,
So you've never
right.
been an employee of the company.
I've never been an employee of the company.
You've never been on the board or in any other sort of function appointed, listed in the corporate registry or anything like that. Is that
I have
correct?
never, so I've never been a director. I've never been an officer of the company.
Okay. Have you been a representative of the company in the sense that you were able to make decisions on behalf of the company?
The only decisions that I can make on behalf of the company are those that are delegated to me by Mr. Rand. Now, of course, I don't go back to Mr. Rand on every little thing. So when Mr. Rand said, Erinn, can you book my ticket to Paris? I said, absolutely, but I didn't have to go back to him and get the approval of the price and get the approval of the seat. When we deal with things in Serbia, we go to Bill, we seek the high-level instructions from him as the owner and the person who instructs us. And with that in hand, with that responsibility, we undertake our tasks. So everything in all directions ultimately flow from Mr. Rand, but that doesn't mean that Mr. Rand, focuses on the minutia and from a molecular or micro point of view and makes every single decision. I mean, it would never be able to work that way.
That's going into kind of different territory. The question was whether you were representative, but again, maybe let's break it down.
Sure.
Did you sign contracts on behalf of Rand Investments?
I have. I'm trying to think when that would be, but it would only be at the direction of Mr. Rand.
Okay. Would you speak to authorities or contractual partners as a representative of Rand Investments?
Have I spoke to people and said I'm a representative of Rand Investments?
Yes.
Yes, I have.
Okay. Thanks for clarifying that. I mean, in a way, when you have an interesting career in the sense you're a lawyer, but you're also familiar with and have acted in lots of business corporate functions, right? And I'm sure you've dealt with lots of transactions in your life. And maybe just on a very high level, I mean, if you enter into a larger corporate transaction, you buy a company or you issue shares or something of that sort, would you agree with me that you would normally do a due diligence before you do that?
Before we entered into a substantive transaction?
You buy a company, you sell a company, you enter into, I don't know, a long-term.
Like, would we do our homework? Yeah, of course.
Okay. What would that normally entail?
It depends what the transaction was like.
If you buy a company?
Well, we've bought in small companies, we've bought in bigger companies. Yeah, again, if you can be more specific, I could.
Well, as a manager in your biotech company, for example, if you would buy a company in due diligence, how would you go about it? Would you hire someone externally? Would you look into the accounts of the target company yourself? I mean, how would you go about that kind of process?
So with respect to the biotech company, for example, I mean, it was along the same lines. We licensed technology from University of Toronto and Princess Margaret Hospital. And so our due diligence was understanding the technology. We engaged counsel to provide an opinion on the patentability of that technology. And then we did our own business due diligence, which we may bring somebody in if we need to, or we had people on staff who could do it. So it really gets tailored. But yeah, of course, you do homework.
Excellent. how about the real estate sector before working with Mr. Rand? Did you have any experience in the real estate sector?
Not particularly. I mean, we dealt with some companies when I was a lawyer that held real estate assets, but that was more on the corporate side. I was not a real estate lawyer. It's kind of a niche area in a way, as real estate law in Canada per se. But yeah, certainly. I mean, I dealt with some REITs that held real estate assets, but we were advising from a corporate perspective.
And then I take from for your question about Siberia, yet you've had no experience in Serbia specifically before working for Mr. Rand?
I had no experience in Serbia before I went there in 2012. That is correct.
Okay. And you've worked for him for now about 12 years. That's also correct, right?
Almost 13 years.
Yeah. And we've touched upon that already. I mean, in your function as managing director, which you said in your first witness statement. Then in your second witness statement, I'm sure you have it, but you can also look at it, it's per 8, 9, 10. I think you then explained that, as we just discussed, you've never been an employee, officer, or director. And everything that you've done is essentially based on consultancy agreements, right?
That is correct. Those are the foundational documents of my engagement.
And in your first witness statement, you said that you, back then you still said the managing director of Rand Investments, and then you go on and saying that you receive a base compensation and that you're eligible for certain bonus payments. Is that correct?
That's correct.
That's an accurate description. Now that we've learned in the meantime that you have these consulting agreements with a company called, I think, Anacott Consulting.
Correct.
So it's that consulting company that receives the compensation, actually. It's not you.
That is correct. That's a company owned by me and my wife.
Okay. Are there any further additional corrections that you want to make to your witness statement other than this managing director complex? Let me
No,
put it
not
like
that I know of.
nothing else. Okay. I think you also said in your witness statement in this phrase that we just looked at, that part of the compensation depends on the success of the investments of Mr. Rand. Is that correct?
That's correct.
And that would include Obnova,
All the companies.
all the companies. So, how can we imagine this compensation to work? So you say there's a base compensation. If I hear base, normally I would assume that's relatively low in comparison to the success or profit component, or however it's called in your consultancy agreement. Can you enlighten us a bit? I mean, to what extent would you be profiting from the success of Obnova, including through this arbitration?
So you may be familiar with real estate prices in Vancouver. It's very expensive. And so for us to live, I need a base salary that would allow us to be able to ensure that we have a home and a roof over our house for our kids. And so I'm paid a fair wage, a monthly wage. And the way it works, and it's not just for me, Bill has this approach with pretty much all of his close advisors, which is if we get good success in a company, I'll come into his office as you know, at his home, and we'll talk about, oh, well, what's fair to give you? I mean, that's really how we've done it over 13 years. We don't really outline it in detail. And so if something happens, or if we've worked, you know, there's been a year where we've worked really hard, we'll have a scotch at Christmas, and I'll think, well, X is fair. And they'll say, maybe it's Y. And within 3 minutes, we've had an agreement, and that's it. That's how we do it. It's a very trusting, and it's not very prescribed. I mean, other than the monthly amount.
So there's no obligation, clear obligation to pay you an amount of X in terms of a profit of Y.
No,
that's coming out of that. But is it in comparison to the base compensation? Is it a significant amount, or is it smaller than or insignificant in comparison to the base compensation?
It depends what year. It depends what year. And, you know, last year, it was just base compensation.
Well, let's go crazy, shall we? I mean, let's assume you'll get 45 million in this arbitration.
Yeah. Well, I don't know what my compensation would be on that, but I hope it would be fair. We put a lot of work into it.
Okay. Will it be 40,000 or 4 million more in the ballpark?
I don't know what the answer is to that.
Okay, I'll take that. Let's perhaps move on to another topic, which I think you touched upon a bit, which is the scope of your responsibilities in working for Mr. Rand.
Sorry, could you repeat that? Maybe you can move that forward if you can.
Of course. I said, let's talk a bit about the scope of your responsibilities working for Mr. Rand. And again, maybe just start by establishing the basics. So you started in 2012,
Correct.
And you moved to Serbia to supervise all of his Serbian investments, right?
Correct.
And then I think you also just explained upon questioning from claimant's counsel that it's the three of you, Mr. Markicevic, Mr. Rand, and you, really?
Well, I mean, there's other people that are involved in the ground in Serbia.
Oh,
and
I'm
so
sure.
forth. But in our close group, I mean, that's the three of us, sure.
And how often would you report to Mr. Rand? Now, not thinking now, because you said, I mean, that has changed over time. Perhaps we were starting in 2012 and then from then onwards, because that's the time we're interested in.
Like, how much do I report to him now, or
No,
in
back then.
2000 in 2012?
Starting at 12, you moved to Serbia. How
Yeah.
often do you report to Mr. Rand?
Maybe like 2 times a week while I was there. I mean, at the very beginning, it took me a while to figure things out. You know, it's not like you just land there and as a foreigner, you have a
Okay, so that's fine. I mean, how would you report to him?
we'd phone him, or I'd phone him. I mean, I don't think we had like video calls in those days. And I mean, there was Skype, but the internet was not very good. So almost always I just phone him.
No emails.
I'm sure there's some, but I mean, Bill's a phone guy. He doesn't like reading long emails. That's not his thing.
What about if there was a significant decision to be taken? I mean, how would you prepare that for Mr. Rand?
Again, it depends. Like sometimes we'd have initial discussions where we'd say, okay, this is what we're considering. What do you think? And if he says, oh, I think it's a good idea. Okay, so we'll proceed. We'll do our, diligence that's required to be done. We'll talk to, whether it's the lawyers or whomever. So we get to a point where we're comfortable with the approach. We would then nowadays, we could get on a Teams call and we would explain it to Bill and we would tell him what the high level terms are. And he'd say, I agree or not. I mean, for example, Bill was a major owner of an oil and gas services company, public company. And in that particular case, I was assisting because I was also on the board of that company. That corporate board is a public company. And I was executive chairman of that company. And so we were taking the company private, which is, there's a lot of paperwork. It's a public company. Bill's not looking at all that paperwork. So we made a decision. We said, what do you think? Take it, because he was a majority share. Do you want to take it private? Yes. Okay, we'll deal with that. We inform him. We say, okay, we're having the special meeting first. Everything gets prepared and submitted. He's not reviewing that. Then we have the secondary paperwork. Then we have the ceasing to be a reporting issuer. So we keep him apprised of the steps and he's got a general sense of what's going, because he used to practice law. But no, we're not sending him, super detailed emails with every step and every document. No, there's no need to do that.
Okay, so no emails, phone updates, but you would share the documents.
No, I
with
didn't.
him.
I didn't say no emails. I see there is email correspondence on different things that we work on, but generally speaking, it's much more effective with him to have him on the phone, to be able to explain so he can ask questions. And yeah, sometimes you have if it's more complicated, you want to make sure you start from the beginning and keep him apprised as it goes on, so he has a better appreciation for it as time passes.
Okay, that's fine. But I mean, if you keep him apprised, as you said, you update him on the phone and send an occasional email as well. So would you send him the documents? Like, would you send him a contract? Would you send him I don't know, a decision by an authority, whatever the relevant document in that context may be.
No, well, I mean, you mean from Serbia?
From Serbia, yes.
So, I mean, what kind of document would you be thinking?
I don't know, you're entering into a contract, you get a letter from an authority, you get a decision, could be anything really.
An agreement.
Yeah.
Well, I'm thinking maybe, maybe not. And if we sent it to him, we wouldn't, it would just be like FYI, we wouldn't be sending it to him for his review, like for his review, because he's not going to review it. He expects us to do that.
Okay. Now going back to 2012,
Yeah.
when you did go to Serbia first, it was Mr. Obradovic at the time who was Mr. Rand's guy on the ground in Serbia.
That is correct.
That's correct, right? So I assume you met him then
I have met him, yes.
as soon as after
That is correct.
you came to Serbia.
Yeah.
And I assume you perhaps got a briefing from him on what's going on with relevant companies. Or
I did.
good. Mr. Obradovic, I think, I mean, you probably know him, and I think you were involved there as well, was also a witness in the previous arbitration
I'm aware of that, yes.
against Serbia. And he seems to be one of the central persons there, being Mr. Rand's guy on the ground, at least at the time. But he's not testifying here. Do you know why that is?
You'd have to ask our counsel.
So you don't know.
Well,
Oh, it's fine if you don't know.
no,
Just,
well,
just say.
I mean, issues of strategy and investment arbitration of where I don't practice. We rely on our counsel to tell us who needs to give witness testimony, and we follow their lead. Now, I mean,
So you don't know. That's fine. And we
do
can
I
move on.
know why we, for example, we called Igor and Bill and me?
No.
and
The
not
question
Mr.
is
Radovic?
why Mr. Obradovic is not here. The question is limited to that. It's yes or no.
Well, he's
you
not
know?
here because we didn't call him. And why exactly we didn't call him as of 4 years ago? I mean, you can inquire with our counsel as to why that decision was.
Okay, so I'll take you to want to answer that. That's fine. Let's move on. Again, we were staying in 2012. And perhaps let's take a look at your witness statements. I think it's your second one.
Okay.
I think it's paragraph 15, where you say, and I'm quoting, paraphrasing, I confirm that when I came to Serbia in 2012, no one informed me about any problems related to either to 2003 registration of Serbia in the city of Belgrade, nor the alleged rejection of Obnova's legalization request in 2004. And then it goes on, Mr. Rand had always made clear that his aim was to develop Obnova's premises for residential and commercial use. Neither he nor anyone else mentioned to me that this could be affected, yada, yada, yada. Correct?
Correct. I see that.
Good. So that is, I mean, the way I read it, that's based on Mr. Rand's briefing or the information that he provided to you at the time.
That would be part of it. I mean, his briefing to me before I went to Serbia was, of a general nature. There were, I think, 5 companies. And again, Bill's nature is to say, this is what I have. This is what I'd like you to do. Go figure it out. And so when I say I confirm when I came to Serbia, so that I don't mean at the moment I came, like I landed in Serbia and nobody informed me. I mean, when I came to Serbia in 2012 and I started to then find out who's who there, with the companies, I started to learn what they were doing. Then when I engaged on behalf of Mr. Rand, Price Waterhouse, and then Kranos Nikolic, nobody there had told me that there was or would be an issue with this incorrect registration. And frankly, the rejection of legalization, I didn't even know anything was rejected. But with respect to the incorrect registration, I was told that it was incorrectly registered, but it was explained to me both by PwC and by the subsequent lawyers that we could just fix it. That's what was advised to me.
Okay, then maybe again, let's break it down. In turn, did you speak to Mr. Obradovic and get a briefing from him that confirmed what you just said? So there's no issue. There might be an incorrect registration, but it can be fixed as you just described. Was that the briefing that you received from him? He was the guy at the time, right?
Yeah. I'm sure I would have had a discussion with him about this, but I certainly would not have relied on his assessment of this. He's not a lawyer. And so the only comfort that I would have gotten kind of from a substantive level was through my engagement on behalf of Mr. Rand of the advisors that I had just noted to you.
And I take it, I mean, there are no documents or written briefings that you received from Mr. Obradovic around this. Emails.
Mr. Obradovic was definitely not an email guy. He that's not how he.
So
worked.
there are no documents, yes or no?
From Mr. Obradovic?
On the briefing of
No.
the property law
No,
situation?
no,
Okay.
no.
So you mentioned PwC. We haven't seen anything from PwC here. There are also no documents from PwC, is that correct?
So the nature of the advisement, and as somebody who's practiced law, some things we get in writing in the sense that maybe there's an email. And again, this is back in 2012. This is not today. And so some stuff would be in writing. So for example, when we were doing the 2012 restructuring, there was a lot of communication back and forth, but there was no like opinions of saying, here's our formal legal opinion. I don't need that. We're on the phone. We explain what we want. I have an understanding of the circumstances. And so, for example, I think Cyprus is a perfect example. We have lots of correspondence.
Well, let's stay on Serbia, please.
Okay, well.
So documents from
Serbia would be the same,
PwC,
yeah.
no legal opinion. No
Pardon me?
legal opinion from PwC on real estate rights.
We got a legal opinion, but whether or not we asked them to formalize it in a piece of paper, we didn't need that.
No written legal opinion. Let's be specific then. Yes or no?
Not that comes to the top of my head, no. I mean, again, this was.
No email about it. Just answer the questions, please,
Well,
Mr. Broshko.
well, I
No
did my-
email from PwC on this.
Well, no email. I mean, my recollection is I don't recall like a legal opinion in writing, whether it be through email or any other channel. But I will say,
Meeting notes, call notes,
so-
anything in a document showing what you just said, that you got this advice.
no, because I don't take meeting notes. I don't need meeting notes. I mean, this was explained to me as a no-brainer. Like, this was not a very complicated thing. Like, what was explained to me was that this company went out of privatization, okay? And although, I didn't have an English version of the privatization agreement, so I can't read it. Statutes in Serbian are, although there were some translations at the time, but some of them were kind of confusing. They're in Serbian. So I'm dealing with English-speaking lawyers, and I'm asking them on these 5 companies what the status is on the ground. And it seemed pretty straightforward to me. They said, basically, Mr. Rand, through Mr. Obradovic, bought Obnova in the privatization. They own all the buildings that you see there, because I've been there many times, and they can use this land. And they'd explained that there was this conversion to ownership that you got to pay. And I'm like, well, Bill's not going to pay because he's not going to develop it right now. So Bill will just be patient. And the company Obnova basically kind of took care of itself. At that time, we already had started to lease out the land. So it's not like it cost us any money. When I say us, Bill. So it just was kind of self-fulfilling. It just kind of went around. And what gave me comfort was the fact that when we went to the second law firm, the advice that I gotten from PwC, so Kranovs Nicholas, the advice was confirmed.
Yeah, you mentioned that also for the first time and indirectly there was a second law firm. So, but let's stay on PwC. So no written document of any sort confirming what you just said, recording in any way this kind of advice, information that you received.
That Obnova owned its buildings?
Everything. Anything from that time confirming the advice or information that you received from PwC?
Not that I can recall on the spot, no.
Okay, thank you. So then you moved on just now. I said there was a second law firm that you did go to. When was that?
maybe like April of 2012.
Or
I'd have to go. you know,
2012. So in
It was
the, in
2012.
the early days.
Correct.
Again,
Yeah.
any written legal opinion, email, summary of advice or information that you received from them
Any legal advice that we received from them?
at the time
About-
about the issues that we just discussed?
No, because I didn't think there were issues.
Okay, so no written document on that as well.
Again, to be clear, we didn't think there were any issues. So when they explained this to me, I was, okay, well, this is pretty straightforward. So I wouldn't need a legal opinion in writing to explain to me something that I thought was pretty simple and straightforward. So
Okay. So you get an oral briefing from Mr. Obradovic, you go to PwC and later you go to Karanovic. Did you do anything else in terms of your due diligence around the situation at Upnova at the time?
sorry, the separation of
The issues at Upnova at the time. So it's still 2012, you arrive in Serbia, you familiarize yourself with the situation. We have Mr. Obradovic, you heard your statements around PwC and Karanovic. Is there anything else that you were doing, compiling documents, hiring other advisors, just to get an overview of the situation over?
So, I mean, you mentioned a briefing of Mr. Obradovic. He's not an overly sophisticated guy. So, you know, he could give me his sense of what the situation on the ground was, but it's not like I was going to be taking this as advice that could be relied upon. Because of this, I said to Mr. Ann, I think we should engage, okay, first PwC, and then we moved over to Kranovic and Nikolic. We had completed the 2012 restructuring. I'd gotten advice. Obnova was just one. There was, 5 companies. And so, but including Obnova, what's the status? What's the state? Again, we didn't think there was any issues. So it was pretty straightforward. You're asking about other advisors. Fast forward. I had advised Mr. Rand that I thought that we needed more competent, kind of on the ground advice in Serbia. And so I'd spent quite a bit of time looking for, and spent a lot of time with the Novak Tennis Club. So I knew a number of people there and they kind of helped me out. And so we had narrowed down like 4 or 5 people to speak to an interview about taking kind of on a central managerial role in Serbia because I wasn't.
Sorry, Mr. Broshko, you're already moving on to another topic and we'll get there.
Well, you're asking me about advisors. I was explaining that we did bring in
that's fine,
another
but
advisor.
I want to stay on the briefing, on the information that you received or were collecting at the beginning when you were moving to Serbia. So did you collect yourself any documents, or did you receive like a package of documents around Upnova, like, I don't know, keyed contracts, association, memorandum of associations, corporate statements, bank accounts, well, whatever you would expect, right? I mean, if you take a look at a company, did you receive something like this?
So everything is in Serbian, right?
You tell me, mine could have been translated, right?
Well, okay, well, I can tell you everything was in Serbian. It was not a regular course translation to English. The operations, which at that time had kind of evolved from this small scrap metal to now leasing out its premises. This was in terms of operationally, it was a small cash flow business. I didn't need to get involved in that kind of thing. What was important was Mr. Rand's instructions on the high level stuff. This was not meant to be, a continuing scrap metal business. This was meant to be, he saw the value in this because he wanted to develop it. So I asked just the basic initial questions. What do they have? Legally explain this to me because I didn't understand the Serbian system. And as I explained to you, they had explained it to me. And it seemed pretty straightforward. And it didn't seem like there was any material hurdles.
Okay, were you shown any documents and, for example, construction permits?
They would not have shown that to me.
Lease agreements?
They would not have shown that to me. Well, I wouldn't have needed to know that.
Correspondence with authorities?
So sorry, should I answer that?
Yes, please go ahead, sorry.
So when we instruct our advisors who are Serbian, the instruction from the beginning is I need to understand with these 5 companies what the status is. Like, I need you to explain this to me. What is the deal? What do we have? What do we don't have, et cetera? So I leave it up to them to advise us in terms of the status and to look at what they need to look at to be able to tell me with comfort, this is what this company has, this is what this other company has, and so forth. With respect to, for example, any construction permits and so forth, I'm sure they would have reviewed them. But I didn't review them because they weren't in English. And I didn't want to spend my time reviewing contracts. I'm not a manager. And so going down there, in fact, part of this was when we were at PwC, they did a good job. We wanted, again, as I said, we wanted other advice with respect to employment law and so forth. But I thought we could get kind of more detailed, nuanced advice. And that is when I interviewed, I don't know, 2 or 3 other law firms. And then we settled on Slobodan Dokostich at Kranovic Nikolic. And he did a very good job. And he's a very detailed guy. So he would have looked at everything he needed.
So you're going on again in other territory. We're talking about the documents. So you said
Yeah.
they were not shown to you. I mean, but the documents were there.
Well, when you say the documents were there, I don't
All
know
kinds
which.
of documents. Was there a proper archive of construction permits, contracts, accounts, even if they're in Serbian? I mean, these documents, did they exist? Did you see them?
Did I see some? I'm sure I've seen some documents. I mean, I went to Obnova. Obnova had buildings on the side that had documents that they held, but did I go and review them? No, because I
And
couldn't
who
read them.
provided the documents to the lawyers then? Have the lawyers looked at them?
So we introduced the lawyers to the members on the ground.
Who is that? Who's the members on the
Whoever the
ground?
manager was. I can't remember who it was at the time. But again, it was not just Obnova.
So was
there
Mr.
5
Obradovic,
companies.
or who was it?
No, they wouldn't. I mean, they might have inquired with Mr. Obradovic and said, we need this or this, or they would have just talked directly to, the manager. I don't know exactly how they did it logistically.
But you
they
don't know who the people were, and you don't know which documents were shown to the lawyers.
No, because I didn't know what was relevant and I couldn't read them. But I had faith that our advisors were sophisticated and that they were going to review what they needed to give me, their sense of what was on the ground.
Okay. So let's perhaps take a document. It's a bit later. We're moving away from 2012. And that's document exhibit, I think, 3337.
Can I have a
Put
copy of
that
it?
on the screen? Can you read that okay? Or we can also move, you have a screen in front of you.
Oh, I
but
see. I see.
We can move it closer if that doesn't work.
Okay.
So that's an email, I mean, just for the record. So that's CC37. It's an email between you, Mr. Rand, and has Mr. Markicevic in
I see that, yeah.
CC, right?
Yeah.
Can we move down, please, in the document to the probably highlighted one? No, not that one. Sorry, further down, it says Obnova property registration.
I see that, yeah.
So this is a bit later, as I said, so we'll be at 2014 now, but there's clearly a discussion between the 3 of you about Obnova's rights in Serbia. You can see highlighted in the first one, it says large parcel, the land is owned by the city of Belgrade, Obnova has the right to use this.
Yeah.
Down there, there's a reference to illegal buildings. Is it, I mean, first of all, maybe you talked about the way the investments were managed in Serbia. Is that a good example of how the reports to Mr. Rand looked like? This is the kind of communication you have?
No, this is a little bit more lengthy than we normally would do. Quite a bit more. So this would have been drafted by Igor, and then this would have been drafted, my recollection, is kind of our own internal summary. at the time of kind of what some of the outstanding issues were. And then I would have just like pasted it and said, hey, Bill, FYI, but there's no way he would have read all this.
Okay. And I mean, without going too much into the detail here, but I mean, just a reference to illegal buildings shows at that time, someone, you said, was Mr. Markicevic who drafted that, I think, just now, would have familiarized himself with the legal situation in
Well, I think
Serbia and the
he's-
permits and everything.
Yeah, I
right?
mean, it says right in here, it has been a practice for decades to build without a permit. So there are many illegal, so when he's using illegal, he's got it in air quotes. And he's referring to buildings without a permit.
Right, so that, but that was Mr. Markicevic. or
Well,
was-
yeah, I mean, look, he would have sent it to me and maybe I would have marked it up a little bit and, but the information on the ground would have come from Mr. Markicevic.
But at that time, would you yourself have familiarized yourself with the documents? I mean, would it have been translated into English? You would have, and it's 2 years later now, right? I mean, I know you're not in Serbia anymore, but you're still supervising. So would you be into the details? Would you know what's going on with that land and that parcel and everything?
No, that's.
No, you wouldn't.
No, but that's not my job. That's Igor's job. So Igor was on the ground. Igor's obviously a native Serbian speaker. He's financially astute, really smart, and he dealt with all that kind of stuff. And then he would report back to me, and we'd have discussions, regular discussions about this and about, what do we need to do kind of strategy. And then, sometimes I'd call Bill on my own or go see him at his house. His house is only 5 minutes away from mine. And sometimes we'd have a call with Igor. It just kind of depended.
Okay. But at that time, I think you were aware now that the land is owned by the city of Belgrade, as well, either you or Mr. Markicevic summarized in this email.
Well, sure, but the important thing is it's the right to use, right? So what I knew was Obnova owned the buildings and had a right to use the land. That's what it says right there.
Right, but at the time but just to get this straight, I mean, you still hadn't seen any documents at the time, you said?
No,
Because
no,
that was Mr. Markicevic who would look at the documents.
So it was not my practice to review documents that were drafted in Serbian. That was left to Mr. Markicevic, correct?
But he would report to you when there's something relevant, I assume, right?
Yeah, I mean, we talk regularly.
Okay. Let's take a look at some other documents, and please, I mean, as based on what you just said, please feel free just to say if you haven't seen the document before and if you don't know anything about it, that's absolutely fine. We just want to know whether you can help us with some things. So maybe let's start with R26. So that's of course the English translation.
What date is that?
That's 9 February 2012. It's a court decision. Do you know this document? We can show you the
yeah,
Serbian
no,
version, of course. So this
so
is
I think I
after
would
you
have
came there, right? So it's after you arrived in Serbia, is that right? You were there
Yeah, like 20 days.
Yeah.
I think I arrived there on the 2nd, if my
fresh on the
recollection-
ground.
Fresh on the ground with lots of snow actually at that time. I would not, so I knew over time that there was some litigation with Luka. I didn't know the details. Igor dealt with it, but I was aware of the existence, but the details. So this document, I knew there was some documents on the record with respect to this litigation, but I haven't read any of these documents.
Did Mr. Obradovic tell you that there's a litigation going on?
I don't recall whether
You don't
Mr.
recall?
Well, whether Mr. Obradovic told me about the existence of any litigation. I don't recall.
Well, I would find that quite significant, but that's, of course, different styles of management here. So you don't recall whether you told about it, and you haven't seen the document, so that we have that straight for the record.
I was aware over time of the existence of this litigation involving Luka, the specifics of which I did not involve myself.
Okay. Let's take a quick look at page 2 of the PDF, please, if we could go there. And the highlighted part, when you said you don't know the document, but the highlighted parts, and you feel free to read it, please, if you want to read the.
I've never read this document, so
specific
you just want
wording.
me to read it?
I
even
can just
though I've
tell you
never
what it
read
is, and if you want to, you can read the paragraph to make sure that I'm not misrepresenting anything. But it says that the owner of the land is Serbia, and that Obnova was lessee under this contract, the 2006 contract here.
Okay, I mean, I'll take your word on that, but that was my understanding of what I was advised. I was advised that Obnova owned the buildings and had a right to use of the land. And the email that you just showed me, which came from me, reinforces that, because I said we had the right to use the land. So my understanding is consistent with the prior document that you just showed me.
So you don't know anything about this?
No, so this would have been translated only for this arbitration. I mean, it's never translated in English.
Never been translated before for you, any of the court documents or any reports?
Well,
From...
the litigation matters?
Yes.
No.
No. And would you have legal advisors updating you on that? I mean, someone must.
So Igor was, so this is 2012.
This is 12.
So I don't know exactly, like, look, this was when I first got there. Okay. So this took me, a few months really to figure out what was going on. So I would have had no involvement with this whatsoever. What the management of Obnova did at that point, I don't know. I can just say that at that point, the management of Obnova wasn't exactly sophisticated. This was a scrap metal business. So how they dealt with litigation, I have no idea.
Okay. And you had no one looking at the whole set of contracts that Obnova had entered into, no sort of due diligence overview, could be accountants, could be a legal firm, which would have shown you agreements like this one?
I don't think it's a fair question. I mean, you've thrown a lot in there. And so, as I've mentioned to you, when I got there, you have to educate yourself.
Yes.
I did that with PwC, Kranovus Nichols. Then we did this by wanting to bring in other people who were competent, who understood what was going on the ground and could be Mr. Rand's representative in Serbia. We settled upon Mr. Markicevic. Mr. Markicevic has done a very good job. He's not a lawyer, but he's very competent. And so we had done a lot of work to get confidence on the diligence side. And so documents, of course, have been reviewed by lawyers. Documents, of course, have been reviewed by Mr. Markicevic. We brought in, Gordana, I can't remember her last name, even though we've worked with her for years, and she's wonderful. She had assisted us in compiling information, not just with respect to Obnova, but others, with respect to filings, property stuff. So, she had even gone through and reviewed the documents that were at Obnova. So, yeah, did I go there and within 22 days have everything set up so everybody could review? No, of course not. I mean, I was jet lagged for 2 weeks. I had 2 kids there, but over time, of course we did that.
Okay. Well, maybe let's stay on this specific point then. I mean, the court proceedings did continue for some time. There are lots of documents on the record, but if you haven't seen them, I don't want to take you to all of them if you haven't seen them. But they did continue, right? It didn't stop in 12. They continued in 13. There was enforcement proceedings back and forth. Did you receive a briefing on that from Mr. Markicevic, who then at some point took over, right? And managed that?
My understanding is that there were no merits. That's what I understood. So.
But you don't know anything further about the details, just that.
No, Igor dealt with that.
Okay. So was it ever, well, let's take a step back, because when you just gone back to the time when you arrived in Serbia and how you familiarized yourself then. So it was always you reporting to Mr. Rand. It was not Mr. Rand himself speaking to PwC or coming to Belgrade or all of that. It was
no.
You who would collect the information and then brief him essentially.
No. So as I had explained earlier, Mr. Rand gets involved when he needs to. And so, for example, when we were looking to hire at his direction, a central manager, so to speak, for somebody on the ground, that was an important decision. Like, Bill takes his relationships very seriously. And so Bill had flown down to Belgrade, I think it was in July, and was there maybe 5 days, my recollection, 5, 6 days, I don't know. Stayed in a hotel because he's got an apartment and we were in the apartment with the kids. And so not only did we go around, we looked at the properties, we did everything, you know, went out to dinners. We explained to him kind of just the updates. And I said, again, to Bill, we need somebody competent on the ground who we can rely upon, who really can kind of provide us additional comfort on this. Somebody with good business acumen. And you kind of, you know, I'll say speaks our language. I don't mean English, but speaks a business language that we're familiar with. And yeah, I think he made a great decision in Igor. But he made that decision, and he made that decision by interviewing. We interviewed him at Novak Tennis Club, and I think we had 2 more interviews, if my recollection is correct.
But that's I'm sorry, Mr. Broshko, but that's again about hiring Mr. Makicevic. I mean,
No, but you asked if Bill had flown down to make decisions.
So
I
it
gave
was
you one
for
example.
that purpose. Okay.
Uh-huh.
But for the initial briefing in sense of what's the state of Obnova, what kind of rights do they have? And you said, and you looked at that paragraph 15 of your second witness statement, you did go there, you learned that there might be some issues, but it's an incorrect inscription, so everything's fine, right?
And it was
So-
consistent with, you know, again.
So you
Bill-
explained that to Mr. Rand.
What I heard was consistent with what Mr. Rand told me. So
Okay.
it would have been kind of
Let's take it
unusual
step
for
by
me to-
step, Mr. Broshko. So who explained to you how the Serbian real estate ownership system, Serbian real estate law worked?
So the advice that again, not just Obnova, there were 5 companies. The advice that I had gotten, again, as an initial kind of explanation, walking me through things, was PwC and then Kranovic Nikolic. So those were the 2
So
advice.
they explained that to you and you passed this on to Mr. Rand then?
I don't know if I passed on the nuances at that point of, I mean, Bill had said, I own Obnova. We own the buildings. We use the property and I want to develop it. Okay, so what I heard said, okay, well, all that makes sense. This kind of ties in. So whether or not I went back to, usually I would go back to them, like if I saw an issue, for example, you know, we had one company that had far too many employees. I went back to them and said, look, you know, the lawyers are telling me it's a real challenge to downsize in terms of, you know, number of employees. This is what you have to do. You know, these are the problems associated with that. So I would usually go back to them if I saw any issues.
Okay.
I mean, and there were, look, I mean, Obnova was the easy one. I mean, it was pretty straightforward what was told me about, but there was other companies where we had issues we had to deal with.
Okay. Thank you, Mr. Broshko. So the lease agreements, I think you said you've never seen any lease agreements in relation to this, or?
So there's lease agreements where Obnova leases out its land to other parties.
You've seen these?
I don't think I've seen those either, though. I just know they're leasing them. I have no recollection of seeing any lease agreements. I mean, until this, you know, and then there was filings on this, but I didn't see any lease agreements, no. Again, they would have been in Serbia.
But were you aware that there were lease agreements entered into by Obnova and Luka Beograd on the other hand?
Sorry?
Between Obnova and Luka Beograd?
That was not my understanding.
So you were not told that?
I was not told that
These lease
Obnova had-
agreements exist between Obnova and Luka Beograd?
No,
That Obnova
I was never told that.
leasing the
No, I was never
land,
told that.
warehousing space, whatever it is?
No,
Okay.
I was not aware of any of these agreements until this arbitration started. I mean, again, the advice we got was pretty clear. We own the buildings, we use the land. That was,
Okay. But you were aware that Obnova was not registered.
yes, I was.
And I think, I mean, don't recall exact wording, and it doesn't matter, but you mean essentially saying that was something that could be overcome, that issue.
Yeah.
Okay. Maybe let's take a look at, again, at exhibit C337. That's the same email we've already looked at. If we take a look, I mean, a bit of a side issue, but maybe we can take a look at that briefly. So that's a separate section there, not Obnova property registration, but the one that's called Bill's apartment. So I assume that's Mr. Rand's apartment, one of his apartments, I don't know, but it seems to be about an apartment where there's a problem with the registration in the cadastre. And if you take a look at that, I hope you can see that okay on the screen, saying what to do about it. And essentially said that it's the last paragraph there. So the solution suggested was to file a lawsuit and so forth.
Yeah, so this is Gordona that I was telling you before that helped us with
Yes, an
Obnova
advisor.
and with, yeah, she would like help us with kind of the real estate, documents and so forth, yeah. And as far as I know, this has been resolved and it's registered in Bill's name.
Mr.
Just so-
Broshko, please wait for the
Oh,
question.
sorry, I thought you wanted me to
This
comment
is
on
how
this.
it works.
Apologies.
But yeah, no, thanks for confirming what's there. But I mean, it says in the last paragraph, essentially, I mean, there's a suggestion that to resolve whatever the problem was in relation to this apartment with the inscription, that you have to go to court to resolve this. Is that correct?
I can read it. I don't recall exactly how this kind of unfolded. I just know that it was fixed, just as we expected. That's the apartment that we stay at.
Okay, but there was an issue and it required court proceedings to resolve it. That's
I
what it
don't-
implies here.
Yeah, I don't recall if we had, I mean, this says suggested by Gordon. I can't recall if that's what happened. You could ask Igor. I don't know if that's what happened, but this is a perfect example. There was an incorrect registration. This was Bill's apartment and the registration got fixed.
I think it is a good example, but I mean, what I'm struggling with is that I don't see a similar discussion down there around Obnova. So did you consider going to court to actually fix whatever in your view a fixable issue was?
I don't, well, I mean, this had transpired over time. So the question of the incorrect registration was something that was known to me, but what the strategy would be as to how to resolve that, that I would have been advised as opposed to been a direct participant saying this is what we should do, because I'm not an expert in that. So how we fix it, that's up to our advisors. I mean, we've had lawyers in Belgrade for a long time.
So who was advising you on that?
At what time?
Tag 2014, 2013. Who was advising you on this?
2013 would have been, well, it was Kranovich Nikolic, and then Slobodan Doksastich started his own firm and we followed him. So there would have been some advice at that time, but I can't recall. Igor would have a better understanding of that than me.
So, okay, so you assume there was advice. You don't know that there was advice from them on how to approach this issue.
No, so I was advised by, again, both PwC and Kranovich Nikolic when I was there. I was advised very clearly that this was not uncommon. And they kind of joked saying, Erinn, it's not like Canada. We don't have these issues in Canada, and probably the UK. I mean, it's just real estate gets registered, there's no issue. Okay. I'm not sure I've ever heard of an incorrect registration. Perhaps there is in Canada. But in Belgrade, I was told like, it's like all over the place. The cadastre is a mess. And this is not unusual. They were unilaterally registered incorrectly and it'll get fixed. Might take a bit of time, but it'll get fixed. Okay.
Okay, but my question was advice into how to resolve this issue. If it's something to overcome, are you aware?
Yeah,
of
no, I'm
anything?
sure we were. I just can't recall exactly what
Okay.
the nuanced advice was in terms of
That's
what
fine
can
if
we
you
do?
don't
Because I
recall.
know there was some efforts, but again, I can't recall.
Okay, and just, I mean, coming back to something, because I mean, it just keeps popping up in my mind. I mean, if they told you that, and you said you were not aware and you've never been told about the lease agreements, did the lawyers know about the lease agreements?
So when you say lease agreements, what are you referring to?
Still, the same lease agreements between Obnova and Luka Beograd.
So the like these warehousing services agreements, is that what you're referring to?
There's a number of agreements, including for warehousing space. and
Look,
all that.
I'd never seen them.
Okay, but do you know whether the lawyers have seen them?
I don't know whether the lawyers have seen them.
Okay, thank you.
In fact, yeah, I've never seen them.
Just staying on that document on 337. So again, this is September 14, if I'm not mistaken. What you don't see in there is a discussion of the 2013 DRP and the Obnova property registration bid. Did you know about that at the time?
Sorry, what was the date of this again?
Well,
This
let's
email?
move up
Let
so
me
you can
just
see it. It's September 2014.
I mean, the first time I heard of that DRP was when Igor phoned me. And I mean, it was a real surprise. I don't know the exact date. I think it was in 2014 when he called me, so whether it was before or after, I don't know.
So
I
you
mean, I
don't,
recall the phone call, but the exact date.
you
I
don't know when you found out.
Well, the exact date, I don't recall, but I
In
have a
14?
very distinct recollection of the phone call from Igor when he says, I gotta tell you something.
And again, there's no document around that. He didn't send you an email, so this is the DRP, this is what it says. It was just a phone call.
I mean, we talk on the phone 3-4 times a week.
So no document? Just need an answer to the
From
question.
2014, not that I can recall.
Okay. And that was the first time you ever heard about the issue, about the DRP? This
From
phone
Igor,
call? Yeah.
correct.
And you have never heard about it before from anyone else?
Nobody.
Nobody. So you were not aware of the earlier discussion about this in 2008? Mr.
Sorry.
Brandt didn't tell you about this?
Sorry,
There was a discussion in 2008, a letter exchange. I'm sure you've looked at that for purposes of the arbitration.
Yeah, I've heard about that.
So, but
correct.
you were not informed about that?
No, nobody said anything about this.
Okay.
Like nobody Mr. Bradovich didn't, Bill didn't, nobody at Obnova did. You know, we hired Igor. Nobody was aware of this. I mean, we were doing business like, this was kind of like business as usual.
Okay. Then let's move on to something else.
Mr. Keller, may I just ask you, are you going to return to this issue, or perhaps I should put in other words, in other terms? There's a small point of clarification that I would like to ask. I can hold it off until you finished your cross.
I would move on to a new issue now. So why don't you go ahead?
Thank you. Mr. Broshko, it's just a small question following up the questions that Mr. Keller's put to you. I mean, in this document of September 2014, which is 9 months after the DRP, you state in that paragraph on page 3, if it can just be shown to you, please, in the highlighted part under Obnova property registration, you say the land is owned by the city of Belgrade and Obnova has the right to use it. So this is 9 months after the DRP.
Yes.
Now, you've just testified that you don't know at the point at which the DRP was drawn to your attention. And in your first witness statement at paragraphs 34 and 35, although undated, you make the point very affirmatively that the adoption of the 2013 DRP precluded any development of Obnova's premises.
Mhm.
And then in paragraph 35, I was advised that the 2013 DRP made it impossible for Obnova to convert the right of use over the land by the plan into ownership.
Mhm.
Now, it appears that these two paragraphs are inconsistent with the sentence in the September 2014 document where you say Obnova had a right to use. Is there any inconsistency in your understanding?
No, there is none. So when we first heard about the 2013 DRP, it's, you know, again, it was a phone call from Igor. And it's not like at that exact moment in time, we knew and understood what all the consequences were. Certainly for me, because I'm not a Serbian real estate lawyer. And there definitely took some time to digest it, to understand it. And whether or not I found out about the DRP after this email or before, I can't tell you. But at some point, we were advised, like, this is a problem. You can't build anymore. You're not going to get your permits. your development is basically stalled because of this DRP. So exactly when and over evolution of speaking with Gordon, for example, Igor reviewing it, talking to our lawyer. I took a bit of time to understand what the consequences were, but I don't know exactly what that time frame is.
In your earlier testimony, though, you did say that in response to a question that this email was drafted by Mr. Markicevic, and you might have topped and tailed or made a couple of little tweaks to it, but then sent it off in your name. But you've also testified that Mr. Markicevic is not only a native Serbian speaker, but extremely expert. It seems rather odd that 9 months later, in the advice to Mr. Rand, this email is being very affirmative about the right to use, when certainly at some point, because your witness testimony addresses this, at some point you are advised and you understand that there is no right to use, that it's been taken away. So I'm trying to reconcile these questions, and I appreciate the timing issue.
Yeah. I mean, you use the word expert about Igor. Igor is very competent, but Igor is not an expert in Serbian real estate. And Igor would have been able to read and explain what he's read. And he says, look, they put a bus loop right on Obnova, which, was like, what? He would have sought, this is my recommendation, would have sought advice with respect to what does it mean? What can we do? How does this impact our ownership of the building, et cetera, et cetera. But I'd have to have a better sense of the timing to try to, interpret this email. But with the benefit of time and understanding this DRP, then the consequences were known to me. And whether or not we found out a month after this or a month before, and Igor didn't quite understand the consequences of what all this means from a legal perspective, I don't know.
Thank you very much.
Thank you, Mr. President. So, as I said, let's move on to another topic, but we'll stay on the early days. That's the restructuring in 2012 that's covered in the first witness statement, I think, primarily. And you state there, and I think it's paragraph 12, that Mr. Rand decided to change the ownership structure of his Serbian companies. It was he that explained to you in 2012 that he wanted to do that for tax reasons. So that's correct.
Correct.
But have you seen any memoranda or legal analysis setting out these tax reasons for the 2012 restructuring? Or you were just told to implement that?
So in 2012, I was just instructed by Mr. Rand. He said it was for tax reasons. I can't remember at that exact moment whether he told me it was through Thorstenson's. I know lawyers at Thorstenson's, a big tax law firm. But I came to know that's where the source of the advice came from. And I know with respect to another of his companies that he had gotten a memo previously. And again, when I exactly saw that memo, I don't know, but he had gotten advice to this effect, a number of years before that with one of his other Serbian companies. So it was then held through Cyprus. And now that I was there and I was a corporate transaction lawyer, he says, let's do it. We couldn't do it until there was a pledge on the Obnova shares, and that was released, I think, in March of 2012. And he said, I'll leave it to you to take care of the restructuring, transfer it to Cyprus. I said, okay.
Okay. So, but you haven't seen, if there's a Torsteinson's memorandum from 2012 for Obnova, is that correct?
That's correct. My understanding is the advice that he had gotten in 2012 was just consistent with the advice that he had gotten years before about another of his Cypriot companies. So, there wouldn't have needed to be a memo saying, do this all over again. I think he said he found them, and that's how this got done. Does this make sense? Yes. Okay, thanks. Okay. And again, it came down to capital gains treatment and so forth, which of course is very preferential in Cyprus.
So then the idea of the restructuring was that there would be a holding company in Cyprus, essentially between Mr. Rand and Obnova. and other Serbian companies. Is that correct?
It would be a holding company in Cyprus holding the shares of the remaining 5 Serbian companies.
And that company was then Kalemegdan, and that was established in, I think, March 2012, right?
That is correct.
And then and I think you also addressed that in your witness statement in paragraph 17. Mr. Rand then instructed Mr. Obradovic, who was still there at the time, to contribute all of his shares in a number of companies, but including Obnova, importantly, to Kalemegdan. That's how it worked, right?
That's correct.
So then Kalemegdan afterwards became and now is the owner of Obnova. Is that correct?
That's correct.
And at the time, Mr. Obradovic was also the owner of Kalemegdan. Is that correct?
Mr. Obradovic was the nominal holder of the Kalemegdan shares.
And there was no purchase price payment as part of that transaction. Is that correct?
Well, there was consideration, if that's
The
what
question
you're.
was purchase price, yes or no?
No, there was no need to.
So what happened, and I think that's what you wanted to go to right now, the consideration that there were shares in Kalemegdan which were then issued to Mr. Obradovic. Is that correct?
Correct.
Do you remember the value of that shares as per the corporate documents?
My recollection is that, I can't remember which document it would have, but we did list, and I think it could have been I think it's the acquisition value, like the original acquisition value. We had to put something in there. And so we included it was lawyers, but that's my understanding is that it was the acquisition value that was listed, not like a proper valuation needed, where you bring an evaluator and we advise you don't have to do that. It's just acquisition value.
Would 17,000 euros sound about right?
I thought it was like, you mean for Kalemegdan for the total
For Obnova,
value of all the shares?
or for the Obnova shares? We're only interested in Obnova.
Yeah, I think it was 20-something thousand, and I think it was an exchange rate issue. I can't remember what was pegged where, but I think the original, my recollection of the original purchase price was like 20-some thousand. So, with exchange rate and from 2005, yeah, that could be right.
Okay. And I think you also wanted to go there already. I mean, there's also Coropi, of course.
Yeah, of course.
You say in your witness statement that Coropi is the beneficial owner of Kalemegdan's shares since incorporation. Is that correct?
That is correct.
So what's the basis of Coropi's beneficial ownership, to the extent that you know?
So there's a couple aspects of this beneficial ownership. So Mr. Rand and Mr. Obradovic had been working together since 2002. I mean, I could get that wrong, but it's
For a long time.
while ago, for some time. And their relationship had always been one where Mr. Obradovic would, if they decided on it, acquire the shares, hold in his name, hold it nominally. He'd be the one that would go to the shareholders meetings. If there was any need for meetings with the privatization agency, he could go. So there's a bunch of stuff that he would do. And Bill would be the beneficial owner. So upon and in advance, but upon the incorporation of Kalemegdan, Bill at that time had decided that, well, rather than me being the direct owner, I'd like to involve my kids. It's a nice legacy investment. And so the idea was that from the beginning, Coropi, because it was at Bill's direction, Coropi would be the beneficial owner. I mean, it's Coropi, and then it's the shares are owned by the trust, and the trust are for the kids. So that was the idea, that Coropi would be the beneficial owner of the Kalemegdan shares, and that Mr. Obradovic would hold those shares for the benefit of Coropi. That was the idea.
That's all very interesting, but I'm not sure that has answered the question. So what's the basis of the beneficial ownership? Like legally,
Sorry, it's hard.
Legally, what's the basis for the beneficial ownership here?
Well, I mean, we got advice from counsel in Cyprus. I'm not a Cypriot
But
lawyer.
if you don't know, please just say you don't
Well, no,
know.
but
and we
I
will-
mean, well, I'm not a Cypriot lawyer, but when we structured this, we did get thorough advice from Cyprus and from Serbia. And those counsel worked together as well as with me. But I mean, I would suggest that basis you can put to the Cypriot experts. They're in a better position to know.
So you don't know.
I'm not a Cypriot lawyer, so I wouldn't pretend to understand Cypriot law.
Okay.
But
then-
again, and
I'm not asking you about Cypriot law. I'm asking whether you know what the document was, what you did do to establish beneficial ownership. If you're not involved in that, then please just say so. But I'm
No,
not
no,
asking
but-
you about the legal side of things.
But
just
I mean, you asked me what the
happened.
legal basis was, and what I'm saying is I'm not a Cypriot lawyer. But what I do know is that the intention and the expectation is because there was a relationship between Mr. Obradović and Mr. N over years. And that relationship and understanding was one where Mr. Obradović would always hold these assets for the benefit of Mr. N. That continued. And so we had that underlying arrangement with respect to the incorporation of Kalemegdan, except Mr. N wanted to have the kids benefit. And so Coropi was involved. And then it's kind of like belts and suspenders. We were advised that we should draft also those trust agreements. And I said, okay, that makes sense. I mean, I had just started working with Bill and I wanted to do a good, thorough job. And so, I was not going to take any shortcuts. I thought the advice made sense. So I think my understanding at the time was the legal basis was twofold. It was the arrangement already between Mr. Obradović and Bill. And then as belts and suspenders, the trust deeds, which were drafted up.
Okay. Well, then let's take these in turn. So the existing arrangement, how were you informed about that? It's just something that Mr. Van told you, but do you have seen any documents about that arrangement?
Sorry, what existing?
The
relation?
Obradović arrangement, let's call it that.
Yeah, I mean, I don't, there's no documents here, but, number one, I was informed about this relationship before I went in 2012. The relationship between Mr. and Mr. Obradović were well known. Everybody knew Bill was the owner. I recall, for example, with BD Agro, there was documentation, establishing this type of relationship.
But
There's documents.
have you seen any documents in relation to Obnova for the arrangement
Well,
between Mr.
I've-
Obradović and Mr.
Yeah,
Rand?
I mean, I've seen documents. I mean, I'd have to go back, but
That's fine if you don't know or
no,
don't
but
recall.
I'm trying to answer your question thoroughly.
Please.
I would have seen communication. I would have been party to communication with respect to Mr. Rand and Mr. Obradović, where all of this was acknowledged. And when I say all of this, everything that they acquired in Serbia was with Mr. Rand's investments. And Mr. Obradović was simply acting as his guy on the ground. So I don't recall anything in this arbitration of, big discussion points on this. But for me, I mean, this was just obvious. Everybody knew it.
Okay, but you haven't seen any documents establishing the arrangement or something like that? We've seen
I
communication.
have seen some documents, but again, with respect to Obnova specifically
Obnova,
saying,
yeah, always
oh,
Obnova.
George is holding this for the benefit of Bill specifically on Obnova, I don't recall, but
Okay.
we didn't need that.
Then you also mentioned the trust deeds, which are on the record, so that's C66, so just so that we have that straight.
So is there something you want me to look at? A seat, what was it?
We can pull it up if you want to look at it, but I just want to ask you a question
Oh,
about
yeah,
it, and you
okay.
let me know if you want to see anything
No,
else,
that's
of
fine,
course.
that's fine.
So it's one of them, one of the trust deeds, and it says the grantor for consideration given is beneficially interested in title. And then there's been some discussion about this in this arbitration, I'm sure. So then you don't mention that in your first witness statement, that you go to that in your second witness statement then. Is, I think it's paragraph 20. And you said that you did pay actually an amount in dinar, about €10 approximately, under each trustee, and they did do so on behalf of Coropi. Did you contain any legal advice or suggestion that you need to do that?
They, when I say they thought it was a bit bizarre, actually. This concept, I didn't know that the concept of consideration for agreements was more of a common law thing, and apparently is not really a thing in Serbia. As I mentioned to you, working with Bill was kind of it was a really good thing for me. I wanted to make sure that he was impressed with everything I've done. I was very thorough in making sure that we had everything taken care of in this restructuring. And the one thing about agreements where, let's say, unlike an agreement where, okay, I'm buying, this bottle of water from you for $10 and we're gonna have an agreement. Okay, I'm giving you $10, you give me water. It's an immediate, recognizable, tangible consideration. Okay, this was a bit different in the sense that, so first off, these trustees were drafted by council in Cyprus, and of course I reviewed them. And I knew that there was this pre-existing relationship, which, in my mind established this trust relationship, and the practice had shown it unequivocally. But because it was a trust agreement where there was no exchange of a tangible item, I thought, it's important to at least have an exchange of some nominal monetary amount.
That was the
usually
advice that you received. Just to
This
be
was
precise.
my advice, because, so for example, the customary language.
So it was your own determination that you should do
Yes.
that. Yes.
And,
Okay. Good. Well, that's all.
and-
That's all.
Well, no,
Really.
but
I'm
just
good.
to give you a thorough answer, normally on that kind of agreement, again, I didn't draft it. You'd say, for $10 now received by party X and for other good and valuable consideration, the sufficiency is accepted. They didn't have that language in there, and I thought, we should probably get a payment on here just so that we have, a tangible consideration element.
So
of
your
this.
idea.
So this was me, and so when I gave it to George, and he was he thought it was weird. And then when I gave it to Igor after, he thought it was equally strange, and I said, maybe it's just a Canadian thing, but just take care of it. I want to make sure George receives.
Okay.
a
How did
tangible
you
piece
come
of
up with the
consideration.
amount?
Pardon me?
How did you come up with the amount?
I just thought €10. A lot of times we have $10. I thought €10, and I did a conversion.
And that was a cash payment. You actually did give that to Mr.
Yeah.
Obradovic.
Absolutely.
Did he give you a receipt? Well, you wanted to do everything properly here?
No, it's €10.
So no receipts. So it
No.
must be really odd when you go to him, so, well, here's €10.
Well, he did find it a bit unusual because I guess they don't do that in Serbia normally.
Did you expense it?
Did
Well,
I
you-
expense €10?
You were a consultant working for Mr. Rand, right?
No, I didn't expense €10.
So when did that happen?
I would have paid the first price at the signing of the first trust deed. And then if the second one was not, I left. Hold on, let me think about this. I left I left before the second trust deed was signed, so I gave it to Igor. Told him to make sure to give it to George.
And you said you were doing that on behalf of Coropi, that's right?
Yeah, look, it was my funds. It was on behalf of Coropi. It was my ability to contribute on behalf of the company.
And you said you looked at the trust deeds, and you also said, there was already an arrangement in place.
Sorry, it's
So you looked at the trust deeds drafted by Cypriot Council.
Yeah.
But your understanding is there was already an arrangement in place
correct.
between Mr. Obradovic and
Correct.
Mr. Rand.
And this was like
in some
in
form.
furtherance of that.
And was that looked at by someone?
Was what looked at?
Well, you established new trust deeds.
Yeah.
But there seems to be something, let's call it a contract of some sort, between
Yeah,
Mr.
sorry,
Obradovic
Can you
before.
move that, or no, that's not on.
Sure.
Is that-
So I said there was an arrangement before. That arrangement I said, let's call it a contract of some sorts, but there was some arrangement
Yeah.
between Mr. Obradovic, Mr. Rand before. Did someone look at how that need to be changed, implemented, amended? If you put in new trustees?
How their arrangement or the
Yeah,
relationship needed to be.
because Coropi was
No.
moving in, essentially. I think that's what you're saying.
No, I mean, I had explained this to Cypriot Council, what the arrangement was. They thought the trustees were a good idea. Again, kind of belt and suspenders.
Okay.
So
All right, let's move on in the interest of time. You were never a board member of Coropi or Kalemegdan, is that
No.
correct? Do you remember the name of the company that helped you setting up and managing? Still probably the
it's like
companies?
HLB.
HLB.
I mean, they had different departments. One was legal and then accounting and so forth, but yeah, HLB.
And have you ever been to Coropi's or Kalemegdan offices?
Yes.
How can we imagine that? I mean, do they have rooms there dedicated for them, or is it just rented on a per hour basis if you want to go there?
We have a lease agreement, I believe, for, kind of like office space if we need it. We are able to use their offices. Yeah.
So whenever you need it, essentially, you can go to HLB
Yeah.
and then have,
Yeah, I mean,
have an
they've
office.
got
for Coropi.
offices, they've got, and they've got, I mean, the directors are also there as well. And so, yeah, I've been there. It's a nice new office tower.
And if someone wanted to find you, I mean, there's a plate outside saying this is Coropi,
You've got our name on there.
Kalemegdan, and all
Our
of
name's
that,
on there, for sure.
and there would be someone answering the phone,
Yeah.
and all of that. Okay.
Yeah, absolutely.
And how did that actually work in practice? I mean, you said in paragraph 18 of your first witness statement, so what you call Mr. Obradovic became a nominal shareholder, but he would always follow Mr. Rand's instructions. Is that correct?
Correct.
So it was actually at all times controlled by Mr. Rand. That's
When you say it,
Kalemegdan, to be very
Correct.
precise, yeah. And then paragraph 20, you also say Mr. Rand was a director of Coropi and controls the company. So
Correct.
Coropi was also at all times really controlled by Mr. Rand.
correct.
And 21 of your first witness statement, that's again about Coropi, said that there would be always a need to obtain obstructions, directions, written consent from Coropi, but that would come essentially also from Mr. Rand. Is that correct?
Well, they would come from Coropi, but Mr. Rand controlled Coropi.
Controlled Coropi, correct. And they said there would be no decision really taken at Kalemegdan level then without Coropi being involved. And permission given from Coropi, essentially.
Yeah, I mean, they would need to ensure that Coropi was on board with actions that were taken. But certainly Coropi, would not have been able to necessarily compel Kalemegdan through the directors to do what they didn't want to do. So, they had to be comfortable with what was going on. It's a common law jurisdiction. They take their fiduciary obligations very seriously.
Okay. Thank you, Mr. Broshko. Let's move on to another topic again, just in the interest of time.
Mr. Keller, just a question to you, and of course your time is your own. I just want to make sure that we take a break for everyone's comfort at an appropriate time. So you tell me when it would be convenient to do so. I appreciate that on the timetable we had considered 11:20, but that was after redirect and tribunal's questions. So you tell me, I don't ask you to tell me how long you're going to go on, but you tell me when will be a good time to take the break.
Thank you, Mr. President. I think we'll need another 15 to 20, I would say, perhaps, roughly. And then there's redirect, of course. I would say we can do that in one go, but.
Well, 15 to 20 plus redirect plus tribunal's questions. We're not going to do that in one go because then we'll be sitting here for 2.5 hours. And I think that it would be appropriate also for the court reporter then to take a break. Would it be appropriate to take a break at this stage, or is there a line of questions that you want to get through before we take a break?
I'm moving on to another topic, I think. I'm very happy to break now, if that's convenient.
Let me just confer with my colleagues. I think let's take that break now. We will reconvene. We've got a break for 30 minutes. I suggest that we be a little bit more disciplined than that, as we're in the middle of witness testimony. Can we say 20 minutes? Is that convenient? So we'll reconvene at 25 minutes past the hour. Mr. Broshko, let me.
I was going to ask you, what
You can't talk to
other
anyone.
than the washroom?
You can't talk to anyone.
Okay, I won't talk to anybody. Can I do? Am I able to go over there, or
You can
just say
you
nothing?
can you can run around the yard. You can do whatever you
Okay,
want.
just don't talk to anybody.
Don't talk to anyone.
Okay,
Yeah, you're sequestered for the moment.
yeah,
On your
but I
own-
can go get a coffee and then go into there and just say nothing.
Yes, on your
Deal.
own recognizance. Yes, you can. You can't talk to yourself either in case someone else overhears.
Okay,
Thank
fair
you.
enough.
Okay. Just hang on for the tribunal secretary. I think he went searching for you, Mr. Broshko. Okay, let's go back on the record. Mr. Keller, back to you.
Many thanks, Mr. President. Welcome back, Mr. Broshko.
Thank you.
Yes, as I said, we wanted to move on to another topic. I mean, interestingly, this is an arbitration where you're not only one of the witnesses and involved in the investment for a long time, but you also at some point decided to invest yourself. And I think you already covered that in your first witness statement when you said it was an interesting investment opportunity. And
Can you bring this forward more closely? Sure. I just want to make sure I can hear everything.
Absolutely.
Thank you.
So your first witness statement, paras 39 and 40, you cover your investment in Obnova in 2017. You say it was an interesting investment opportunity. So that's correct, right? So that's your assessment as of 2017 then?
As of 2017, correct?
And you said that you believe there was significant value in Obnova. And the reason is essentially that there was compensation, which you say in your witness statement you would expect to be due based on the value of the premises before the 2013 DRP. That's correct?
I mean, I think it's partially correct. So, I mean, I think it was when I acquired the 10% interest on the market, 2017, we were still hopeful that because we thought and were advised that Obnova's ownership rights were very clear, that there would be perhaps an opportunity for the city to, I don't know, come to its senses and allow Obnova to remain on its location and develop its property. But, you know, to the extent that that didn't happen, then I was advised by our legal counsel that this would be considered an expropriation because of this regulatory change, and that there was an obligation under Serbian law to compensate Obnova for the fair value. And so if you leave the 2013 DRP, but pretend that never happened, yeah, I thought there was significant value in Obnova's premises. And so I just expected that that one way or the other it was going to be resolved. Either they'd move it to a different location or Obnova would be paid out fair market value.
And you said now again, and you did that a couple of times today, and also you said you were advised.
Mm-hmm.
So was there new advice for that purpose? Was there a new due diligence? Was there new, what happened there in 2017? I mean, what was the trigger? Did you get this?
The trigger is somebody, I got a call, or not me, but I think it might've been Igor, I got a call from the broker I was using, said, you know, there's some sell orders on the market for Obnova. And, you know, as you can appreciate, it may not be the most illiquid market in the world, but it's very illiquid. And so there's not much trading whatsoever. So when something pops up in the market and I thought, okay, well, this might be a good opportunity. That's what spurred the thought in this. And so I had spoken with our legal counsel saying like what happens here if we can't find a solution with the city? And we were all still hoping. Bill was still hoping. That's still our preference to this day. We've been there a long time. We'd love to see a development there. It'd be very personally satisfying. But he says, look, if you can't, then this is the Serbian law, and this is what your expectation should be. And I expected Serbia to follow its own laws.
Okay, and just because you said I was advised, I mean, was there any new legal advice or due diligence report or anything at the time in
No,
2017?
I mean, we talk to our lawyers in Serbia all the time, so I asked them.
Okay, so there's no new written document report. It was just your understanding from
Well, it wasn't
managing the company
no,
anyway.
It was my understanding because that's what they advised me.
Okay, but there is no legal opinion or something at that point that
I
this
would
was the
not have
case.
needed a legal opinion for them to tell me that change in regulation, which evaporated our rights to development of the land, was some form of expropriation or indirect expropriation. And the important thing is, what is the obligation then of the government under such circumstances? And they said it was to pay fair market value. And so I said, okay.
Right, but to be expropriated, you need to have a right, right? And did you get any additional advice on that, or the right to be expropriated here?
Well, I think as we had gone through previously with a number of questions from you and my answers, we believed that our rights were solid, that Obnova owned the buildings,
That's
that Obnova had a right.
all fair
use
enough.
of the
I'm just
land.
asking whether there was new advice or new information at the time, because you said I was advised.
But that was continuing, that was the continuing conclusion of now 3 law firms. So PwC, okay, then it was Kranovis Nicholas, and then it was Stankovic and Partners. So we now had the same conclusion from 3 different law firms. And, that gives one a significant level of comfort that that is in fact the law.
You say in your witness statement, I think that's paragraph 43, that he did not conduct any due diligence because you've been involved in the investment for such a long time already. Is that correct?
Well, yeah. So when I say due diligence, I'm talking like business due diligence. I knew what the value of the land was, or had a pretty good sense, which would be like assuming that this change in regulation never happened, because I'd now been there, I guess 5 years, 5 years. I'd been there like often. I knew that Belgrade, you could see the changes day in, day out. It was slow. Now it's become quite rapid, but you saw the positive developments. It was very encouraging. From a business perspective, it was pretty clear. This was in the city center, right by the river. There was tremendous potential. So on the due diligence side of business due diligence, that's what I meant there. I had been, part and parcel of overseeing this now for 5 years. But of course, I asked our lawyers a question because I wanted to know the answer. What happens if we don't come to a solution?
Right. And it's a different time now, right? We discussed 12 and 14, and now we're at 17.
Yeah.
So maybe let's just take this into account. You were aware that there is no inscription of Obnova. Anyway, the rights were not registered at the time. You were aware of that.
Yeah, of course. I was advised that at some time in 2012.
You were also aware that there were some issues with the legalization requests back and forth. There were proceedings ongoing in court.
Yeah, I don't know how much I got in the weed on legalization requests. I know there was some discussions, but it's, pretty nuanced. My understanding is that after the change in regulation, that because of the 2013 one, that this kind of like stopped everything dead, which is why my hope was that we could just resolve this with the city. Nobody wanted to argue, but anyways, it didn't happen.
But you were not aware of the details of the legalization requests? There were quite a few.
I was aware that there were ongoing requests. I understood that there was a request kind of before my time, but I don't recall whether there was a response. I just don't have that recollection right now.
And that would be, going back a bit to what we discussed earlier, but you wouldn't have received translations of all the correspondence and documents from Mr. Markicevic on this?
No, of course not. No.
Other kind of reports from Mr. Markicevic on legalization requests, court proceedings, any updates?
3 times a week, 4 times a week. Sometimes it's a quick call. How's it going? Good. Anything new? Nope. Okay. Sometimes it's a few hours. And like I say, I go down there regularly, but the Serbian system is it's unique. It's different than what I'm used to. And so we have to bring in good advisors and we have to rely on the advice of our competent, the people that we hire.
Okay. And I think you acquired 10% of the shares through, I think it's your company, MLI, right?
Correct.
And you paid 200,000 dinars, is that correct? Roughly.
Is that what I got? That sounds about right.
I think it's also somewhere in your statement, which is.
Yeah, I mean, if whatever I say in there, that's
In Exhibit C003.
Yes. You want to look at it? Shall we put it up?
no,
Well,
that's
it's just about
I mean,
the
that's
rough
that
number.
sounds. I mean, I know it's but it sounds.
It's not about the exact number.
Dinars are
right?
always tough to.
So
convert
that's
for me.
200,000 dinars. I mean, on my calculation, I'm a lawyer. I'm bad with math, but I think it's roughly 2,000 euros,
Yeah, that sounds right.
give or take, right? Okay. And then there was also a loan that you purchased on the market as well for some 10, 15, 20,000 euros as well.
Yeah,
Is that
so I think the purchase of the shares were in November. And then if my recollection is correct, so that was November 2017. And then I think in February of 2018, there was some correspondence that we had received from the city, and I was advised that they had raised the issue of compensation. So I thought that was very promising. And then in March, so a month later or so, I had acquired the certain receivables that Obnova was required to pay to certain creditors. And so Mr. Markicevic assisted me because I can't speak to them because I don't speak Serbian. But I got them at a good face value. I think it was like a 70% face value. So it was like 20,000 euros, I believe I paid, and it was, 70 some thousand face value. I would have actually acquired more at that point, but the other creditors didn't want to sell that we approached. But the reason was because if we could find a solution with the city to develop it, then ultimately you do your development, it starts throwing off cash, and I get my receivables paid off, and that's a good return. And then I've got a 10% equity interest in the company going forward. So that's a good outcome. And if it doesn't happen, and under Serbian law, they pay fair market value. So then the company goes with the cash. The first people are paid are the creditors. So that means that money comes back to me at face value. And then I would have anticipated a distribution of cash in Obnova to the shareholders. And I'd secured a 10% interest in Obnova. So I thought it was a pretty good deal.
Yeah. So I think, assuming you and Mr. Rand were successful in this arbitration, and you'll receive an award of, I think, say 40 million. If you have a 10% share, you'd cash out roughly 4 million on the basis of that investment. Is that correct? Ballpark.
Well, it doesn't. No, because the money goes to the claim. Well, no, it depends if there's even an award to me. Otherwise, it goes to Coropi.
Yeah.
Right. So the Obnova doesn't get the money.
So you wouldn't get any money?
Well, if my award failed, or like if my claim failed, so I wouldn't get anything under that. If I did, then it would be up to the members of the tribunal. And if Coropi was successful, then I would hope that I'd get some kind of bonus. I mean, Bill and I would have to talk about it. I mean, I've worked on this for quite some time, but Obnova doesn't get the money, right? Okay. So it's not like that. It's not a direct.
That's true. I mean, there's a legal setup around this, but I mean, assuming you would get like a 10% share based on your Obnova investment, then it would be like 4 million. I'm just testing the investment opportunity here, right? So when you're investing 2,000 euros, and then
so just dealing with Coropi's claims, I would be very pleased with 10%, but I very much doubt that would be in the cards.
Okay, but it sounds like, I mean, the way, again, assuming that the assessment of your lawyers is correct and your expectation is correct, it would sound like an amazing return for a 2,000 euro investment.
I got to tell you, this was not something we wanted to do. And I know this was raised the other day, But even when we started this, we thought that this was like a last ditch effort. The settlement offer that we had sent through was actually, it was initially at my suggestion, and I talked to Bill, and Bill says, I agree. And even though, because I did the calculation, that time it was almost €1 million in legal fees. And we were prepared to leave that because we just wanted to develop this. So I don't look at this in terms of, what is a quote unquote return on an award in this arbitration. We always wanted to develop this. And even as a year ago, we were, imploring legal counsel to please, and the government to just give back to Obnova what they took. And we can all call this today. We weren't even asking for payment of legal fees. We just wanted to develop the property. So unfortunately, we're here because of what Serbia has done. This is, we didn't have any other choice.
I understand that that's your position in these proceedings, but I just wanted to know whether you think it's a good investment opportunity there that you took up, and I think that's what you're saying, right? It's a good investment opportunity in either way.
So, well, in 2017, I gave you and remember, this is an interest in Obnova, so this is separate and aside from what happens in this arbitration, because Obnova is not a claimant. In 2017, at the time, I felt that this was a good investment opportunity because of what I told you.
Thanks. That was the only question, really.
No, but this is, I think this is important because it's completely separate from the arbitration.
Yeah, no, that's
Right?
fine. I wasn't going there. It's fine.
Okay, and so, yeah, obviously I thought
Mr.
it was a
Broshko,
good
please,
investment.
let's move on.
Okay.
And I think you were still under the consultancy agreement with Mr. Rand here, right? And I think you still are probably as of today.
Yeah, I still am.
So under the consultancy agreement, you're actually obliged to raise investment opportunities for him and to him. Is that correct?
You'd have to show me the language.
Sure. I think it's C692. Let's pull it up. I think it's in clause 2, actually. And if you go to paragraph 2, consultant shall promptly disclose to the company, so that's Rand Investments, each corporate opportunity that arises for providing the services which properly belongs to the company, which the company might reasonably consider.
Okay.
Would you think that applies in this?
Applies to what?
To your investment in Obnova, given that you have managed Obnova or were involved in the management of Obnova on behalf of Rand Investment and Mr. Rand?
Well, I don't know if that applies, but I did tell Bill my intention to pick up the stock. If he wanted it, he could have had it. He just didn't care. He's like, okay.
Okay, thank you very much.
I just say, like, Bill has a ton of stuff going on. It's not just he's got, a few things in Serbia. He's got stuff going on all the time. He's busy. And, at 83, it's a very taxing thing, which is why he has people like us. I mean, I told him, this is what we heard. It's on the market. I'm going to buy it. You cool with that? And he's like, yeah, don't care. That was it.
Oh, that's fair enough, Mr. Broshko.
Yeah.
Many thanks.
I'm sorry, just to be clear, you told him this before you acquired the stock?
Yeah. I told him I was intending to buy it, and he's like, okay.
Thank you.
I have nothing further. Thank you.
Thank you. Redirect.
Thank you, Mr. Chairman. I would first have actually a question to my colleagues to avoid a potential objection. Would you object if we showed the witness our privilege log? I am cognizant of the fact that the privilege log is not included in the hearing bundle, but obviously we have it available electronically.
I think it's quite an abstract question. I think, it's as long as we don't hear anything further, but I think we would object, actually.
I think the question for Claimants Council is whether the privilege log goes to a point that has raised and is, if you like, a rebuttal point, or is a clarification point on an issue.
Yes, indeed. I apologize. I should have started by that. So at the beginning of the cross-examination, there were questions about legal advice that Mr. Broshko sought and obtained with respect to the status of Obnova and its rights to the real estate. There were questions whether he received any documents, any advice in writing, several repeated questions. And we thought that we might refresh Mr. Broshko's memory by showing him the privilege log produced in this arbitration.
I think as the document is not in the record, even though it is responsive to a question that's been raised, I think you can raise the questions that you wish to raise, and you can apply to admit it, and then deal with it in argument in due course.
Okay, thank you. So, Mr. Broshko, do you recall whether in this arbitration Serbia asked specifically for documents relating to legal advice that the Cypriot claimants sought with respect to the status of Obnova's rights to real estate?
Yes.
Mr. Broshko, do you recall whether the Cypriot claimants claimed privilege with respect to such documents?
Yes.
Do you recall whether there were some documents responsive to that document request which were put on the privilege log produced in this arbitration?
I am, but the specifics, I need to see them specifically, but I do have a recollection, of course.
So therefore, can you confirm that there were written documents, privileged documents, responsive to a request for production of documents recording advice obtained with respect to the status of Obnova's rights?
Yes, I can confirm that.
Thank you. My second line of questions relates to...
Sorry, perhaps I should just note so that it's clear on the record that, of course, in referencing the privilege log and what it addresses, the witness was informed of the content of the privilege log. He's now affirmed that he recalls that we would expect to see these issues addressed in due course, and if not, the tribunal will ask about this.
Indeed, we will later in today make a formal application for the privilege log to be admitted into the record, and then we will address it in our submissions on Friday. It was around 10:48 a.m. this morning. You were asked a series of questions about the in-kind contribution of the Obnova shares into the capital of Kalemegdan. Do you recall that?
I do.
You were not shown, you were referring to a document, but you were not shown any. I just thought I would give you an opportunity to tell us whether a document I will show you is the one you had in mind and perhaps comment on it. Do we have access to the screen?
Probably easiest if you just ask them to call up
okay,
the
well,
document.
thank you then. No. So then I would kindly ask Respondents' Council to pull up document C-342, agreement on capital increase between Kalemegdan and Mr. Obradovic. 342. And if you could just scroll down slowly through the document for the witness to be able to see it.
I recall
Yes,
this document.
thank you very much. So, Mr. Broshko, can you confirm this is the document you had in mind?
That is correct.
Do you wish to make any comments on the document?
Yeah, I think the question was about the in-kind contribution for Obnova. I think it's above. Maybe you can just scroll up. Up, hold on. Yeah, there it is, 1.14. Currently held by Mr. Bradovich, which are valued at euro 17,000. Yeah, my distinct recollection is the acquisition price was 20-some thousand. I think it's a exchange rate issue, but I mean, this was, again, these numbers were put in place with the, between kind of the Cypriot advisors and Kranovic Nikolic, and the idea was to do a transfer where there was no tax triggered on the exchange, and so I think they went with the acquisition price. That was my recollection.
Is the acquisition, or was the acquisition price used also with respect to the other companies whose shares were contributed to Kalemegdan at the same time?
Yeah, I believe so, yes.
Thank you. That concludes my redirect.
Thank you. I think the tribunal has a number of questions. I will start us off. And in doing so, let me make it clear, as you will well appreciate, that you shouldn't read anything into my questions. I'm just trying to, and the tribunal is trying to understand issues that it needs to come to grips with. And I'm not going to sort of pursue the questions in any systematic way. First point is, could you tell us, Mr. Broshko, whether anyone else briefed Mr. Rand directly?
About
the issues that we are here concerned with? Did Mr. Markievicz or did Mr. Obradovich, did either of them brief Mr. Rand directly, or were you the conduit to briefing Mr. Rand?
Well, obviously I was there only from 2012 forward. So I was the primary conduit. There has been some occasions where, you know, Igor and Bill would have a conversation, but it usually involves me. So I'm again, yes, I would be the primary one. Prior to 2005, you know, Bill had conversations with George, but I mean, that's before my time. Our lawyers, they would not have communicated directly with Bill. I know, for example, with the restructuring, we had to get some stuff notarized. And so I think Bill went to the courthouse with Slobod and Doktastit to get that done. But, you know, Bill was not involved in drafting any of it. That was 100% me. I mean, Bill's been involved in this arbitration with our counsel, but that's kind of separate. So I would say that there has been some times, but I'm principally the guy that oversees this for Bill.
And presumably, while there might have been the odd occasion in which, for example, Mr. Markievicz briefed Mr. Rand directly, it's likely that you would have been present, as you were.
Yeah, most likely, yeah.
And just to be clear, and I think that this is on the record, but just to be clear, you don't speak Serbian.
I do not speak Serbian.
So any a briefing of Mr. Rand that you would have undertaken would have been on the basis of briefings to you, either by Mr. Markievicz or Mr. Obradovich before December 2023, or your lawyers or your other advisors.
So the brief, so if it was a more comprehensive briefing, yeah, I'm not going to do that because I don't want to get anything wrong. And so usually the way we do this is I would have calls with Igor, and then we would have calls, or like, you know, was Zoom, now Teams, with our legal counsel, and we, you know, whatever the issue was. And then we would have a call with Bill. And if it was like a kind of a more detailed thing that we're talking about, Igor would be there. Sometimes we've had calls with our legal counsel and Bill. It's not that regular because there's just no need. But yeah, I mean, sometimes I'll call them and say, hey, we're working on a few things and that's it. Sometimes I brief them a little bit more, but if it comes down to it and we want to give them a more thorough briefing, then, I would make sure Igor was there at a minimum.
Thank you. I'm simply trying to understand, and perhaps the council would call up the first witness statement and paragraph 48 of that first witness statement, just as a matter of clarification. And there are a number of examples of this. If you have a look at the last sentence of that, you say, finally, I understand that Obnova's estimated the losses it suffered at 45 million euro.
Yeah.
And I think there are a number of instances in which you use this language, I understand, or I was advised, but it's seldom that you actually tie that understanding or the advice to anyone specific. So I'm just trying to be clear whether this understanding or advice would have come from Mr. Markicevic or Mr. Obradovich or one of your...
Mr. Bradovich had, so for example, let's just to deal with that you've highlighted there, the request for compensation. So that was, I mean, we were advised that we should put in this request for compensation. My recollection is I talked to Bill and he's like, okay, make it happen. It was drafted by the lawyers. Igor had a hand in it. I recall reviewing it, but I don't think I had any revisions. And the estimated value at that time was more in Igor's hands and the lawyers, because Igor's got a better handle on those things than I do. So that would have been kind of how we dealt with, for example, that one unique instance. So when I say I understand, like that was, yeah.
And that particular document, presumably you indicated that you reviewed it, would have been drafted in English, or if it was drafted in Serbian, it would have been translated into English for your benefit, because it was lodged obviously in Serbian.
I don't know I think this might have been a dual translation, or maybe I'm wrong. Then they would have, because this was an important document that we were asking for compensation. So I don't recall if in this, and it's not very long, right? So whether they sent me an English translation or it was, because sometimes they do things in Serbia, it's like, it's got Serbian on one side and English on another, like if it's a power of attorney. I don't remember if that one was like that, but I mean, I definitely read it and we had a call about it, but I was not drafting it, so.
I simply want to make sure that I understand correctly that there were evidently some documents that you reviewed. Counsel for respondent asked you quite a lot about whether you received written advice, whether you reviewed documents, and as a matter of generality, the impression that I got, but this is what I want to test, was that as a matter of generality, in fact, you didn't review documents either because you didn't consider it necessary to review the documents, or because the documents were in Serbian and therefore you were trusting the advice of others.
So the level of oversight that I have is there are on certain occasions documents that they would translate. I mean, I think the question was, did I go and review construction permits? Well, no, because first off, I'm not an expert and have a substantive familiarity with Serbian real estate law, so I would not have gone back into the archives and reviewed that. There definitely were times when, and Igor sometimes just does a Google Translate and sends it to me, or I just get advised by both Igor and Nenad, who's been our longtime legal counsel. And so we go back and forth. And part of this is somebody's going to have oversight on review. And so whether it's Igor and Nenad, or sometimes I'll say, what, can you just send me a quick translation? And they'll send it to me and I'll review it. So I definitely have reviewed documents, but I choose those that I feel I need to review. And sometimes I just don't need to. As long as they explain to me what's going on and why it's important and what I need to know, I've got trust in them.
And with regard to developments in Serbia more generally, not transaction related, not associated with documents like this, you were presumably dependent on either Mr. Obradovic or Mr. Markicevic advising of these things, because apart from Google or other English language texts or newspapers, you were not able to follow what was going on in Serbia with a degree of granularity.
So Mr. Abradovich, although, you know, I mean, he had a level of involvement throughout. It was kind of early in 2012 because there was involvement. When we brought in Mr. Markicevic, Igor, that was later in 2012, in the summer of 2012. And on, for example, the companies that are now owned by Kalemegdan, with the exception of Pester, the other ones, Igor pretty much had oversight of those. And so I was not speaking with Mr. Abradovich very regularly at all. And I wouldn't have sought his guidance in terms of, you know, any type of legal or business analysis. So of course, as an English speaker, when you're in a jurisdiction where the laws are somewhat foreign, and when the documents are in language you don't speak, there's a certain level of reliance. But I was pretty comfortable in the working relationship we had. And if you've got people you trust and they know what you need to know, like in Bill's case, I tell Bill what Bill needs to know and the decisions that he has to make, then he makes the decisions. And so it kind of filters down. Igor does the same with me. We do the same with Bill. So yes, there's some reliance, but there are times when I say, you know what, I want to get Nenad on the phone. I want to understand this better. And in some cases I'd say, you know, please, you know, show me the relevant passages if that's what we're doing. And they'll, you know, maybe they'll send me a Google Translate, maybe not, but I get what I need to make decisions.
I understand that. I'm just
Sure.
trying to understand where you got your information from. And
But it's not, sorry, just, I don't, we have had considerable involvement from 2012 with our legal advisors on a whole host of issues. And as smart as Igor is, and he is smart and he is capable, he's reliable, he's trustworthy, we would not have been able to move forward without substantive legal advice. And that has given me, and Igor, frankly, a lot of comfort in the decisions that we've made.
I understand that. I'm trying for the moment also to establish the role of Mr. Abradovich, because although you said that particularly once Mr. Markicevic, and I think I'm obviously mangling the pronunciation of his name.
Markicevic.
Markicevic.
Did I get that right? Yeah.
Markicevic, I will try and
Okay.
and get it correct. But although Mr. Markicevic came on board in whenever it was late 2012, early 2013, I forget the exact date, Mr. Abradovich was there for a period of 11 years during your tenure.
Sure. Yeah. So, Mr. Abradovich, the whole kind of like Bill's introduction to Serbia was through Mr. Abradovich. And Mr. Abradovich introduced him to Belgrade, and they had looked at a number of deals that actually weren't consummated. And then ultimately, there were a number of these companies bought out of privatization. Up until 2012, Mr. Abradovich was kind of Bill's guy on the ground. He was the bear holder. He held the shares and was responsible for that oversight. The reason why I was hired is because that oversight was lacking. Mr. Abradovich was not a lawyer. He was not an educated, overly sophisticated business person. He had an eye for good deals. There's no question. I'll give him that. But he was not a sophisticated business person. So when I came in 2012, that became, I mean, that was one of the reasons for Bill asking me to go. But as the year went, or the 6 months went on, I said to Bill, look, you need somebody else on the ground here. And you need to kind of not let George look at and oversee management of these companies. And Bill agreed. And that's why Igor was hired. George was still the holder, the nominal holder of these shares. And there was still that relationship going on. And there was no need to change that. And so when Bill said, look, let's do this restructuring, you know, Bill was not going to travel there. I was not going to go back and forth. The easiest thing was just to keep George as the nominal holder. You know, he can vote the shares. If there's any other things that he has to deal with, he's on the ground. And as time went on, he basically had no involvement with these companies. I mean, he hasn't had involvement with these companies other than being that nominal holder for quite some time.
So essentially, if I understand your testimony correctly, Mr. Obradović was, as you say, the nominal shareholder who received instructions from Mr. Rand and executed those instructions.
Yeah, certainly more before 2012. I mean, after 2012, because management had been kind of now overseen by Igor, or undertaken, if you want to call that, because I mean, he was, the general manager of Obnov as well. But so Igor was involved in not just management, but overseeing the other companies. So George's role was considerably diminished, or the scope of it was. So to the extent that there was any instructions that Bill had to give him, he was going to follow it, but it became less and less so because George was just not really that involved anymore.
I mean, it appears that Mr. Obradović, though, had some continuing substantive role. I mean, he was one of the witnesses advanced by the claimant in the Rand investment against Serbia case.
Yeah, and that was, so his role in BD Agro as compared to the other ones was more significant, but it was also the same, which is kind of post 2012. His role, even under those circumstances, was considerably. I mean, he was, like in BD Agro, he was on site often. I mean, with these other companies, it was much less so.
I anticipate that I know the answer to this question because you've hinted at it, but let me ask the question and get your direct answer on the point. Why, to your knowledge, did Mr. Rand and Mr. Obradović part ways in December 2023, if I'm remembering the date correctly?
So Coropi had that effectively a call option. He could transfer the shares whenever he wanted. And I mean, I suppose we could have dealt with it earlier, but there was no need to because it was neither here nor there whether he was holding the stock or not. Bill had, or his kids had, the beneficial ownership through Coropi. It had come to our attention towards, I think, the end of 2023, or maybe it was the mid part, through our legal counsel, that there were questions with respect to inappropriate behavior that Mr. Obradović had undertaken with this separate company, Pester, with respect to distribution or disposal of assets. And Bill's a very trusting guy, but he has no interest in being associated with people where he feels and is comforted or gets comfort that they have acted inappropriately. We had conversations with the public prosecutor in Serbia who was looking into this matter. I had asked Igor and Mr. Stankovic, our legal counsel, to review the documentation with respect to the disposal of these assets. And I had received back basically advice that there was merit to what the prosecutor was saying. I conveyed this back to Bill. Bill was very unhappy. And Bill said, end it now. And basically, we exercised the call option, transferred the shares, and that was it. And I mean, nobody stopped.
Okay, thank you on that. Just moving to your the way in which you were badged as managing director, and as I recall, both from your oral testimony and also from your written statement, that was a decision that you and Mr. Rand took after discussion because you considered that it would be more efficient than getting an apostille authority or anything of that nature would allow you to as well represent or take decisions for Mr. Rand. Am I misremembering?
So I don't think an apostille actually apostille wouldn't have anything to do it. I mean, it actually, Canada became a part of the apostille convention, I think, like last year. And before that, if we ever had to do documents in Serbia and get an apostille, it was a huge hassle. But that's a separate issue. Like I could never get an apostille. Anyways, the managing director thing was, I mean, I needed some title. I mean, so when I would go there and represent Bill's interests, I needed to say I was something. And because, again, it was a private equity company, and because I had done work a lot of work previously when I was running the public biotech company with the investment banking world. I knew what their titles were: managing director of biotechnology, managing director of natural resource, and so forth. And I knew in private equity, this was a common kind of like senior managerial function. And I said to him, well, what about managing director? And he's like, okay.
But you did not decide, for example, that it would be more directly correlated with your actual role to badge yourself, for example, as consultant or advisor or representative or something of that nature?
Well, I mean, I think the title of managing director is a representative, right? Like it's a
Well, let me stop you there just to clarify the point to which I'm sort of edging. And let me stress, I'm not a Canadian lawyer, I'm not a Serbian lawyer, I'm not a Cypriot lawyer.
It's pretty close, so it's we're all from
But-
the same common law world.
But as a matter of English law, if you badge yourself as a managing director, it causes those with whom you are engaging to understand that you have a role, and it gives rise to questions of, if you like, corporate liability. Now, because when you are representing yourself to be the managing director of a company, just like when you are representing yourself to have some other formal title, the expectation on the part of those with whom you are dealing is that you are not simply someone who is exercising occasional delegated authority, as you suggested in your witness testimony, but rather that you are the managing director for all purposes. So I'm trying to understand whether you considered that there was any a risk, if you like, of representing a fiction to those with whom you were dealing.
So the answer respectfully is no. I never had, until this arbitration, nobody's ever questioned this title. My delegation, in a way, was not kind of isolated events. I mean, you get delegated certain tasks. I mean, I work with Bill through this consulting agreement. And the reason why it's through consulting agreement is more preferential from a tax perspective. And I do work with other companies. And Bill knows this. But in terms of the title of managing director, in North America, it's a common managerial title, and nobody's ever questioned me about it. I don't know. I'm not sure what else I can say.
No, well, thank you. That's fine. And let me stress that I'm not questioning it. I'm just trying to
No,
understand.
fair point.
And I'm trying to understand, for example, what appreciation those on the other side of your 10% share acquisition might have had, or indeed others, or indeed lawyers, when someone who is badged as the managing director then seeks to make a purchase. I mean, would there be or have been a warranted appreciation that in fact you were acting on behalf of or together with Mr. Rand, even though you were buying through MLI?
It was on the public market, so I don't know who I was buying from.
Well, presumably you were only buying from the employee shareholders who had received their shares following the privatization.
I don't know, because it's a public market, so it's de-identified. I mean, I knew that there were some sell orders, and they took out the sell orders. I mean, that was, so they wouldn't have known that I was buying, and I didn't know who was selling, and it's just a public market.
Okay, thank you. That's helpful. May I ask counsel please to call up first witness statement, or it's there to scroll to paragraphs 34 and 35. And let's have a look at paragraph 35, where you say, in addition, I was advised that the 2013 DRP made it impossible for Obnova to convert the right, etc., etc. I drew this to your attention when I asked my question in the midst of your cross-examination. Can you be a little bit more specific about who you were advised by, and whether there, to your knowledge, whether there is any evidence on the record about that advice?
The advice that our right of use was affected by the on that specific point, I can't tell you if that specific piece of advice or a specific issue was of a narrow legal kind of like, I don't know, but it just seemed, I mean, when I was explained the 2013 DRP, this seemed to be kind of a substantive overhaul of Obnova's rights. Like not, and I mean, there was no, we couldn't retain the right to use if they were going to come in and put a bus loop there. So just, I mean, maybe there's a more nuanced kind of thing you're looking for, but I mean, it was like, look, you've got these buildings, you can't do anything with them. You had a right to use, that thing's gone, and now the city is zoned this for one and one only use. So
I understand that. My point was a much more straightforward point. It's whether you recall by whom you were advised on this, and whether there is any evidence in the record of this advice. I'd be interested to see it, and I obviously haven't been able to review every single document.
No, of course not. I don't recall about that. It would have been in, it's like whenever we found out, or whenever I found out in 2014. So obviously we were speaking with lawyers at that time about like, what does this mean? Like, when Igor first told me, I said, they can't do that. Well, so once we found out about that, it took us some time to kind of, what does this mean? Talking to lawyers, how does this impact us? So it's not like we found out on a Friday and a Monday we had our answer. It took some time for us to figure this out, but we couldn't have figured it out without legal advice. I mean, we just couldn't.
And of course, this goes back, and I'm not going to retrace the steps, but just to sort of recall it, this goes back to the email at Exhibit 337, which was sent in September 2014, drafted by Mr. Markicevic, but perhaps not reflecting, notwithstanding that it was 9 months later, that the rights of use. If you go back then to paragraph.
But can we pull that up? Sorry, can I see that language again that you're referring to in that email?
If you scroll down there, please. On the next page. There we are. That paragraph.
Yeah, so the land is owned and Obnova has the right to use it. But I mean, the thing that I'm referring to here is made it impossible for Obnova to convert the right of use to ownership. So I'm looking at that, and it looks like what I'm referencing is just the right to use the land, not to convert it into ownership.
Well, let's read the next sentence. The new law that will regulate construction procedures, registration of property, etc., is expected to be in the Parliament shortly, but it is still uncertain what kind of changes it will bring. Now, I'm assuming that the advice that you were given would have been up to date, but this new law presumably was the law that was passed in December 2013. It was the DRP. And yet that's not, we're not referring to the 2013. So this is new laws with respect to, construction proceed, like the conversion price, that kind of stuff. I would not have been referring here to the 2013 DRP. So if you were not referring to the 2013 DRP, but you were still asserting to Mr. Rand in an email that was drafted by Mr. Markicevic 9 months later, it rather suggests that there was a timely appreciation of what was going on. And yet nonetheless, here you say, or the email says, Obnova has no right to use it. And in your witness statement, if we go back to paragraph.
Sorry, Mr. President, can you see, it says Obnova, you said has no right to use it?
Sorry, you said Obnova has the right to use it.
Can I just read this again? So we have the building permits, land is owned by the city, Obnova's right to use it. New law, which is the law on like conversion, which is what my recollection is, expected to be passed, but we didn't know exactly what that law was, because until it's passed, we don't know what it's going to say. I mean, when I read this, that's all we're saying. And it could have been, it could have been that we found out about the DRP after this. I'm I don't know exactly when Igor called me and told me about this. I'm not sure.
Right. And that's consistent with what you said earlier. If we go back to your first witness statement, please, paragraph 34, you say the adoption of the 2013 DRP precluded any development of Obnova's premises.
Mhm.
And I just pause to contrast that with what seems to have been said earlier on, but you make the point that you don't recall when you were informed about the 2013 DRP. And then it says, to begin with, the 2013 DRP expressly prohibited any development on the land affected by the plan,
Mhm.
other than the envisaged bus loop. And there's a footnote there to page 6 of the 2013 DRP. Now, I'm not going to take you to that DRP because I think this is something more for council to address. And I'm not in their direction. We would expect them to come back to address this. I'm just wondering who introduced the footnotes into your witness statement.
Well, this was drafted in conjunction with our legal counsel. And this was, again, when we had notations about what I was advised with respect to the law. I mean, my understanding is if I'm going to talk about the DRP, we should make a notation of that.
Right. So if I was to take you to the exhibit C24, would you be able to walk me through the detail of that and to page 6 where it apparently says what you say it says?
I'm not sure me interpreting the DRP, which has been translated in English, would be helpful to you. But
right. Thank you. That's what I expected, which is why I'm not going to take you to the document. But I would in due course, and again, this is simply a point of clarification, I stress. I would in due course like counsel to address that because I struggled with the language of the DRP to find out exactly what it said and how this correlated.
No, I think it's a fair point.
Just to clarify, and this is not apropos anything, but just to clarify, you indicated that your consultancy contract permitted you to have other business interests, and you've sort of hinted at some of those other business interests that you were, I think, managing director of another one of Mr. Rand's companies. Can you just develop that a little bit and what your other business interests are and the extent to which your other business interests are either side interests on your work with Mr. Rand or whether they are much more significant in personal and financial terms?
So my predominant work, or the predominant time spent, is with respect to Mr. Rand and his investments. So Serbia was one, another company called New West Energy Services, which is, as I said, Mr. Rand was one of the largest shareholders of that public company. I was a director, corporate director, and the executive chairman of that company. But we took it private a couple of years ago. I do a lot of work with another individual in Vancouver who is a very successful person in the mining sector. So I am
in Canada.
Yes, very successful.
I just want to clarify that it wasn't in Serbia.
No, not in Serbia. No, in Canada. In fact, he's staked more property in Saskatchewan for uranium and from Saskatchewan than anybody else. So as part of that relationship, I work with him. Bill knows it. His name is Tim Young, and he's a close friend of Bill's as well, but it's totally separate. As part of that, I do work with him personally. I'm a director of a company that he's a shareholder in called AFA Energy, which is a publicly traded uranium company. I am the director, although in CEO, but it's a small public company, of a company called Golden Harp Resources, which is also a mineral exploration company. Not last year, but the year before. Also, Bill knew about this and was supportive. I did quite a bit of work with Silver Bowl Resources. So, I do work and through Anacott, which is the consulting company. My wife, who was general counsel at the second largest university in British Columbia, also does consulting work for universities through Anacott. So, I mean, all of this though, I'm not going out and going rogue and working for, I mean, Bill knows this, right?
Sure.
So most of my work is for Bill, but he's, you know, so long as I do my job, he's supportive of me fulfilling these other roles. So it's a great job that way.
Thank you. No, that's very helpful. You are a lawyer, having practiced law for some years. Mr. Rand is a lawyer, having practiced law.
Was a lawyer. He's no
Well,
longer called. He
okay,
hasn't been
he's-
called
he-
for a long time.
Okay. I think the reference to is a lawyer. is
Once a
that
lawyer,
the-
always a lawyer.
Once
Yeah,
a lawyer is
fair
always a
enough.
lawyer, precisely. I'm just interested to explore a little bit further your response to Respondents' Council's line of questions, which seemed to sort of elicit your testimony that it was only very rarely that you, if at all, that you advised Mr. Rand in writing. I mean, we have the email, but
Yeah,
you did
I
not send
think
him
that's-
legal advice. You
I
did
think
not
that's-
have legal advice, I mean, written legal advice.
So while I'm a lawyer, and I'm not providing legal advice to Bill per se. I oversee his investments, and as a lawyer, gives me a very unique opportunity to kind of understand legal frameworks. Although frankly, at the beginning I struggled with the Serbian landscape because it is difficult. However, when we need to facilitate that, I do, as I noted, seek out legal advice and I report back to Mr. Rand. A lot of these times it's used to be on phone calls, now it's through Teams, at his house in person. He is more engaged and he's more kind of open and active when we report to him in person.
I understand that entirely. It's really just, again, to clarify the point that when you advised Mr. Rand, it was invariably orally, occasionally by email, but I don't
That
think
is correct.
we have anything on the record where you transmitted to him a legal document and said, I'd like to talk you through this, or this is going to require some big decisions or something of that nature.
No, because he wouldn't read it. It's just, his business, again, he's 60,000 feet and I'm at 30,000. And, as this, after 13 years, as he's gotten older, you learn what the best way is to make sure that you have his attention and that he knows exactly what he needs to decide upon. And, I've just found Teams has actually been really good because, for example, he'll be in Palm Springs for 4 months. As soon as he gets back, he's leaving the day after and then he'll golf every day. So we'll say, let's have a call. We'll have Igor, and we just walk him through things and we say, this is our recommendation. Do you agree? Somebody says no. So most times it says, yeah, I agree because we thought about it.
Thank you. That's helpful. I mean, in your evidence, in your testimony about the 10 euros consideration.
Sorry, the tenure of?
The 10 euros.
Oh, yeah, the 10 euro,
consideration.
yeah.
Your legal training obviously kicked in. And it's interesting to me, and I'd just like to explore it. Your legal training kicked in and said, I'm quoting the nuance rather than the statement. Being a common law lawyer, there's a risk that if there's no consideration, the contract may not be of any value, and therefore I'm going to hand over two euros so I can say to myself that I paid consideration. Like you retain a lawyer and you pay 1 penny, and then you
Yeah.
well, correct me if I'm wrong.
Yeah. So, and I don't know if it's different in the UK, but certainly in North America, again, when there's nothing like tangible, like I'm selling you this cup, right? So in this particular case, there was already that relationship as between Bill and Mr. Abradovich. And so as it kind of continued forward, these trust agreements were really reflecting in a way what was already there, except incorporating Coropi. And so what, like if I had drafted it and I had, I would have said again, for 10 euros, now receipt and other good and valuable consideration, the receipt and sufficiency is hereby acknowledged. But I did notice that before we went out, and that's why I said, oh, we should probably give him something, even though I would have been comfortable because there was consideration already. There was a business, arrangement. And so in Canada, we do see, it used to be $1, and I don't know if it's inflation or what, but now you often, you'll say, $10. I actually did, some work before with this other friend of Mr. Rand's. And then that one I said $100, although I thought to myself, does it really matter? 10 or 100? It's just, it acknowledges this consideration. So that's what I did.
I understand that, and that's perfectly clear. Again, what I'm trying to just to clarify, so there's no uncertainty in my own mind, is your evidence in response to Mr. Keller's questions. The legal mind kicked in and said, I should give consideration. But the legal mind didn't say, I ought to record the fact that consideration somewhere so that if someone questions it, I can show the expenses claim, or I can show this or that or the other.
Yeah, I suppose I could have done it. And you'll have the opportunity to ask Igor about it too. But I was there in Serbia. I thought it was kind of belt and suspenders, which is what the trust agreements were. And, I didn't get a receipt. I don't know,
What is what is, one can't reinvent that.
Yeah.
May I take you to paragraph 14 of your first witness statement, where you say, I understand that Serbia questions the reason for the restructuring and asserts that it was done in order to obtain investment treaty protection with respect to potential dispute related to Obnova's rights onto its premises. That assertion is not true.
Yeah.
And I'd just like to know how you know it is not true.
Because I didn't even know at the time that this whole world of treaties and investment arbitration existed. But
this statement in paragraph 14 is not going to your knowledge of investment treaty protection. It's going to Mr. Rand's knowledge, and yet you are hearsay asserting that it is not true. And I'm just wondering, did Mr. Rand say to you it is not true?
No. You mean for the purpose of preparing this?
Yes, I'd like to know when you say it's a very affirmative statement and you've given your...
That's a good question. So unless Bill had in the back of his mind, this was the purpose and never uttered it to me whatsoever, which would be bizarre because he didn't even, he's never been involved in this. And I know he told me it was for tax reasons, and I know what advice he'd been given previously with Thorsenson's, and it makes sense to put it through in Cyprus. And so I know it's false, because if there was an issue like that, Bill would have raised it. You can ask.
But this statement is assumption rather than within your own knowledge. That assertion is not true.
Sure, I can accept that. I can tell you that at no time, under any circumstances, until years and years after the fact, when we had an issue with the other company, nobody even muttered these words, investment arbitration. I know it's normal for you guys, but when I explain to people what I'm going through here, even my lawyer friends are like, huh? It's very new, it's very niche.
That's fine. I'm not trying to get you to a point that deals with investment treaty protection. I'm just trying to understand whether, when you say that assertion is not true, whether there is something that stands behind it, or whether it is your understanding out of the ether.
Bill had Bill's representation, it's all about tax planning, and let's move it to Cyprus, which of course is a very favorable tax jurisdiction. That's all it was.
Please don't take the next question as an implication in any way that, if your answer is yes, that this is in any way improper? I'd just like to know, did you and Mr. Rand look at each other's witness statements in draft?
Yes.
Thank you. So he knew what you were going to say?
No, he wouldn't have read mine. But certainly I looked at his, of course.
Right. There are elements in the language
Yeah.
which are quite similar.
Yeah, for sure.
Thank you.
But yeah, no, he wouldn't have. I mean, he's not going to be reviewing my stuff. He's very hands off. So he'll review his stuff, and lawyers, we walked him through it. We talked to him about it. We would work with him in terms of what the status was, what the scenario was, as he knew it. So he was definitely assisted in putting down, kind of his recollections and so forth.
In your experience, and I'm not asking you to be a lawyer, and I'll take your response with a caveat of caution on your part. I'm curious, as a lawyer from another civil law, another common law jurisdiction, that it appears to be common as regards the evidence in this in these proceedings, that the beneficial owner can, without more, simply instruct a trustee to take certain action, rather than the trustee acting in the knowledge of what his or her trust responsibilities are. In this area in which you're involved, is this a normal way of proceeding, that a beneficial owner can simply, on the record, instruct the trustee, you will do as I say?
Is this with respect to the Ahola family trust that you're asking?
Well, it's with respect to Mr. Obradovich.
Yeah.
And there are a number of documents on the record,
Yeah.
which indicate an agreement between Mr. Rand and the Coropi trustees, or Mr. Obradovich, that you will not do anything without the direct instruction of, and it's quite clear that Mr. Rand is the one who gave the direct instructions. And I'm just trying to clarify whether it is common and accepted that a beneficial owner can simply give an instruction to a trustee. I'm not a trust lawyer.
Yeah.
I'm an English lawyer, but in my English law knowledge of trusts, there is, whether it's a fiction or not, but there is a very clear divide between the entitlement of the beneficial owner and the responsibility of the trustee to act. And the trustee will invariably reserve his or her authority to take a discretionary decision.
Yeah, I think that when we talk about beneficial ownership and so forth, I think that the structure that we've seen, which is that George would hold this, for example, as the nominal holder, and then later we saw the restructuring. From my experience in North America, this is not uncommon. Now, I'm not a trust lawyer either, and even though we characterize this as in trust, really what it is, we've got a nominal holder who's holding it effectively for convenience, because Bill doesn't want to fly back and forth. Bill is the ultimate owner, but this other person also works with and takes directions and works for Bill, if that's what you want to call it. So Bill instructs him. So I actually, from day one, didn't see anything unusual about this.
It seems to be, but this is not something that we'll get into with you, but it seems to be more than just for convenience.
Convenience was a big part of it. Bill doesn't want to fly back and forth to Serbia all the time, and doesn't speak the language. And, especially again, like I said, as time goes on and, he gets older, he doesn't want to deal with this stuff. He wants his people to deal with this.
Okay, just moving on to, and I don't have many more questions, but moving on to your purchase of the 10% stake in Obnova, which I think you address at paragraph 44 of your first witness statement. We can call it up, but I'm not going to take you to the details of that. And you say you did not coordinate your purchase of Nova's shares with Mr. Rand, and you did indicate that you informed him of it in advance. But from your evidence, it does not sound as if there was an engaged discussion of any detail. It was, Bill,
No,
I'm going to buy this, and he said fine, and nothing more than that.
I don't even know if he said fine. I said, there's 10% popped up in the market. I'm going to pick it up. Okay.
And in circumstances in which the bulk of your professional endeavor was devoted to working with Mr. Rand, as you testified earlier on, is there no issue at the back of your mind that perhaps you buying 10% might have given rise to a conflict of interest with Mr. Rand, because all of a sudden you would have a significant minority shareholding in a property in which indirectly he was the principal shareholder? Maybe that might have been issues in due course of wanting to sell, but you didn't want to sell. I'm just curious about whether any conflict of interest or potential conflict of interest arose in your mind.
Well, no different than if somebody else held the 10%, in the sense that if Bill wanted to do X or Y, he was going to do X or Y, regardless of whether or not I agreed or other people agreed. So first off, I didn't see any conflict of interest whatsoever. I saw it as an on-market purchase. Yeah, I didn't see any conflict. Even though, Bill's, for example, a chairman of a company called Aranova. It's an exploration company. And they, I think just over the last couple of months, they've raised that up $5 or $6 million. And I participated in the private placement, the first private placement. I think it was the end of November, beginning of December. I know other people. The guy didn't ask Bill's price. I said, hey, by the way, and I told him. He was, oh, okay. So that's another company I invested in. And in this case, Bill's he's not the majority shareholder. He's a big enough shareholder. He's the chair. So I participated in that private placement and just told him after. Okay.
Okay, thank you. The phrase that you used, and this is consistent with what you said in response to an earlier question from me, is you said this was an on-market purchase. How did you come to value that 10% stake? There were 198,000 units.
Well, to state the obvious, it's not an expensive purchase, right? And the only real question for me, and then, which is probably another reason why, nobody else was putting sell orders on there. Somebody wanted to sell. Okay. I just had a sense at that point, again, hopefully we could resolve this. And if not, I got that legal advice. And so in my own mind, whatever the value ended up being, it was a lot bigger than what my investment amount was. And so the investment certainly seemed like a good idea.
I understand that, and I'm not sort of edging towards any question about whether this made good financial sense to invest. I'm just trying to establish how you came to that valuation, which is about 1,700 euros or 2,000, just to sort of round it up. And as you say, it's not a huge amount of money, and it was an on-market purchase, so there was a willing seller or multiple willing sellers.
That was the price they were asking.
I understand.
So I didn't determine that. It was either I accept it or not. So it was on market. There was the price. And I said, well, let's buy it.
But you would have presumably said, this looks like sort of a good deal, because either the city is going to relent in the DRP, or I'm going to get compensation value. But presumably, if you as a reasonably informed investor would have had that sense, so would the sellers, and therefore the possibility of either compensation or the city revisiting the DRP would have been baked into the price. My question here is, if we take 10% at 1,700 or so euros, that puts the value of the company at 10 times 10, 17,000 euros. Your claim in these proceedings, and you are one of the claimants, is considerably more than that. So I'm just trying to understand how you came to that valuation.
The valuation of 1,700 or 2,000 euros for that.
Yes.
So again, I didn't come to that valuation. That's what they had put on as a price to sell. I think though that you're implying kind of an efficient market in Serbia, where sellers are knowledgeable and sophisticated, where sellers have bothered to go out there and get full information, et cetera, et cetera. I think what you'd find in Serbia is that marketplace, which it's struggled for years, is a very inefficient model. So I took what somebody wanted to sell, which could have been former employees, I mean, I don't know who they are, as in a way absolutely irrelevant to what I thought the value could be. I mean, and I don't know if you've ever visited Belgrade. All you have to do is walk around the Obnova property. It's a great property in a great location. And I was already seeing in 2017 that there were positive changes happening throughout, step by step by step. That's it.
So I understand that fully, and I appreciate entirely that it was not an efficient market. What I'm trying to understand is whether, when that 10% became available, whether you said to yourself, oh my gosh, this is an extraordinary discount on its value for me, if either the city revisits the DRP or I get compensation, because gosh, I'm going to be able to claim compensation for millions and millions a la these proceedings. So did you see this as an extraordinary opportunity, or was this just a commercial transaction?
Well, I'm not sure that it's mutually exclusive. I mean, it was a great opportunity and it was a commercial transaction. And so, you know, like Bill, I mean, I wish I could emulate Bill. Bill's had a life of basically good asset acquisitions with incredible appreciation over time. And, you know, I looked at this and thought, this is a great deal. You know, the private placement I was telling you about that I participated at the beginning of December, that's going to be an incredible deal, like incredible. So to the extent that you can get an asset and somebody wants to sell it and you look and you see value in this, I'm happy to take it.
Okay, thank you. I just have one more question, and let me preface it by saying, do feel free not to respond to it, because I've already put this to your counsel. But you were a witness in the Rand investment against Serbia proceedings. Do you have any takeaway assessment for the tribunal as to what your view as a participant in those proceedings is of the bottom line of that award, which
part of the award?
Well, the part of the award concerning the Canada-Serbia BIT.
So
which is the basis on which you are proceeding in these proceedings.
Yeah. Well, my takeaways on the Rand decision is, I mean, I think they certainly got it right in the merits. There's no question. It was egregious conduct. I think they also looked in those circumstances where they had kind of multiple linked claimants, and somebody had to get paid, right? And so it was easiest to just give it to Bill. And so they kind of chose the path of I don't know if you want to call it least resistance, least analysis, so to speak. I think they got it right. So I think quantum was flawed. And
so you think quantum was flawed, liability was right, but the decision on the Canada-Serbia bit was, these are not your words, let me stress, was a bit of a cop-out because they just found that they could find liability on some other basis.
No. I think, look, generally I don't think that's what it was. So they had in that particular arbitration, and again, I'm no arbitration lawyer, right? If I was, I'd be sitting over there. They had a number of claimants throughout a line of investment. And you're not going to pay all of them the same amount. I mean, there's an aggregate amount that they'll find on quantum. And it appeared to me that the easiest thing was just to say, okay, Bill's claiming under the Canada BIT, he's last, and let's just give it to him. Even though we had Cypriot claimants, and even though we had also the kids and so forth. But I have to say, I mean, I thought the tribunal on the merits got it absolutely right and recognized the conduct of Serbia. I just think that they made some material errors on the quantum side. That's it.
Thank you.
And on jurisdiction, I mean, these guys could speak to it. They know
I'm sure they
more
will.
about that. Yeah,
I'm sure they will. Let me just turn to my colleagues. I may have asked all the questions that occurred to them as well. Do you have any questions?
I have just two very briefly.
Microphone.
I think, sorry, I think indeed you probably asked almost all the questions. No, I want to come back, Mr. Broshko, to the way in which you related to Mr. Markicevic and Mr. Rand. From what I saw, and we can ask Mr. Markicevic the same question, but I wanted to hear from you, is that you were 6 months in Serbia, right?
Mm-hmm.
And I assume that, and I'm asking, during that time, of course, you have significant involvement with the people on the ground.
Correct.
When I mean people on the ground, I mean general managers of the companies, because this is, and correct me if I'm wrong, there are 5 companies.
Yes.
Or 6.
6, 5,
Six.
yeah,
Six,
6.
five. So you had to talk to, well, through someone, I assume. I
Sure.
don't know if they spoke English at the time or you needed a translate. I'm speaking before Mr. Markicevic got into the scene, right?
So there was of course Mr. Obradovic who was there. He spoke English. Luba Jovanovic, he spoke English. He was at the time the general manager of a company called BD Agro. So the two of them would assist me. You know, I mean, I was introduced to the managers on the ground. We'd go to the different properties. Yeah, I mean, that's kind of how I functioned there. And it became a lot, it was much more simple once we had started to engage legal counsel because, you know, they were really able to kind of like help me work through kind of how everything worked and kind of the general basis of the law. But in terms of on the ground, Mr. Obradovic, Mr. Jovanovic, he would, the two of them would assist me. And it was a lot easier also when, because I would have to like say to them, hey, let's go here, or I want to, you know, come take me there so we can speak to a manager on this company. So it was somewhat limited in that respect, which is why, again, I suggested to Bill that we centralize kind of his oversight with one person who spoke English and could dedicate their working days to assisting Bill in that respect and communicating with us.
And you said that it improves when lawyers were engaged.
Yeah,
So I
totally.
assume when you arrived there, there were not like the one
So-
law firm advising the entire.
So, I mean, they did have, like, for example, BD Agro, which is one company, had like an in-house counsel.
Yeah.
Although I didn't speak with him because I don't think he spoke English. And I do understand that they did have some legal counsel at the time. But first off, I wanted to engage on Bill's behalf our own legal counsel so that we were getting completely unbiased information, that any changes with the companies, for example, downsizing, that we had legal counsel that would be responsible, you know, to Bill through us. And so that's why it was important for us to get our own legal counsel, which ultimately then was incorporated. Once Mr. Obradovic was kind of less and less and then out of the picture, it was our legal counsel that was providing us exclusive advice for the companies.
And you at that time were able to talk in English directly to them and get it.
To the legal counsel?
Yeah.
Yeah, the people at PwC and then Kranovs Nicholas, they all spoke English.
And then Mr. Markicevic got into the scene. I understand that, and correct me, that he became the general manager.
At Obnova, and, you know, he was involved in the other companies, but as for Obnova, exactly, he was the general manager.
Of Obnova was
Of-
the only one that he was general manager, right?
I'd have,
I'm asking. I don't
yeah,
know.
no. I don't recall if he was a general manager of some of the other companies. I definitely know that Igor was very hands-on with the other companies because he was providing that oversight. But whether or not it was a formal managerial position, I just don't recall at this point.
But Obnova he was. And we
Yeah,
can-
Obnova, 100%.
And
Yeah.
we can ask him this,
Yeah.
but you recall that how many workers had at the time? Obnova, or we can ask him. But your recollection, it was an operative company with cash flows.
Yeah, it was, but I mean, this was up until when I went there, there was it was steel waste before, steel kind of recycling. But even at that time, that had basically ceased, and now they were leasing the land out as opposed to that operational entity. But that's how it started. It wasn't like you had significant operations on that site. It just wasn't. The value of that organization was the real estate investment. That's where the value was. In terms of the number of employees, I mean, I'd go there. The manager at the time did not speak English. He was very dark. I can't remember dark complexion. And I would go there with Luba. I'd go there with George, and kind of get an update through them as to what was going on. I'd see a number of the employees walking around, but in terms of like that kind of minutia, I wasn't really involved. And then, when Igor came, I mean, that was all left to him. I was not managing anything.
And that's my next question on this, and I'll close. Then you came back to
Vancouver.
To Vancouver, and how often you came back to Serbia? It was regularly that you were traveling?
Yeah,
or you were most?
No, I mean, so there was regular conduct or regular communication.
With Mr. Markicevic?
With Igor, yeah. So, very regular communication where he provides updates, and we bring Bill in the fold when we absolutely have to. But you can only do that so long. You can't do that all the time. You need to go there and you need to see how things progress, right? You want to see, when you're there and you're going out to the restaurants, you see how the city changes, you see how things progress. And again, because it's a different business culture than I was used to. And so I would go back, I still do maybe 4 times a year, 5. I go back regularly, and sometimes there's lots to do. Sometimes, we have meetings over a few days, and then the rest we can go out and see our partners. And it's just, you got to be on the ground to a certain extent to see the people and talk to them. That's why.
I would say 4 or 5 times a year more.
At least. I think there was one year I went back 8 or 9 times, but that was maybe a couple of years ago, my recollection.
And last on this, Mr. Markicevic also talked directly to Mr. Rand, or would it say
So, I
usually
mean,
was?
Yeah, no,
through
so
you?
he would, but it wasn't that regular, because anytime that we had to have a communication with Bill is usually kind of some kind of decision, and again, I would give updates to Bill, but I couldn't do as good a job as Igor, because Igor, he's on the ground. He has a better understanding of kind of what's going on. So although he informs me, I'm like, okay, it's been, 2 weeks, 3 weeks, a month since, you've provided Bill an update, even though I would be talking to Bill regular, let's set up a call. And sometimes, it's required on a more timely basis because something's going on. So it just kind of depends.
No, I just was trying to understand that sort of the structure
Yeah.
that you.
Yeah,
presented to us.
yeah, that's how it worked.
So you usually would.
Okay.
So you will be involved in those.
Correct.
In those
Correct.
communications. I would say.
Correct.
You wanted-
I just wanted to make sure that your response to Mr. Jano was the same as your response to me. Most of the time, you were the one who was updating Mr. Rand. On occasion, Mr. Markicevic, was involved in those as well. You would be the one who would set those up, but this was on occasion. You were principally the one who was advising Mr. Rand.
That is correct. But not on occasion, like every 8 months kind of thing. I mean, it was regular. I mean, part of this as well is, there's that human connection that's important when you have these type of relationships. And so it's good to have regular team calls and just fill Bill in. But, I'm on the phone usually 3-4 times a week with Bill, probably the same with Igor. And then maybe with the 3 of us once a month, once every 6 weeks. Usually.
I followed that, but just going back to that September 2014 email, you said that you were not the one who drafted it, but you were the one who sent it, and it went in your name. So the advice that was coming to you was very frequently, as well, and I don't mean this in any way, in a disparaging way, but was repackaged and then sent in your name because you were the.
Yeah, sometimes I just, if it was something, related to one of our companies, I could just forward it from Igor. And nowadays I'd be just more like I'd say, Igor, just, send it to Bill directly, or I'll just hit forward. So.
Thank you.
Thank you, Dan. I have only one more question, which is related to the document that was shown to you by Counsel for Claimants, Mr. Rostislav, which is the C342, which is the document of the agreement on capital increase of Kalemegdan. You were asked about the value of the shares that you bought and bought in the market. And looking at this agreement, if you can scroll it down, please, you can see that there is a number of companies there that they are valued, right? And one of them is Obnova.
Correct.
And the value that is attributed to Obnova there is 17,867 euros. It's 1.1.4. And then there is a total amount of the shares issued to Kalemegdan in 2 million euros, a little bit more. So, which is probably the sum of all the companies that are there. So my question is, do you have a recollection of how this amount of 17,000 or the other amounts were they come up to? There was a valuation, there was simply a nominal value at the time that is reflected. They use the value of the privatization just to know. I'm asking, it's like a precise number. So I'm asking where this number.
So again, it was the lawyers that drafted this, but I was an active participant in reviewing. My understanding of this is it had to do with the initial acquisition cost, which was like something like 20-something thousand euros. And then they worked on whatever the exchange rate was of that day, which ended up being, this 17,867. But this was not like a valuation. There was no need for a formal valuation. This was them saying, okay, we're putting something in here. We'll put like initial acquisition cost, and then it just becomes kind of a share for share exchange. But that's where that number came from.
Okay. So we would say it's probably the value of the acquisition back in.
I think it was 20,000 something euros.
And the difference probably come from exchange rate that has moved over time.
Yeah, and I think I can't remember what the original privatization cost was, but I think it was like, I don't know, 32,000 euros or something like that. So, yeah.
Okay, thank you very much.
Yeah.
And just to be sure, before I hand the microphone across, this was a valuation of 17,867 euro. I'm not quite sure whether this is the valuation of the whole of the full value of Obnova or just the 70%. It looks as if it may be the valuation of the 70%, because it says which represents 69.9960.
Yeah, and it cost, again, I know it says which are valued at. This is not a valuation per se, right? This is not like you're bringing in a valuator to say what's fair market value. This is, okay, so the lawyers are saying we've got a document basically for this share-to-share exchange. We've got to put a number in here. Nobody wants to pay capital gains taxes on it. We want this to be a tax-free share exchange, and that's what they said needed to be done to effect that.
No, the reason why I'm sort of pulling on the string though is that we identified a moment ago that your purchase of 10% some years later, 5 years later, and after the 2013 DRP was valued at about 1,700 euro. Whether or not there is a correlation, this is giving us a sort of figure of pre-DRP valuation of 70% is about 17,000. Post-DRP, the valuation at which you bought the 10% is about 10% of the pre-valuation pre-DRP 70%.
I think that's a coincidence. I will respectfully, that's definitely not how we saw it.
Okay,
Yeah.
that's fine. One just point of clarification for the record, because at various stages you have referred to George when you have referred to Mr.
Obradovic.
Obradovic, and his name is Jura, I think.
Jura, yeah, it's
But again, just
yeah.
for the
Correct.
record, when you refer
Jura
to
is
George.
Correct.
Thank you.
I'm sorry, may I use the washroom?
Yes, please.
Okay, thank you.
You're,
I'll be very.
you're sequestered.
Yes,
for
I'm
purposes of the
sequestered.
washroom.
Okay. Thank you.
Just while we have that document on the screen, can I just confirm an understanding, it may be incorrect, that the 17,867 euros is the amount that Mr. Rand paid over to Mr. Obradovic for the assignment of the privatization agreement?
No. So there was one Serbian national who acquired the shares out of privatization.
Yep.
That's 2003, and then in 2005, at Bill's direction, Mr. Obradovic then acquired these shares through an assignment.
Yeah.
And so again, it was, my recollection is 20-something thousand euros. And so that number, to my understanding, is meant to reflect that, but there was some exchange rate stuff, which means it's slightly different. So that's what it's meant to show.
Right, so it's,
To my understanding.
it's the same.
It's the same.
fee.
It's the same.
Okay,
Yeah.
understood.
Yeah.
Okay, can we bring up C 337 again? It's a document that you've seen a number of times now. Just if we go to start at the top of the page, it's called Serbian Update. And so first question is, do you think this document reflects all of Mr. Rand's interests in Serbia at the time? You're going through each interest that he has?
No, I mean, it's 2014. I wouldn't recall whether or not we left some things out that would have been, or whether or not this was just some relevant items of the day. I don't recall.
Is it fair to assume that you listed them in order of importance?
I don't think so. I don't think it was that formal.
So you wouldn't have started with the important ones and got eventually to the less important ones?
Not necessarily.
Not necessarily. Because I guess my impression is that if he's sending you out there, or you weren't there at this time, but it's a big investment from his part to send someone out to Serbia, especially a foreign national, and then keep you on the payroll afterwards. He's not going to do that for an investment that he paid 20,000 euros for. In other words, that was a probably quite a small part of the portfolio of investments that you were overseeing.
Yeah, I think he looked at this as kind of an aggregate investment, and that, again, it's not even so much of the purchase price. I mean, Bill looks at this again, it's about what's the opportunity and is it worth allocating funds to develop and seek out that opportunity? And so, once you pay for it, it's a sunk cost. If the opportunity is not there, he's not going to throw any more money into it. And kind of in the opposite way, even if he got a great deal and the investment cost was, just a spectacular opportunity, to the extent that he needed to, he would contribute further funds to that. And Obnova was a perfect example.
Well, on that point, when you went out there, 2012, did you have a conversation with him as to his estimated timeline in developing the property?
No, because it was unsure.
Because
I mean, it was unsure. I mean, so when I went out there, there was kind of again, he asked me to have a look at the companies, give some recommendations, how can they be operated better, et cetera, et cetera. With respect to Obnova, it was more, my immediate task was to have a look at the company and see if there's any changes that need to be kind of immediately in terms of how things were operated, how it was organized. But all he said was, this is a real estate investment and I'd like to develop it. Now, some of the stuff that Bill has bought and held, he holds for a very long time. So whether or not in his mind, it definitely wasn't like, let's develop it tomorrow, even if we could. My understanding as he explained it is he thought that Belgrade and Serbia itself were going to evolve. He thought that there was a good chance it would join the EU, and kind of as part of that we'd see social and financial development within Belgrade, and that when the right time came, he'd like to develop it.
One of the things you'd need to do to develop it, suppose, and this draws on your experience as a transactional lawyer, if you wanted to get a bank to finance the development or help finance the development, for example, you're going to have to provide a written legal opinion about exactly what rights you have and so on, a due diligence on title, essentially. That costs money because once you've got that legal opinion in writing, obviously the advisor's on the hook. If they're negligent, then they can be sued. So at what point in time were you going to do that, do you think? And were you going to allocate the funds to obtain that sort of?
Well, we would have had to make a decision at that point to actually undertake and further development. I mean, we weren't there at that point in 2012. So there was no discussion with bank with respect to bank financing for a development at that point that was not in process. We did do research on title when I got there. Again, it was, how do I understand this? What advice can I get to understand what the rights are? My understanding when I was there, and again, has been confirmed through 3 different law firms, is that Obnova owned the buildings, had right to use the land.
What I'm inferring, though, is that you didn't get from those 3 firms, we haven't got a written legal opinion on the record. And they're expensive to get. And I imagine from a business point of view, until the time that you want to develop the property, you're not going to spend tens of thousands, if not hundreds of thousands of euros.
But if there was a reason for me to get a legal opinion, if there was a reason, then I would have just gotten a legal opinion. I mean, they were advising us, we had gotten their opinions, and it was, I only asked for things that are relevant for what we're doing. And so part of this was to get a general sense in the first 6 months I'm there of what we have and what we need to do.
That's understood, but I go back to the point, the difference between someone telling you something over the phone or even at a meeting and a formal legal opinion with bells and whistles that tends to cost a fair amount of money.
Well, it depends the extent of, we've incurred considerable legal fees over in Serbia. And, I guess all I can say is if there was a purpose to a formal legal opinion when I was there in 2012, and again, once we worked with PwC and I went over to Kranovs Nicholas, which I think was, if not the largest law firm, certainly one of the biggest ones. When the advice I'm getting is consistent.
At that point, you didn't see the need to get a formal legal written opinion. And
Well,
what I'm asking you is that because at that point in time, development wasn't imminent?
No, I did seek a legal opinion and opinions. It just, I didn't have the need to get it in writing.
Because you weren't planning on
Because
development.
the important thing was to
For a
understand,
third party, they're going to ask for a legal opinion, aren't they? They're not going to say, well,
but who are we going to give this to?
to a bank, for example, if you're going to develop. the
We
property.
weren't going to the bank in 2012 for bank financing.
Hence my point.
No,
At that point in time, you weren't planning on developing it.
that's not true. That's absolutely false.
I thought
So-
you said in response to my earlier question that you had a discussion with Mr. Rand and development of this property was not imminent, you said.
So that's development not being imminent is different than not having plans and an intention to one day develop it.
Oh, I understand that.
So
But you
development in 2012 was not imminent. That is correct. Was Bill's plan always to develop it? Absolutely.
I think that's a different point. You expend money to develop something at the time when you want to develop it, don't you?
Yeah, but you plan for it in advance. So you put all the, I mean, this, development doesn't take 2 weeks. I mean, with everything, just like in Vancouver, I mean, it's years and years long process. You have a plan. And it's not just the legal construct that you look into, but, the societal, the financial, kind of like what the city is like. That's why Bill had always said, look, it's inevitable that this waterfront is going to be developed.
Just
And the
on
question
this
is when.
document again, 337,
Mhm.
just going through it. I don't know what a lot of these things are because it's not related to this case, but look, for example, on Geo Westphalia, if you go down a bit, you talk about someone called Slobodan prepared the legal analysis. I'm not sure who Slobodan is, but maybe you can enlighten us. Was that a legal advisor that you had at the time?
Yeah, Slobodan Doklistich, correct.
And then you get to the next one, Bill's apartment, and there's someone that you've already identified, Gordana, who's helping you on that one.
Mhm.
You get to Obnova, and there's no mention of a legal advisor you're assisting you on that one, or providing the advice that is being provided here to Mr. Rand.
So if you scroll up, so with respect to the apartment, Gordana is not a lawyer. So Gordana Kostic assists us, although she hasn't for a little bit of time, but for years she'd assisted us with respect to kind of gathering documentation with respect to different properties and so forth. And she had worked quite a bit of time on Obnova to put paperwork together, to go through kind of the archives at Obnova and so forth. So Gordon is not legal counsel. And if you scroll up, the only reason, Westphalia, I think was, that might have been the milking parlor. Yeah, this is like the milking parlor for BD Agro. So obviously there was an issue. Now, whether a legal analysis, I wouldn't have gotten it because it's on the ground stuff. It's managerial stuff. So he's just giving us, an update. So, and if you look at the demand letter, I'm sure that, we would be able to source the demand letter because that's something that was sent. I mean, we do have correspondence with lawyers with respect to what they do. We have court filings with some of our companies and so forth. So yes, of course, there's stuff on the record.
So this analysis here under Obnova property registration, is it fair to assume this is provided by Mr. Markiewicz?
I'm sorry, can you repeat that, please?
Is it fair to say that the analysis that's provided in respect of Obnova, this is an analysis provided by Mr.
Yeah, I think that's fair. And that would have been in conjunction at the time with our legal counsel. So, because again, Igor had a much better sense of this on the ground. He was able to review firsthand documents. Given time change, he was able to go and see the lawyers and so forth. I'd get the updates and I'd go there 4 or 5 times a year. But yeah, Igor was responsible for this.
And in relation to your transaction, I mean, you've said various things about the state of the property law system. At one point, you said that the cadastre is a mess, and that these
So what was a mess?
the
The
cadastre,
cadastre, yeah.
and that the registration mistakes happen all the time, and you knew that there were pending legal proceedings. isn't it possible that the person selling you the shares may have come to a more informed analysis of what the state of play was? And maybe that person did do some due diligence and thought, well, actually, the Obnova doesn't have any rights of significance to this property, and this is what the shares are worth.
I mean, you're asking the question of whether it's possible.
Hmm.
Well, there's a lot of things that are possible. Do I think it's likely? No. But then again, I can't ask the person because it was on the market and I don't know who we're buying it from.
Understood.
So,
But for you to be absolutely certain that you're right, again, you would have needed to have that rock solid legal opinion in writing, I would suggest, that everything that you thought you had was properly registered in a situation where you yourself say that cadastre is a mess, that registration mistakes happen all the time, that Obnova wasn't registered, and that there are pending legal proceedings.
So I don't think that you necessarily conveyed that properly. So having a rock solid, as you say, legal opinion doesn't necessarily mean that it has to be in writing. So these are relationships with these lawyers that we've had over years. These are trusted advisors. And there is no gotcha moment, which is put something down so we can come back to you. This was advice that was given to us, not just by the first law firm, by the second, and as with the passage of time, the same advice from the third law firm. So I'm very comfortable with the advice that we've received. It's just unfortunate that Serbia just doesn't see it.
And just finally, you gave a number of answers to questions and you've given the same answers to me, that you got this advice orally and that was good enough for your purposes. Your counsel took you, well, alluded to the fact that there may have been legal advice given in writing that's privileged. And I just wanted to ask, did you have access to that advice at some point? Did you see that advice? Or?
I would have to see what they're referring to specifically, and then I'd be happy to comment.
Okay. But you don't have a recollection of seeing written legal advice?
Well, I'd have to see what they're referring to, and I would refresh my recollection. Like I said, I'd be happy to answer any questions that you may have about that.
Okay, I think that's probably as far as we can go. Thank you very much. It's been very
Thank you
helpful.
very much.
Just a small point of clarification on this document again, so that we are not misunderstanding. I mean, Professor Douglas took you to the GAE Westphalia, where it says Slobodan prepared the legal analysis. Is the Slobodan, I haven't got the record here in front of me, is it Slobodan Petrovic?
No, Slobodan Doklistic. So
Oh,
he
right.
he was at Karanovic Nikolic, and then he went to his old to a new firm, and we went with him there, and then we made a change to Stankovic and Partners.
Right. I thank you. That's helpful
Yeah.
because I see that there is a reference to Slobodan Petrovic earlier up in the
Okay.
in the message. I just want to make sure we didn't misunderstand.
Understand.
I think that concludes the questions from the tribunal, unless so any recross from the respondent, and then we redirect.
No, nothing from us. Thank you.
Okay.
Just one very small point. I'm always fascinated as a continental law lawyer by the concept of consideration. And I remember my first year at Harvard when I was given a book written by the father of my mentor, Arthur van Meren, who basically suggested that it's a loss of time to try to explain it to continental lawyers. But is it usual practice for Canadian lawyers to ask for receipts when they give consideration, nominal consideration?
You know, if you're doing a big transaction, yes, but not. I mean, would it surprise anybody that I didn't ask for a receipt for, you know, for 10 euros of consideration? No.
Thank you.
That's it. Broshko, you thought that you were going to have a short
Yeah.
examination, And I think no doubt Mr. Rand has been wondering what happened to 11:50, which
Yeah.
is come and gone.
Well, I asked Mr. Keller at the break, I said, is this more tiring for me or you?
Well, we take comfort in the fact that you've been there before, so you know exactly what you're
Thank you.
what you're getting into. That concludes your testimony, so I release you from your
Thank you.
statement. I draw 2 points to your attention, but also to everyone in the room for sake of the record. Although it is not set out in sort of precisely these terms, paragraph 2212 of PO1 makes it quite clear that subsequent witnesses of fact shall not be informed about what previous witnesses of fact have said. So for everyone in this room, Mr. Broshko and everyone else, Mr. Rand and Mr. Masevich should not have sight or knowledge of the testimony that has just been given. I understand that you understand that fully. There is nodding in the room for the record. The second point to note is that the schedule has gone out the window. So we, I think, are now an hour 40 late. I think we can say with a fair degree of confidence that Ms. Tomic will not come on this afternoon. And probably that makes sense so that you wouldn't be sequestered overnight. We'll see how we go with the other facts witnesses.
Would you mind if I just had a 30-second conversation?
This is in your capacity as party representative rather than as witness.
We'll be very quick.
So now that council has instructions, anything that you want to say in response to my observation that Ms. Tomic will almost certainly not come on this afternoon. We'll have to wait and see whether there is time following the examination and cross-examination of Mr. Rand, whether Mr. Markisevich will come on this afternoon, and we'll just have to assess that. Any point to make?
We would like, I don't know if it should be on the record or even not, but so the issue is that we believe that because of this 1 hour and 40-minute delay and an additional 1 hour, which will be needed before we start the I would say afternoon session, Mr. Rand may be very tired. We just repeat that he will turn 83 this year, and it has its consequences. Therefore, we would like to explore the possibility whether it would be envisageable to reshuffle the order a little bit so that his testimony starts tomorrow morning. Our experience is that he is much fresher in the morning than in the afternoon.
Well, I will turn to the respondent in just a moment. While there is another fact witness to whom we could come this afternoon, I am not sure that it is consistent with a good order of these proceedings to have an expert witness come before let's put it in these terms without any offense, Mr. Broshko, to the principal fact witness here. I'll hear Respondents' Counsel in just a moment. You can be sure that if we do proceed, as I think it's likely with Mr. Rand this afternoon, we will be attentive to his needs. But
I think, I mean, I would like to consult with council, the council team over lunch over that, but we'll definitely consider it. We'll hear what you're saying. And then we'll
Well, I think if you could consult with council team, also having heard what I've just had to say, but I think it would be helpful if you come back to us before the end of the hour so that we
Of course.
are in a position to reflect on it and to give directions. Yeah.
If I may, I think in practical terms, it also depends on how long we might take with Mr. Markicevic. Because it might also be that we would only be able to finish Mr. Markicevic today, given how much longer we have taken with Mr. Broshko, in which case the issue of having an expert testify before a fact witness would not arise.
Well, let's put that question to Mr. Keller. I think your 95-minute estimates for Mr. Broshko was obviously some of the delay is at the tribunal's instance, but some of it went beyond, your 95 minutes went beyond. How accurate do you think your 85 minutes is for Mr. Markicevic?
So I think on Mr. Broshko, I think we just went over by roughly 10 minutes or so. And I think, I would expect this to be roughly right on Mr. Markicevic as well. Might actually be a bit shorter, you never know, right? But roughly right.
Okay, well, we can be very precise on that because the tribunal secretary has got a record, but no matter. Well, reflect on that, and if you could come back to us actually pretty quickly, once you've had an opportunity to talk to council, and the tribunal will reflect on that as well. And otherwise, we will start again with one witness or the other at 2:30. I should say that if for any reason we are to delay Mr. Rand until tomorrow, and he is due to testify on examination and cross-examination without the tribunal's questions for 105 minutes, that is going to put us into severe difficulty as we go forward. So with that, we are adjourned. Thank you very much, Mr. Broshko, and
Thank you.
appreciating the rigor and the time that you spent. Okay, is everyone ready? Yes, respondent? Yep. Mr. Round, you ready, willing and able? Good. Before, Mr. Round, before I ask you to take the oath, let me just see if there are any housekeeping issues on part of council.
No issues.
No issues from the respondents either. Okay. Mr. Rand, you will very much appreciate that we are running late. You were due to come on according to the schedule at 11:50, so we sort of appreciate that the delay has probably been less than comfortable. You also know how these things work. You've been in that seat before. If at any point you would like a break, do let me know, and we will certainly be accommodating. Now, you should have in front of you an oath for a fact witness. If you could read that in, take the oath, please. Oh, I think we need your microphone on, please. That's it?
Okay.
Yeah. I
solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. Is it Mr. Anway? Your witness.
Thank you, Mr. Chairman. Good afternoon, Mr. Rand.
Good afternoon.
Mr. Rand, you issued 2 witness statements in this arbitration. Do you have them before you?
Yes, I do.
And can you confirm your signature is on both of them?
Yes, I can.
Have you had the opportunity to recently review those witness statements?
Yes, I have.
And do you have any corrections to make to them?
No.
Mr. Rand, can you just explain very briefly to the tribunal why you decided to invest in Omniva in 2005?
Well, I'd been in Belgrade since about 1992, my first visit, and knew the area fairly well. And I have been in the real estate business for a long time, not as my main business, but as an investment process. And I walked around quite a bit, and I saw the proximity of these properties to both the port and the central city of Belgrade. And they were zoned for commercial and residential, which seemed appropriate and sensible, and they looked like well located. And I thought it'd be a good opportunity maybe to see if they were available for sale, and they were.
And how did you come to the understanding that the property at issue was zoned for commercial and residential?
Well, once I saw the properties and I inquired from a lawyer, I had met Mr. Yankovic, who was the previous Minister of Justice, and he had a law firm, and I had met him socially a couple of times, and his law firm gave me the advice about the zoning.
And did you inquire about Omniva's title to its buildings and the land?
Yes, of course, yeah.
And what were you told?
I was told that Omniva owned the buildings, and by virtue of ownership of the buildings, they had the right of use of the land.
And who told you that?
The lawyer at Yankovic's firm.
Mr. Rand, how much did you spend on acquiring the Omniva shares in 2005?
Approximately, exchange rate fluctuated, but approximately 20,000 euros.
Now, Mr. Rand, were you here on Friday during Serbia's opening statement?
Yes.
Do you recall Serbia saying that in 2005, Omniva was leasing its land and its buildings to a company called Leo or Luka Belgrade?
Leasing it from Luka.
Is it your understanding that Omniva was leasing its land and its buildings from anyone in 2005 or thereafter?
No, not at all.
Again, referring to the opening statement you said you were present at on Friday, do you recall Serbia showing in its opening statement certain warehouse servicing agreements and referring to them as lease agreements?
Yes.
And had you seen any of those agreements before this arbitration?
No.
Final topic I'll ask you about from the opening statement is that, let me just ask, did you hear Serbia arguing that in 2008, Omniva was aware that a bus loop was planned at Duvnaska 17 through 19?
I heard them say that, yeah, but what I heard was that it was just a rumor, not a plan.
And when that rumor occurred, do you know if Omniva did anything in response to it?
Yeah, they wrote a letter to the city advising them that it was zoned for commercial residential and they should take that into account.
And are you aware of what the city did with that letter?
I learned subsequently that they had forwarded on to the planning department or the planning agency that was doing the master plan.
And are you aware of what the city told that body in the communication in which it forwarded that letter?
Just that they should take it into consideration.
And did you ever receive any response from the city?
No,
And so what was your conclusion about this rumor?
that it was just that, just a rumor, and that there was no substance to it.
My final question is, Mr. Rand, could you please explain to the tribunal what your role is with respect to Coropi and Kalemegdan?
I'm a director of Coropi. I'm not a director of Kalemegdan, but I would say I am the main voice of Coropi. I control it, so.
In Kalemegdan?
I'm not on the board of Kalemegdan, but since it's owned by Coropi, I would assume I would be able to control it.
And are you involved in the management of either?
No, not at all.
Mr. Chairman, that concludes my questions.
Thank you, Mr. Hamrick. Before I hand the microphone over to counsel for the respondent, could you just identify for me, please, in Mr. Rand's witness statements where he refers to Mr. Jankovic as having advised on these issues? I may have missed it, but it seems to me that this may be new evidence that's been put into the
With
record.
apologies if that was the case, Mr. President. I'm not able to point you to a particular paragraph right now, but happy
Okay.
to withdraw that question.
I do anticipate that that reference to legal advice opens up a line of questions. Thank you. Mr. Keller, is it you again?
It's me again, and actually, I think you preempted a comment of mine. I think it's not only now in the direct of Mr. Rand, but also the direct earlier of Mr. Broshko. I think it seems like claimants.
Sorry, what was
Counsel.
that?
I'm sorry, Mr. Keller, would you like to bring the microphone closer to you?
Yeah,
Because I
sure.
think we're all
Of course.
struggling with it here.
So no, it's not for you, Mr. Rand. It's just I'm addressing the tribunal. I think it's now, but it's also in the direct testimony of Mr. Broshko. It seems claimants counsel elicited quite a number of new facts. So that includes the PwC advice, includes the Jankovic advice, if I noted that. Now there's more. We just want to say clearly for the record, we've noted that. We reserve our rights. We'll take a look and might come back to the tribunal on these points.
That's fine.
But with that, now, hello, Mr. Rand. Good afternoon.
Good afternoon.
Thanks for taking the time to being with us today. So my name is Moritz Keller. I'm part of the council team representing Serbia. I will ask you a few questions about your witness statement. And I also want to echo what the president has said. So if you ever think you need a break from
No, I'm
the
good.
examination,
Thanks.
please let us know, of course, at any time. We're happy to accommodate that. So maybe just establishing the basis for our discussion. So you have submitted these two witness statements that claimants counsel already referred you to.
Yeah.
And I think, everything that's in there, but I'm just double checking that's complete and accurate, right? You stand fully behind these
Yes, I
witness
do,
statements. And then in paragraph 7 of the first witness statement,
Paragraph 7. just
will
a
come
sec.
up on the screen, but please also
Okay.
feel free to use your hard copy, of course. It says where the facts and matters referred to in this witness statement are within my own knowledge, they're true. Where they're not within my own knowledge, they're based upon my review of the documents referred to. And they're true to the best of my knowledge and belief.
That's
I
correct,
assume
yeah.
is still correct.
Yeah, yeah.
So I'm interested into the part which is not within your own knowledge. So the second sentence of that paragraph. So in preparation of the witness statements, I assume you've been assisted by counsel. There's nothing wrong with that. Is that correct?
Yeah, that's what it says, yeah.
Is it the case that at some points claimants counsel refreshed your memories, showed you documents?
Of course, yeah.
Does it include documents that you had not seen previously?
I don't know whether I've seen them or not before. I've seen a lot of documents in the last few days and the last few years, so yeah. I
You
don't know.
can't say, is what you
Can't
say.
say, well, when someone shows me a document, did you see it before? Did you see it yesterday or two? I don't know.
Okay, thank you. No, we'll come back to you. And in terms of some specific documents, maybe that's easier.
Yeah.
Okay, so then in terms of your business, I think you're a lawyer. We've heard about that already earlier today. So you practice corporate and securities law, is that correct?
That's right, until 1992, when I stopped practicing law.
And in addition to that, or after your practice as a lawyer, you're now essentially an investor in several businesses.
Yes,
You're
that's right.
independent businessman.
Yeah.
And that's a variety of sectors, including, I understand, natural resources, oil, real estate. Is that correct?
That's right.
How many investments do you supervise and own?
I don't really supervise any of them really, other than my own real estate that I've got real estate in, student residences back east in Canada and the United States. And my son and son-in-law are basically looking after them to a great extent now, because I don't want to.
Okay, you don't supervise them. I understand that. You don't supervise them all. I understand that, but how many do you own? I mean, how many companies do you own? If you can say,
How
right?
many companies?
Yeah.
A dozen, 15 maybe. I
Okay.
have a number of different companies because usually if I buy like a student residence back east, I'll do a separate company to hold it. And some of them my son runs, some of them my son-in-law runs, and whatever.
So it's 15 companies, but the 15 companies, are these your holding companies, which then hold investments in other companies again in turn?
No, I usually don't do a tree, but normally I'll have a company and that company will run an asset of some kind.
Okay.
And
So
some of them I have partners in, so yeah.
okay, so just to be clear, you say you don't normally have a holding structure where a company would hold a number of different other companies
No,
and
I
again, but you have
Well, other than the ones in Cyprus.
other than the Cyprus companies. Okay. And the others, I think you said, I'm just looking at the transcript, is one asset, one company, essentially. That's normally your approach. Is that right?
I would say one company, one or more assets.
Okay. So in terms of real estate, how many real estate investments do you hold?
You want me to start
A rough number,
naming
just
them off?
an idea.
No, I've got student residences in Barrie, Ontario, Peterborough, Ontario. I own a large tract of land on a lake in Ontario. I have apartment buildings in Seattle. 2 buildings I own myself. One I own with a couple of other people. I have some real estate in Vancouver. I've bought homes for my 2 daughters and my son and whatever.
So I think, I mean, these that you now mentioned, are these in addition to the commercial real estate holdings, or is that everything that you hold in terms of real estate? But maybe let's go on.
You mean everything? I don't
on the
understand
screen
question.
yeah, that's what I said. It might be easier to look at it. So there's an annex to your witness statement, commercial real estate holdings. Can we perhaps pull that up? It's the end of the first statement, if I remember correctly. Yes, this one.
Is it in the back of here?
Yeah, it should be at the back of your first
Yeah, I
witness
got it in front
statement.
of me. Yeah, okay.
Do we have that?
Yeah.
Okay, is that the overview of your real estate
Yep.
investments, or is there more?
Or is it what?
Is that a complete overview of your real estate investment portfolio?
Well, it does include my I don't think it includes my recreational properties, most of which are in the name of my wife. I have a place in Palm Springs, a place in Gulf Islands, etc., that are in my wife's name. So they're probably not here.
So there's more, I understand. It's not a complete list. Is that
Well, it's
correct?
a complete list of what I own, but it doesn't include everything my wife owns.
Okay. That's clear.
I'm sorry, just to be clear, this doesn't include the properties in issue through your indirect holding in Serbia.
No, it doesn't. No.
Thank you. But other than the properties that your wife holds, which may be more private investments, and the properties in Serbia, this is a complete list that we're looking at here?
Yeah.
Okay, thank you. And how do you supervise these properties if you do? When you own, pick an example, you own a significant chunk in a retail shopping mall in, was it Summerland? British Columbia, for example? I mean, how often do you get
The ones in
reports?
Kelowna, you mean in Summerlin?
Yeah, but just an example. I mean,
We
it's a
have
general.
we have an accountant that lives in Kelowna and she looks after them.
Okay, so someone else is doing that for you.
Yep.
Essentially. Okay. And then how often do you see reports from management or from that accountant or updates or any sort of information coming from
I
that?
just get a very brief summary every month of the rent paid and expenses paid and what's left over.
Okay. And you would receive that by email or hard copy mail or
No, email, yeah.
email? Okay, thank you. And then how are these properties doing? I mean, are they doing well overall?
I've had them.
Just a general idea.
Some of them I've had for a long, long time. So yeah, I own them clear title and I get rent and
So no problems there.
there's no problems.
Okay. So in comparison, would you say that Serbia is perhaps your more difficult or the most difficult investment in that sense in the real estate?
Well, I've
front?
never had lawsuits over any others, put it that way.
Yeah.
Or arbitration claims over any other properties I have.
I'll take that as a yes. That it's a difficult one. Thank you. Now let's move on to Serbia then, perhaps.
Okay.
So in paragraph 10 of your first witness statement.
Of my first one,
Yes, your first one. I'll put it to you, but please take a look.
paragraph 10.
Paragraph 10 is you talk about your early day decision to invest in Serbia and then Mr. Obradovic,
Yeah.
who then introduced a couple of projects to you and then some bigger projects didn't work out. And they said, and you might
Yeah.
pursue smaller projects.
Yeah.
That's a take. And then he said, Mr. Obradovic had a pretty good understanding of what's going on there in Serbia.
Yeah.
So then,
Yeah, he was a Canadian that lived in Edmonton for a number of years. So
okay.
Just clarify, he was a Canadian who lived in,
he was both. He was a Serb and a,
so that means that he spoke English.
yes, perfectly. Yeah.
Thank you very much.
Thank you. I mean, I assume that Mr. Bradovic was a person you trusted because then you started taking up a business relationship with
I
him.
guess
I think.
originally I did. Yes.
Yes. And he testified as a witness in the last arbitration, correct?
Yes.
He's not testifying here, I think. We understand from what we heard earlier today that there was a bit of a falling out with him. Is that correct?
Yes.
Could you explain why you're not working with him anymore?
Yeah, he stole some money from me. So
He stole money
and
from
he
you.
got charged criminally, and to tell you the truth, I don't know what happened, but I know he was charged. And
So, and when did that happen?
2, 3, 4 years ago, I think. I'm not, maybe longer ago. I'm not sure. Happened some time ago, anyway.
So was it before the first case or before? We know there was another arbitration, right? I mean, I think with a hearing in, I want to say 21, but
Yeah.
was it before or after that testimony?
Yeah, it was before that, but he wasn't really. I don't think he was really charged then. But I had my suspicions about him. But I don't know exactly when he was actually charged.
Thank you. And then when did you stop working with him? And in fact,
Oh, I actually haven't had nothing much to do with him after the last arbitration.
okay. Could it have been at the end of 2023?
But before that, I would say.
Before that?
Yeah.
But he was still the owner of Kalemegdan until the end of 2023, is that correct?
I'm not sure. I know at some stage he was asked to transfer his shares to the other company or get them out of his name, and it
But-
happened right away.
Thank you, but you don't recall when that was specifically?
Not exactly, no.
Okay. Well, we might come back to that, but I want to move on to a different topic now. I think, I mean, we established you're a very experienced lawyer and business person. We have a lot of investments, of course. I assume you would agree with me that before doing an investment, you would do a due diligence into whatever the target company or target asset is.
To some extent, yeah. Some types of investment more than others, but generally, yes.
So, and if you would buy shares in a company, say, you would check at least, well, whether there's some, I don't know, bankruptcy issues, whether what the assets of the companies are, these types of issues.
Right? Say that again, bankruptcy.
Bankruptcy issues, yeah, I mean, it might be close to the brink of bankruptcy, just picking an example here. You might want to check whether they actually own the assets. You might want to check who's the management.
Yeah, I guess there's a difference between buying a private company or a company on the stock exchange. You buy stock on the stock exchange, you can read a couple of reports and, you know, buy it or not buy it. If you're going to buy a private company, then yeah, you have to be more careful and do a little more due diligence and find out more about it. But usually it's fairly straightforward. Sometimes it's a little more complicated, like in Serbia.
And then to what extent are you typically involved in that kind of transaction yourself, right? I mean, and you feel free to distinguish perhaps between now and 10 years ago, right? I mean, if you were to consider an investment, would you handle that kind of thing yourself? So would you say, well, I need to instruct, I don't know, financial advisors, lawyers, I need to think about this and that, or would it be someone is doing that for you typically?
Depending what I'm buying. What do you mean if I'm buying a company or buying a piece of real estate with no housing or buildings on it, or
a company?
Well, what does the company own? That's all you want to find out. Like, is it an asset that's complicated? If it's a raw piece of land, then you can make a pretty easy assumption. If it's an apartment building, you can do the calculations. And if it's something more complicated, then you have to do more work.
So my question was slightly different. I mean, I don't know whether you would handle that yourself or whether you would have someone handle that kind of transaction for you.
Well, it depends. I mean, if I get a financial statement, I'll read it myself. But if I have to put together a financial document, I'll get someone else to do it for me, and I'll look at the summary. I mean, I don't have time to spend weeks and weeks and weeks looking at a project. I don't have the patience for it. So.
Okay, so I understand what you're saying is that if it's relatively easy, a smaller transaction, you might just do it yourself, and if not, you would get some support for that.
And a lot of my real estate, I have partners that will do a lot of the work for me, and like some of the real estate I own in student residence and stuff, is I have two partners, and one of them has a full-time job managing it. So
okay. So then you would rely on your partners handling that, including the due diligence and all that. Okay, no, that's very clear. Now let's move closer to the subject matter of this dispute, perhaps. So we're talking Obnova, and I think now you said when you were first, well, it wasn't entirely clear, but when you were first visiting Serbia, you did walk around the area a lot, and you seemed to like it, and that was because you saw potential there, and that's why you decided to invest there.
Yeah, I had a lot of trips there. I bought an apartment there, so I knew the area well, and I walked all around the city all the time. I'd get up in the morning and go jogging all up and down the waterfront and in and around the old fort.
So there was your idea to buy that particular area, the company that you thought might own the land, or was it suggested to you by someone?
Well, I was told at some stage that it was available for sale. So I knew the general area, and then when I was told it might be for sale, I went and looked at it more closely.
And who told you it was up for sale?
Probably Mr. Obradovic.
Mr. Obradovic. And did Mr. Obradovic then also do the kind of the setup of the deal for you at the time?
Did he? Sorry,
Did he? I mean, as we just talked about it, if it's an easy transaction, you might do things yourself, but if it's more complicated, you might have someone assist you. So I'm asking whether Mr. Obradovic then did organize the transaction for you, or how did it go about essentially in practice?
I would have talked to a lawyer for sure, and had the lawyer make some inquiries about whether there was any issues with the property, what the zoning was the zoning okay, what was the plan that the city had with respect to the property, etc. But I would have gone not through Mr. Obradovich, I would have gone through a lawyer to find that out.
Okay, maybe let's take this step by step. I mean, there was no Mr. Broshko back at the time, right?
Not at that time, no.
So it was you directly dealing with Mr. Obradovich, is that correct?
Yes, that's right. Yeah.
And then I think you just said I would have talked to a lawyer.
Yeah.
You would have made some inquiries. So did you make some inquiries? Did
Yes,
you
of
go to a
course.
lawyer
Yes.
in this?
Yes, I did. Yeah.
And this is the Mr. Yankovic we heard about earlier, is it?
Well, I knew Mr. Yankovic and we had been a number of dinners, but it was other juniors in his firm that I talked to and did the bulk of the work or the research to find the details. He was
And-
ex-minister of justice. He was the head of the firm, but I don't know.
And Mr.
hard
Yankovic
it
was then
worked.
doing the due diligence for you? Is that what
Pardon?
happened? Mr. Yankovic was, or his law firm, were then doing the due diligence for you?
Yes.
Is that what you're saying?
Yeah.
And is there any written documentation of that due diligence?
I mean, did he write a written report on the status of the properties? No.
Could be anything. Could be an email reporting to you saying, I've looked into
I
this.
think it was
This is the situation.
mainly conversations.
Conversations.
I'd go there, I'd meet with them, talk to me, and
You didn't receive any legal opinion,
No.
correspondence, could even have been hard copy. We're talking 2005,
No.
right? No.
Excuse me, Mr. Mr. Rand, may we know which Mr. Yankovic this is, because there are lots of Mr. Yankovic's in Serbia, just so that we do know which one he is. What's his first name?
just I can't remember his first name. He was the ex-minister of justice in the Milosevic government.
Thank you very much.
But I knew his first name at one time, but I don't remember.
Thank you. I don't hold that against you, just wondering. Thank you.
So there was no written advice, but did they provide any documents to you? Like not advice produced by that law firm or by that lawyer, but documents from authorities, I don't know, land maps, anything? Was there any documentation that was shared with you?
Not in English anyway, put it that way.
But do you remember that there was any documentation shared with you at the time?
Not shared with me, no. If it
No.
was in Serbian, they wouldn't have bothered showing it to me, but
Well, they could have translated it to English.
they could have, but they didn't.
Okay, so no documentation. In addition to Mr. Yankovic, is there any other inquiries that you did undertake, or is it essentially it was him?
Well, I talked to, Obradovich, what he thought about the area, what he thought about the city, where the city was going. I read a lot of articles about Serbia, whether it was, I always thought at that time that Serbia would be joining the EU at some stage, although I must admit I wasn't correct in that assumption, but I was fairly convinced that Serbia wanted to become sort of more westernized and would eventually join the EU. And, it hasn't happened, but it's the way it is.
And can I just ask you head on? Why didn't you mention any of this in both your witness statements?
I didn't think it important, but you're asking the question, so I'm answering your questions.
You didn't think it was important whether you conducted due diligence, or you didn't think it was important that you received legal advice on the properties?
No. When you buy something, you buy a house, do you make a report that you got a report from this lawyer and that lawyer about the house? No, you say, I tell your neighbor you bought a house.
Well, actually, I do. I do receive written documentation. I receive my correspondence by email and hard copy, and I tend to keep them if I buy real estate,
Yeah.
which I do.
And these days, back in '92, I didn't have email and all that stuff.
Yeah, just to be clear, we're talking about 2005 now, right?
Yeah. I can't remember when emails got to be extremely common. Probably by then it was, but still it was 20 years ago.
Okay. Do you recall what Mr. Yankovic told you? What was the status of the company, Obnova? Anything?
It was basically just about the zoning of the Obnova property.
But you were buying a company, not real estate, right? You were buying Obnova. You were not buying the land.
the asset was property.
Okay, but
There was no other asset, so that's the only thing I was interested in.
was the company still operating at the time?
Yes,
Did it have employees?
yes,
Did it have accounts?
yeah, sort of. Yeah, it was
Was
a sloppy little business, put it this way. It was a scrap metal business. It wasn't making any money. They made enough money to pay themselves. And
But what was the information that was provided to you on these points about the business, turnover, employees, debtors, creditors?
I didn't get a report on the active business. I went there and saw them, collecting scrap metal and putting it into little squeezed packages and selling it to the the government-owned company called Zelvaz, and we supplied them with a lot of scrap metal, and then they didn't pay us for it.
Okay,
And so they ended up owing us 200,000 euro and not paying us. And then even though it was owned by the government, it went broke and closed up. And
but that's
I never
past
got paid.
acquisition now, what you're talking about, right? That's past acquisition, what you're now talking about, the government company not paying its invoices.
Yeah,
So that's past. I asked what kind of information was provided to you when you were buying the business.
when I bought Omniba,
Yes,
they didn't even have a set of accounts.
they didn't even have
But
accounts.
I was interested in the real estate aspect of it, not particularly the business. The business was a shitty little business, to put it.
But how did you know that they didn't have accounts? I mean, who checked that for you?
Pardon?
You said they didn't even have accounts, but who checked that for you?
Who checked it for me?
Yeah, I mean, someone must have gone and checked whether there are accounts, looked at the archives. I don't know. I mean, I'm asking you.
And I think, no, I never saw a financial statement that they produced. They didn't seem to produce anything. I think the employees were running it to feed themselves, to tell you the truth.
Okay. And in terms of the real estate, you said you were told about the plan. Were you told about the construction permits of the company?
Construction permits, I was told about the zoning and about the ownership, and that they own the buildings, and that they had the right to the use of the land, and that they built the buildings like in the 50s or whatever, and they continually occupied the buildings, and as far as I was concerned, they owned the buildings.
Okay, so but no one showed you or discussed with you construction permits or the lack of construction permits?
No, I don't recall discussing construction permits at that time.
Did anyone mention to you that they're not registered as the owners of anything really?
I don't think I think the registry system then was very incomplete. I was told at that
I'll
time
take
it
that,
was-
but that's not the question. Did anyone mention to you at the time, Jankovic or otherwise, whether they were not registered as the owners? Obnova was not registered as the owners of the land, the objects, anything.
I don't recall.
Were you advised about any risks around your acquisition?
Advised of any risks? Yeah, I don't know if I was advised of any risk. I mean, you buy anything in life, there's a degree of risk. So
Well, let's make it clear. I mean, you're going to buy a company. Apparently, you didn't know whether they have construction permits. I'm not sure whether you knew whether they were inscribed into the land register or not. So there's some uncertainties. Would you agree?
yeah, but if you buy a house, do you go back and find out when the guy that built the house that's selling it to you, did he get a construction permit to build a house? No, you don't ask that. You say, did you own the house? Yeah. Did you build the house? Yeah. Okay, thank you. You don't go back and say, well, where's your construction permit?
No, I think I would look at the land register, to be quite honest with you, and then I would get my answer. But since they were not inscribed into the land register here, I mean, is that something that you were told by Mr. Jankovic or Mr. Obradovic or otherwise?
Was what something I was told?
That they were not registered as the owners or as the owner of a right to use.
Right. I knew the land registry was, apparently there was 2 million properties in Serbia that had not been registered in the land registry. So the fact that it wasn't registered did not seem to be a particular concern.
Let's perhaps take a look at the document from the time, which is document exhibit R46. That's a privatization program in relation to Obnova, and then you'll see the translation, of course. You have a screen in front of you, that's easier
Okay.
perhaps. But I mean, before we go anywhere, I'm just asking, do you know that document? Have you ever seen that document? So that's the privatization program for Obnova. And you can scroll down, it's of course, the original is in Serbian. I'm not sure how.
I don't think it was translated then, so if I saw it, it wouldn't have meant anything to me.
But do you recall seeing this document at any time?
No, if it's in Serbian, they wouldn't bother showing it to me.
Okay, so we haven't seen that, but then I think, I mean, I would not want to ask you about any of the details in there. Does anyone brief you on the document?
I would have had a lot of discussions about it. Yeah, I'm sure.
What kind of discussions? What did people tell you about the document? Do you recall anything?
I recall it today, exactly what was said, no. But I know we discussed the privatization and I'd bought other assets in the privatization process, so I roughly knew the procedure anyway, so.
And when you say we discussed the privatization, who would that be?
Say it
You
again?
said we discussed the privatization just a minute ago. So who
I would
is
have
we
talked-
in this?
I would have talked to the lawyers and I would have talked to George Abradovich and, and
Okay,
but
but
I had a number of dinners with people that were in business in Serbia, and you talk about it, and they all knew I was a foreigner, and so I'd have dinner with other Serbian businessmen, and we'd chit chat and talk, and I'd ask questions, and you just sort of find stuff out in the course of these discussions.
okay, but I mean, about this specific privatization document in relation to Obnova, I mean, do you recall any discussion?
I would have been told about the process, but I wouldn't have read anything because it was in Serbian, so I wouldn't have seen anything. I had to rely on people telling me what was in the document.
And who would look at that document for you, if anyone? Would that be Mr. Obradovic?
Mainly Mr. Obradovic, yeah.
Okay. Thank you, Mr. Rand. Maybe just to stay on your initial due diligence and the initial acquisition. I mean, did anyone tell you at the time that there were registrations for these land plots, but not in Obnova's name?
You mean registrations in a land registry? You mean?
Yes.
And what's the question?
Well, we talked about earlier, you said you were not concerned by the fact that Obnova was not registered. I think
Yes.
that's what you
Yeah.
said, right? So did anyone tell you it's not only that Obnova was not registered, but that everything was registered in a different name? Were you informed about this?
Everything was registered in a different name?
Yeah, for a different owner.
I don't understand that.
Well, there was an entry in the land registry. It was just not in the name of Obnova. Is that something you were informed about?
No.
No.
An entry about what?
Well, the ownership.
Of this particular property?
Yeah.
No,
You were not informed about that?
no.
Okay. Let's go to your second witness statement, please.
Okay.
I think that's paragraph 12.
Okay, I've got it in front of me.
Were you referring to a letter sent by a Mr. Golubovic? Probably mispronouncing that.
Golubovic.
Yeah. And that's also referenced in the footnote number 8, I think, if I'm not mistaken. And that letter, you say, according to your clear recollection, attach documents to it, and that it includes a historical lease agreement with the city of Belgrade from the 1950s. That's all in your paragraph 12 of your witness statement. That's correct, right?
Yeah, no, that's what I was told. As I said, it was all in Serbian, so I wouldn't have been able to review it and say, yes, this is what it says, but this is what I was told, yes.
And you say, my clear recollection is that the letter showed and so forth.
Yeah.
And attached documents. So you specifically recall that particular letter from 2008? Or is it something where documents were shown to you to refresh your memory?
No, I mean, at the time, I was told what the letter said and what it included, and that's all I knew.
And
at the
who
time.
would have told you about this? Who would have briefed you about the letter and its content?
Probably Mr. Obradovic or maybe one of the lawyers at Yankovic's firm. I can't recall particularly.
They would have sent you an email, or how would they have done
Would
that?
have been by email.
Sorry, I didn't get that. What did you say?
Pardon?
Can you speak up a bit? I didn't get your
Oh,
answer.
sorry. So what were you ask again, and I'll try and answer it again.
The question is, first question was, who told you about it? And you said it was Mr. Obradovic or perhaps one of the lawyers. And I asked you how would he or how would they have informed you about it? Was it be by
Just
email?
verbally. No, just verbally.
So you wouldn't have seen the letter?
No,
You wouldn't have seen the attachments?
no, they were in Serbian. They wouldn't bother showing them to me, I'm sure.
Okay. And was it the general modus operandi? So they would not translate documents for you and would not send you draft documents? Is that correct?
No, I wouldn't. There was, in all these properties, there was reams of paper. No, I wouldn't get them translated, no.
Okay, thank you. So this is talking about one lease agreement. And you said, I mean, it would be Serbian, so you wouldn't have seen it, but you knew it existed, this lease agreement.
I knew, sorry, what that the letter existed?
No, that the lease agreement existed, which was attached to the letter.
And the attached documents confirm including their historical lease agreement. Right.
Between which parties was this lease agreement?
It was, I guess, a lease agreement with the city of Belgrade.
And when did you learn about this lease agreement?
When did I, sorry?
When did you learn about this lease agreement?
Sometime during the course of the conversations with Mr. Glibovich, Mr. Obradovic, I don't know exactly when. I can't say when exactly.
So this letter is 2008, but I mean, your acquisition was 2005. Is that something you knew when you were buying the company? Is it something that came up in later discussions?
I don't know. When I bought it, at the time I bought Obnova, I made inquiries. I knew they were using the premises, that they built the premises. They had them since the 50s. They weren't paying rent to anybody, and they occupied them and they built them, and I assumed therefore that they owned them.
I'm not sure you answered the question. I mean, when did you learn about the lease agreement? Was it in the context of the acquisition, before acquisition?
When did I learn about
the lease agreement? We're still on the lease agreement. When
the
did
lease
you?
agreement, the one back in the 50s, you mean?
Yeah, that's the one.
I probably had some reference to it, but it was irrelevant. By the time I bought it, it was what happened in the 50s was.
Sorry, that was not the question. The question is, when did you learn about the existence of the lease agreement? It's not about whether you think it's irrelevant or not.
I mean, when did I learn about there was a lease agreement in the 50s?
Yes?
I have no idea. Sometime in the course of talking about it, it might have come up in conversation, but it's not anything that would have stuck in my mind because it was no longer relevant. So I wouldn't have thought much about it.
So I'm just reading the various answers here. So just to make sure that we get this right. So you say you can't recall whether you learned about it before acquisition or after acquisition of Obnova?
Sorry, say that question again.
You don't recall whether you learned about the lease agreement before or after the acquisition of Obnova?
Yeah, I'm not sure. I would have hoped I found out about it before, but maybe I didn't. I'm not sure.
And just a minute ago, you said, I mean, there was a conversation and someone told you it's no longer relevant. So when was that?
When?
Yeah.
Probably around the time I bought it.
Mhm. But do you recall?
No.
I mean, you probably know from council there's a discussion in this case, and claimants council asked you about that earlier, about a number of lease agreements that were entered into even after this one.
Yeah.
From 1959, from 60, from 2003, 2006. Have you seen any of these agreements?
I've seen them in the last few days, but not previously.
No one has ever told you about these lease agreements.
No.
Okay. So let's move on to another topic then. And if we could perhaps see on the screen exhibit C337. So that's an email, if you can see that properly. It's an email chain between you, Mr. Broshko, and Mr. Makicevic. And it's dated September 7, 2014. Can you see
Okay.
that?
I see it, yeah.
And if you can perhaps scroll down there, there's a section discussing the Obnova investment called Obnova Property Registration. Can you see that?
Right.
And there was an email sent to you by Mr. Broshko.
Yeah.
And is it a typical kind of update or report that you would receive from Mr. Broshko?
I assume so.
How often would you receive these updates from Mr. Broshko?
I would have talked to Erinn like number of times a week, like a lot. We were in relatively constant contact. You know, the emails, every now and then there was something he wanted me to remember or focus on, he'd do an email, but a lot of it was already been dealt with in discussions. And but he was pretty good at, you know, putting things down in writing and sending me things like this to get it on the record. But we probably would have discussed it in advance, and I'd see that and I'd look at it quickly and move on. I'm afraid I'm not that detailed in a lot of things. So.
Okay, so is it regular updates by phone? We would speak to Mr. Broshko frequently, and then occasionally when you would get updates on significant issues in the form that we see, here.
Yeah.
Would he send you documents as well, like, I don't know, draft contracts, draft letters, this sort of thing?
No.
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 Would he send you also significant letters received, like, I don't know, a letter from an authority or a letter from a court or a letter from an angry contractual counterparty? I don't know, these sort of things.
Not. I mean, he lived there for several months and was dealing with things every day. I'd talk to him, I don't know, maybe once a week or once every 2 weeks. And I had full faith that he was able to look after things adequately without my constant oversight.
Okay. So then let's go back to the actual document in front of us. So that's, as I said, this is an email from Mr. Broshko, including you, both you and Mr. Markicevic. It's September 7, 2014. And you see on the screen now an update on the Obnova situation. Let me put it like that. Want to discuss with you first the second paragraph, which says other parcels. Which said there are no building permits for the buildings on other location. Has been a practice for decades to build without permits, so there are many illegal buildings. So at that point in time, and this is of course long after your acquisition now, you were informed that a number of these buildings did not have a construction permit. Is that correct?
I probably was, but do I recall the conversations? No.
Okay. If we then move up to the paragraph above, please. Starting with large parcel, and then we said we have building permits for this parcel, apparently for all buildings, and they say which is sufficient to register the ownership. The land is owned by the city of Belgrade. So again, I mean, at some point you must have been informed, of course, at the very latest with this email, that the land is owned, inscribed to the city of Belgrade.
But I've occupied the buildings and had the right to use them, etc.
Well, that was not the question. So you were informed that the land is actually inscribed to the city of Belgrade at some point.
Probably. Do I recall specifically at that time? No, I don't.
And were you aware that the lack of registration of rights of Obnova and the registration of the city would cause some issues for you?
Well, I knew there was a lot of issues with the land registry system, that they'd adopted the system relatively recently. There was millions of properties in the country that weren't registered, so the land registry was a bit of a mess.
But did you consider that you might have to go to court about it, or that there's something else that you want to do to resolve the situation?
I think it was a function of just, explaining things, getting a lawyer to submit, the correct documents, show your ownership, show what you've done, and hopefully sometime in the next 2 or 3 or 4 years, they might get around to, because they were very, very backlogged. So when you introduce a new registration system, you got a whole country where you're trying to register land. It's not that simple, and it's not going to happen that fast, and they're going to make a lot of mistakes.
And you think, I mean, function of explaining things, getting a lawyer to submit the documents. I mean, who told you that? I mean,
who told me?
Who told you that it's just a function of explaining things, submitting a couple of documents, and then things will be resolved?
Probably Erinn, Broshko.
And were you involved at this time? So again, we're talking 2014. So you've been an owner of the company now for 9 years. About the correspondence with authorities, court proceedings, and the like? Do you know anything about that?
Not really. I mean, yeah, we'd have discussions about things sort of on a regular basis, but he wouldn't get into anything unless it was sort of relatively crucial or important. Or
so you were not.
I'm not sure. So I'm not sure whether a specific issue was discussed. I can't say.
We were not informed about attempts to inscribe Obnova, court proceedings, correspondence with the authorities? You were not briefed about this?
Probably not.
Okay. Yeah, let's maybe take a look. No, before we do that, let's stay for a moment on this document, actually. So we'll be staying on the first paragraph that you can see on the screen here. So the one that starts with large parcel.
Yeah.
And if we go to the bottom of that.
Yeah, other parcels?
There's the bottom of that same paragraph. So in the middle it starts, I'll read it out to you, but so that you can follow. Obnova has a number of ongoing lawsuits with the creditors from the previous years. Most of them sooner or later end up in an attempt of foreclosure. I mean, the creditors realize that there's no registered property, they give up and stay in line of the blocked account. We could submit papers to register ownership, but there would be a significant risk that someone initiates a foreclosure as soon as the property is
Okay,
registered.
just let me read it because
Yes,
it was
please.
in dark and I couldn't read it.
Please
Observe
do.
has a number of ongoing lawsuits with the creditors for the previous years. Creditors. I don't. I read what it says. Did that ever be brought to my attention? No, I don't think so. I never recall all this stuff before, previously.
I take that, Mr. Rand, but just to remind you, there's an email that has been sent to you
Yeah.
to brief you.
Do I remember any of this stuff? No.
And for me,
Did
when
I
I
read it all? Probably, but
would you agree with me that it sounds like that a driver of some strategy might have been not to register ownership to avoid the creditors?
the practice for decades to build. So where you where are you referring to? What are you asking?
Again, same paragraph highlighted there. It says, when the creditors realize that there's no registered property, they give up. And then the next sentence reads, we could submit papers to register ownership, but there would be a significant risk that someone initiates a foreclosure as soon as the property is registered.
I don't recall.
You don't recall that?
I don't recall this stuff.
Okay. And again, when we're talking 2014, right? So you've owned the company for 9 years now.
Yeah.
You said you were not informed about any attempts, court proceedings to register and all of that. Do you recall any decision to actively pursue a proper registration to get the rights that you think that the company had registered and confirmed?
Me personally, no. I was relying on Erinn to look after it, tidy up the title, hire whatever lawyers he needed to fix it, and I was always optimistic that eventually it would all get sorted out, and that Obnova would end up owning the property without any issues.
And what was this optimism based on? And did you see any documents showing that Obnova had the right to use? Did you see anything?
Well, they built them. They'd occupied them for 50, 60 years. I think it's fair
So
to say that.
The question is, have you seen
they
any
weren't- they-
documents? Anything, any evidence of a right to use?
Probably not, no.
Thank you. Let's take a look at another document.
I may-
Sorry, before you move to that, sorry, I was going to just ask a clarificatory question. Mr. Rand, I just want to be sure that I'm sort of absolutely clear about a couple of things. First of all, if your counsel can scroll to the top of the page of this document, please. This is your email address, and it would have come to you personally.
Yes, for sure.
And so your testimony, I think a moment ago, was that you don't recall the detail, but you would have read it.
Yes.
I just want to establish that this is not an email that would have gone to a PA or something like that. It would have come to you directly.
Yes, it would have come to me directly. Yeah, for sure.
And the second thing is that both in terms of the title, but also in terms of the first line, where Mr. Broshko says, Bill, please see below our update. Please confirm that we have a Skype call at 9 a.m. Vancouver time tomorrow.
Yeah.
Would it normally have been the case that before a Skype call, you would have got an update like this, and this update sort of sets the agenda for the Skype call? Or would there not necessarily have been a correlation between the Skype call that followed and this update? And the Skype call might have been about something entirely different. So just to sort of to encapsulate it rather more clearly, I'm trying to establish whether an email like this would typically have come to you, set the agenda for the call, and then there would have been a call afterwards.
I think that makes, yeah, I would agree with that.
So this would be the normal
This would be-
practice.
Here's some information, we'll talk about it tomorrow, type of thing.
Okay, thank you very much. Counsel for
Yes, I was going to suggest that we've been going for an hour and it might be.
I'm going to leave
appropriate
that
have a
to Mr. Rand to draw attention rather than to council. Mr. Rand, you have my invitation at the beginning. If you need a break, you
No,
will
I
tell
don't
us.
need a break. No, I'm good.
Thank you very
Good,
much.
thanks.
But I am going to leave it to Mr. Rand, the witness.
Thank you, Mr. President. Yes, I wanted to take a look at a different document. So can we pull up R20, please? So, Mr. Rademan, first thing is would really, again, just to see whether you actually know this document and can tell us about anything about it. So this is a court judgment, the translation. We can also show you the Serbian version, of course. It's dated 23 April 2012 at the left top-hand side, yes. And it's a court proceeding between Luka, Belgrade, and Obnova. Have you seen this document?
It doesn't matter. Motion for enforcement on the basis of credible instructions with request for receiving, that's a confusing.
It's a
heading.
translation. But have you seen this before?
Not that I recall.
Okay. Maybe can we scroll down to the Serbian version just for, sometimes it's also the way a document looks. So this is how the document would look like.
Mr. Keller, I'm assuming that if Mr. Rand says that he can't read Serbian, and these documents may look very much
No,
the
it's just, I
same,
mean, sometimes when you see a document, how it looks, it might trigger something. But I mean, as I said, if you don't know it, then please
I
just.
have no idea.
Okay. Are you familiar with the court proceedings between Luka Belgrade and Obnova? Someone briefed you about them then?
I assume I would have been informed about it. And
But do you recall anything? Does it
not,
ring a bell?
do I recall? No, not really. To be
Okay.
honest.
Okay. Let's move on to something else then, if you don't have any knowledge about the court proceedings. And that's the 2013 DRP.
Okay.
I think you mentioned your witness statement. Maybe let's pull it up so that we have that.
This is
I think it's the first one.
is my July witness statement.
The first one, I think it's February, right?
Okay.
And I think it's paragraph number 51.
51.
Yes, it will come up on the screen as well. Where you address the 2013 DRP.
Yeah. I do not recall how exactly I was informed. Yeah.
Do you remember when that was? Any idea, rough idea?
I assume it was in 2014. I assume because in December they adopted it, and sometime after that they would have called me and told me about it. Because
Okay.
I don't know, it was around Christmas time or early December. I have no idea.
Okay, can we go back to 3337 then, please? The same email that we've been looking at for a while. So again, this one is September 2014. It's a Serbian update email, and it has an update section on Obnova, which we can look at again. It doesn't mention the 2013 DRP. Can you tell us why you were not informed about this at the time, or?
Sorry, so just let me look at it. We have a building permit. The land is owned. The number of ongoing lawsuits. Blah, blah, blah. There are no building permits for the building. It's been a practice. So what's the question?
Mr.
again?
Chairman, I apologize, but I'm going to object against this question. This is a document which clearly was not authored by Mr. Rand. Therefore, the question why.
I'm going to stop you, Mr. Bakash. I mean, Mr. Rand is capable of actually giving that answer, so I'd rather let him give that answer.
So what's the, sorry, I've lost what the.
Well,
train of thought.
let's go back to context again. So this email is September 7, 2014. The 2013 DRP was, as you rightly
I'd
said.
like to make it clear who it is from and to whom. So
Well, I just wanted to start with time first. So this is September 2014, this email. The 2013 DRP, as we just discussed, as you just mentioned, was issued in December 2013. This email, maybe if we could go up again just to make sure that Mr. Rand is aware of this. So this is an email from Mr. Broshko to you, Mr. Rand, and it's copying Mr. Markicevic. If we can now go back to the Obnova status update. My question was, it doesn't mention the 2013 DRP, although it had already been issued for quite some time. Can you explain to us why that is?
Sorry, I don't quite understand the question again. Sorry. Why?
Perhaps I could rephrase the
Sure.
question, Mr. Rand, for you. I think council is trying to establish whether you have a view on why Mr. Broshko would not have drawn to your attention the December 2013 DRP when he wrote to you in September 2014, 9 months later. I think that's the essence of Mr. Keller's question.
Like, why was he so late in sending the email, you mean? I'm not sure.
Why there is an apparent inconsistency between the email, which says Obnova has a right to use the land,
Yeah.
and the 2013 DRP, in which there is evidence that says it indicated that Obnova did not have a right to use the land. So counsel for the respondent is just trying to establish whether you have a view on why Mr. Broshko did not refer to the DRP when he wrote to you 9 months later.
I have no idea. I can't. Do I recall? No, I don't recall the time difference between the emails and the calls. I just don't recall.
Thank you.
I mean, I talk to Mr. Broshko regularly, so I'm sure I would have been kept relatively up to date on information. And
Mr. Keller, sorry to intrude into your examination, but I presume that's the question you were trying to ask and trying to get a response to.
Thank you, Mr. President. No, I'll follow up on that. So in the relevant part of your witness statement, it's the paragraph 51 that we just looked at. You say,
sorry, 51.
yes,
Yeah.
where you say you do not recall how exactly you were informed.
Yeah.
So you do not know when that call or whatever happened to take place, but even afterwards, did you receive any briefing in writing on the 2013 DRP and its consequences, legal analysis, financial impact, anything of that sort? You do not mention anything.
Not that I recall. If someone showed me and said, here it is, you should have seen it, maybe I did, but I don't recall anything like that.
But the 2013 DRP, I mean, has been described in these proceedings as a shock. I think you say it's a big surprise.
Yeah.
And I think essentially your case, your side's case is that this is a significant event for the investment, right?
Yeah, it didn't make any sense to me because they had the bus loop across the street. They had their bus infrastructure across the street. And I have my property on the other across the street that's zoned commercial. And they didn't need it for their bus loop or their bus facilities because they already had them on the other side of the street.
And
So
who
it didn't
provided you with that analysis? I mean, who briefed you?
Who briefed me?
Yeah, I mean, the analysis that you just described, I mean, someone must have looked at the documents, done an analysis for you.
That would have been Erinn, for sure, yeah.
Okay. But we haven't seen any email, hard copy document, anything of that sort.
You probably just did it by phone anyway, yeah, I assume.
And did you obtain any
I did.
legal advice around this?
No, I would have relied on Mr. Broshko's information. Whether he got legal information, I don't know.
But would he have obtained the legal advice on behalf of you? Is it something you would have expected him to do in relation to the 2013 DRP?
I don't know. He's a lawyer. He would figure out whether he needed to get some other legal advice about the issue or not. I assume if he felt it was important, he would have gotten legal advice. We had lawyers he could talk to. So whether he had to or not, he would have figured that out. I wasn't going to query him. If he told me something, I assume he knew what he was talking about, and I didn't ask him, oh, did you get a legal advice on this? And did you talk to this guy? Did you talk to that guy? If he said, this is what happened and this is what's going to happen, or this is what we're looking at, I'd say, good, thanks.
Okay, but you were not aware of any written legal opinion or legal analysis.
No, I wasn't
Okay.
aware at all.
Okay.
I'm not saying there wasn't any, I just wasn't aware of it.
Okay, let's go back to, we're staying on the same topic, but let's go back a few years. And I would like to see on the screen Exhibit C314. So this is a document from March 27, 2008. It's a translation, of course, again. I'm very happy to show you the Serbian version as well. It's addressed to the city of Belgrade, and it's a document from Obnova, submitted by Obnova, as you can see, and it's by Mr. Nebojša Golubovic. Do you know that letter?
Well, I've seen it with respect to this arbitration. I've seen it. I don't know if I saw it at the time. I don't recall, but I've certainly seen it here. So
You don't know whether you've seen it in 2008 at the time?
I don't know if I saw it then or not. No, I don't know. I don't even know. Was it translated back then? I'm not sure.
And would someone have briefed you about this? Not about the letter specifically, but about the issue, the plan that was being considered here?
I'm sure Erinn Broshko would have briefed me on it, sure. But do I recall a specific conversation where he briefed me? No, I don't.
Just to remind you that this is 2008 now. My understanding that with Mr. Broshko was only picking up work for you in 2012.
That he was only...
Starting working for you in 2012. So this is 2008, what we're looking at here.
Okay, so it's before his time. Yeah, that's right.
Okay, but you don't have any recollection?
No.
On the underlying issue, the letter?
No.
So just 1 second.
Mr. Globovich probably would have brought it to my attention, I'm sure.
I think when you testified earlier, when asked by claimant's counsel, that you were aware that this letter, which is Obnova raising the issue that Obnova thought the bus loop should not be put at that particular location, was to be considered by the city. Is that correct? So that you do recall?
Pardon?
That you do recall? Because you just said you don't have any recollection, but that there was some, let's say, a signal from the city that they would consider that you recall?
Yep, there was a rumor about it, yeah.
And that rumor, to use that term, I mean, who told you about that?
About the rumor?
Yeah.
Probably Mr. Obradovich or Mr. Glubovich.
Okay.
I'm not sure.
And I think we've seen in this arbitration, I mean, you could say the 2013 DRP, one of the versions we've heard from claimants is that the 2013 DRP is the reason for this arbitration. So it seems like a very significant issue for Obnova, right?
Yes.
So did you follow up afterwards just to find out where the plan and planning process stood, or whether there was any progress, or whether there was any change of plans or not?
I'm sure we had discussions about it, yes, but do I recall any specific discussions? No.
And when you say we, who is we in
It
this?
would have been Mr. Obradovich or the lawyers at Yankovic's firm, one or the other.
But do you recall any follow-up, any correspondence reaching out to the city? Any update on that?
No, I can't really recall, no.
Did you instruct anyone to follow up on this?
Did I instruct them to follow up? No, but in the normal course, they would follow up and I'd have conversations with them and I'd get an update and did I actually say, no, I want you to do this and do that? No.
So you don't know whether anything happened, whether Mr. Obradovic or Mr. I can't pronounce his name, Golubovic did follow up? You don't know that?
I assume they would have followed it up and kept track of it, but would they have reported everything to me at the time? Not necessarily.
Is there any
Unless a decision was made at some court to finalize it. Or
is there any documentary evidence of any correspondence with the city or anything of that sort?
not that I've seen or saw at the time.
Anything from, I think you said the lawyers at Mr. Yankovic's firm? Anything from them?
No. I mean, all these documents would have been in Serbian, and I might have been given a brief summary of what was in them, but they wouldn't have translated all the correspondence and sent it to me, no.
But did you recall receiving any such summary?
Do I recall a specific conversation? No, but I would have had regular conversations about this and other issues, and because I had other properties in Belgrade. And in the course of those discussions, I'm sure I would have gotten updates.
Okay, so I'm just looking at what the transcript records. So you said assume and would have. So you don't remember any sort of additional information in relation to any communication after the 2008 letter?
I don't recall any specific discussions at a specific time, no.
Okay. Thank you. Let's move on to yet another topic that is covered in your first witness statement in paragraph 33.
Sorry, 13.3?
33,
Oh, 3.3.
section 6, changes in the ownership structure of my Serbian companies in 2012.
Just a sec. Oh, yeah, okay.
So what you say here is that you received an advice in 2008 from Torsteinsons
Thorstensen, yeah.
to restructure your ownership of BD Agro through a Cypriot company. Is that correct?
Yeah,
And that's also, you did implement that at the time.
yes.
But you did not implement anything in relation to Obnova at the time. Is that correct?
Not at that time, not in 2008, no.
So then you say in paragraph 34, just a bit further down, in 2012, consistent with the advice given me regarding BD Agro, Torsteinsons subsequently advised that it would be beneficial from a tax perspective for me to restructure and so forth. So this time, this advice seems to refer to Obnova, is that correct?
Yep.
And how did this advice come about? I mean, did you reach out to the firm and say, I mean, I have other investments in Serbia?
Thorstensens?
Yes.
Yeah, they'd given me tax advice on a lot of my business affairs, yeah.
Yeah, I'm interested in this specific advice in 2012. Did you reach out to them and ask them to look at the
Yes.
the investment?
Yeah.
So you've gone to them in 2012 to ask whether it would be, from a tax perspective, beneficial, to use your words,
Yep.
to restructure the investments in Serbia.
Their office is just around the corner from my office, so you know them quite well.
So you did obtain then a separate legal advice regarding Obnova, is that correct?
Yeah.
Do you know why that's not on the record, but the 2008 advice is on the record?
Say that again.
The advice in
why?
relation to 2008, BD Agro, is on the record in this arbitration. So we know the document. The document in relation to the second advice that you say you've received from Torsteinsons in 2012 is not on the record. Is there any reason for this?
It's not on the record. It's in my witness statement, so.
But the advice itself, the document or whatever it is that records the advice from Torsteinsson is not on the record. Is there any reason for
It
this?
probably was verbal advice, so what could I put on the record other than this?
You don't know whether there was a written legal opinion, is that what you're saying?
No, I wasn't. The guy's terrible at writing anything down. He likes
I
to-
take
he-
that, but I mean,
he's
the
very
question
smart.
is,
He's a very smart tax lawyer, but he's not very good at writing things down. He likes to have a discussion and tell you what to do, and you make your notes and away you go.
okay, you're saying there was nothing in writing. Is that what you're saying?
Yeah.
And you're positive about it? There's nothing, was nothing in writing. in
I'm
2012.
almost positive. John Gregory, who's a very, very smart lawyer, but he doesn't report well in a writing fashion.
And why did he do so in 2008?
I have no idea. I don't know if he did then. I don't know if he wrote a letter in 2008. He gave me the advice as to what to do, but I suspect he didn't write a long memo about it because he's not very good at that.
But you do recall receiving that advice specifically in 2012.
Yeah.
And why did you reach out for that advice? Why did you go to them in 2012 to ask for that advice?
I don't know. Why do you go to a lawyer to ask for advice? Because you think you need advice, I guess.
You could have done it in 2009, 2010, 2011, and perhaps 2008 when you were actually restructuring your investments in Serbia.
I don't know. I don't know why I didn't do it in 2008, 9, 10, 11, 12, 14. I don't know.
You do not recall.
I mean, why I waited to 2012?
Yeah. Well, it's fine if you do not recall. I mean, just say it for the record.
I don't know. I don't know why I wouldn't have done it earlier or later.
You don't know. Okay.
Mr. Keller, I am going to propose a break at some time shortly. If this is a convenient time, we'll do it now. If you've got a line of questions that can be completed in the next few minutes, then we can carry on.
Yeah, I think if everyone would indulge me for another 5 minutes or so, and then I think would be a good time.
We'll go on just for another 5 minutes, then we'll
Okay.
take a little bit of a break.
Yeah, sure.
I'm staying on that subject. So we're in 2012. You say you reached out to Torstein Sons and to ask about tax restructuring. You received this advice.
Yeah.
In terms of the situation, the factual situation at the time, do you recall that in September 2011, the city of Belgrade was registered and inscribed as the owner of the Dunavska plots of the real estate?
Do I recall specifically? No.
Would someone have told you about this?
I'm sure they did, yeah.
Okay, but you don't recall
No.
back from the time. Okay. So you also don't recall whether you've considered pursuing legal steps in relation to that inscription of the city of Belgrade?
No, I wouldn't have. I wasn't contemplating any sort of litigation at that stage, I don't think. It's not something you really want to do if you can avoid it.
Well, being a litigator, I mean, of course, curious about this. So, I mean, this is your real estate.
Yeah.
You're saying and have been saying today in this arbitration, well, the inscription was incorrect anyway, but it's easy. We could have fixed this. Just, I think you said earlier, you just need to get a lawyer, submit the right documents, and you get your rights registered. Now it's 2011, so that's 6 years after you invested. And now the situation is actually getting worse. So the city of Belgrade is now inscribed as the owner of the real estate. And you're saying you wouldn't consider that something you would want to fight against?
Probably you wouldn't want to fight against it, sure. Would you initiate a fight at the time? Obviously, I didn't.
And do you remember, is that a conscious decision back then to say, well, we'll just accept that the city
No,
of
I wouldn't have
Belgrade?
made a conscious decision to accept it. No, I would have hoped that it could be resolved in some other way.
What's that? What is resolving it in some other way? I mean, there's a legal situation now. The city of Belgrade is inscribed as the owner. I mean, how would you resolve this? It doesn't magically go away.
I think most of the country was registered in the name of government entities of some kind or other, and the whole process of getting things registered in your name was slow and cumbersome and not going to happen overnight. I mean, I think the registry, the cadaster, was overwhelmed with paperwork from hundreds of thousands of properties around the country that weren't registered and people trying to get them registered.
I appreciate that, Mr. Rand, but I mean, this lack of registration is that I think we're talking about objects and not the land. And here is not, it's not a communist legacy issue that we're looking at. It's September 2011, and there's a new registration on behalf of the city. It's a bit of a different situation.
Yeah.
And you still thought, I mean, it will just be resolved in some way.
Yep.
Okay. Let's take a look at another document. I promise that's the last one before the break. And that is document R26. It's again court document, Belgrade. You can see here it's a commercial court of appeal. It's dated 9 February 2012. You can scroll down a bit.
Yeah.
So this is a judgment. And it's proceedings between Luka Belgrade and Obnova. You've seen this document, or is it new to
I
you?
don't recall seeing it, no.
Okay, let's just take a look at page 3 of that document then. We've highlighted it here for you. You're more than welcome to read. I mean, I just want to tell you what it says and whether you were aware of that at the time. So again, these are court proceedings between Luka Belgrade and Obnova. They were going on at the time of your restructuring. They're going on at the time relatively soon after the city of Belgrade has just been registered as the owner of the land. And in this court judgment, it's recorded again that Obnova is not the owner of the land and that Obnova is using the land on the basis of a lease agreement. Is that something that you were aware of?
I would have felt like, I don't know, was this even translated at the time? I don't recall.
You were not aware of this in 2012?
Not that I recall. Let me just see what it says. Applied substantive by challenge decision. I'd have to read it more carefully to find out if the information in this was conveyed to me, but it'd take me a little while to go through it.
Okay, but I mean, if you say, I mean, you were not aware of the court proceedings and you were not aware of the statements that the land was not owned by Obnova and was used based on these agreements, I think then we can rest on that.
I might have been briefed on the summary of what the court decided, but did I actually read this written summary? No. But I would have expected, I would have been briefed on it,
but you don't recall. Okay, thank you, Mr. Randman. Let's pause here.
Thank you, Mr. Kellam. Mr. Rand, before we take a break, may I just ask you one small point just to clear away? It's a clarification point.
Yep.
In your second witness statement, if council can call that onto the screen and go to paragraph 39.
39?
Yeah. Mr. Rand, it there says, following the tax advice I had received as early as 2008 from Thorntonson's, my participation in any decision-making relating to Coropi or Kalemegdan was done only while I was physically outside Canada. Could you just explain that? Was the tax advice that you could not be involved in the administration or decision-making of either of those two Cypriot companies while you were physically in Canada, because that would otherwise bring you within the jurisdiction for tax purposes?
No, I think what you were trying to establish is that the decision-making was made in Cyprus, not in Canada. And so if I was giving instructions from Canada, then they could make the conclusion that it was being run and decided in Canada, not in Cyprus. And the object was to make it clear that the decision-making process was in Cyprus.
Even though, as you say in the last sentence of that paragraph, you would have taken these decisions in Palm Springs or on your estate in Italy.
Yeah. While I was outside of Canada.
Which was outside. Okay. Thank you very much. Council no doubt if they wish to be able to come back to that. Let's take a break now.
Okay.
Subject to any wish that you may express, Mr. Rand, for a longer break. I'm going to propose that we take a 20-minute break. But if you feel that it would be helpful,
Whatever you want, I'm easy either way.
no, I want to make sure being a witness is an exhausting thing.
No, it's
You've got
not.
to.
It's okay. I feel fine.
You feel fine. Okay. Well, then, okay. You, in due course, once you finish testifying, you can tell your counsel that you are very robust on these issues. Let's take a break for 20 minutes and come back 20 past the hour.
Good. Thank you very much.
Was it?
Some vinegar.
Excuse me, sorry.
Everyone ready?
I'm
Rand?
ready, yeah.
Okay. Mr. Keller, over to you.
Thank you, Mr. President. Welcome back, Mr. Rand.
Thank you.
So I want to move now to the structuring of your investments. And we've already touched upon that a bit when talking about the tax advice and the situation in 2012, when you are going about the restructuring of your investment in Opnova. Let's start a bit earlier before. So, and I think that's the first witness statement, if you want to take a look at it. It's paragraph 11, where you address that, I think, for the first time, when you're saying that all of your investments in Serbia were structured in the way that you were financing it, but it was Mr. Obradovic who was the owner, and you say nominal owner of the investments. That's correct, right? So that's the setup.
Sorry. I got
Number
the wrong
11,
one.
you should see it on the screen now as well.
Let me get this. Same way. Yeah, yeah.
You got it? Okay,
Yeah.
perfect. So you're saying all your investments in Serbia were structured in that way. So I assume then when in 2005, you decided that you wanted Opnova, then you instructed Mr. Obradovic to purchase Opnova on your behalf so that the same setup would be put into place. Is that correct?
Yes.
Okay. So you had some sort of, let's call it arrangement with Mr. Obradovic. What was the basis of this arrangement?
You mean the monetary arrangement?
Well, let's take it step by step. Maybe first legal. I mean, was there a contract saying that he
No, I
was
had nothing in writing. With Mr.
no contract with him?
No.
So then you wanted to go to financial. So what it would look like financially?
Well, the deal was that if I bought a property and I made some money, I would give him a bonus of some kind without a specific amount mentioned.
Okay. Did you have any rights over the property? I mean, if Mr. Obradovic was inscribed as the owner, and I'm talking all investments now, it's a general question about your Serbian investments. So assume something might happen, as I think you told us earlier, did actually happen with Mr. Obradovic later. So he was misbehaving, let me put it like that. I mean, did you have any rights then, which would allow you to take control of the Serbian investments? Because you were not inscribed as the owner, right?
Yeah, you know, I always had agreements with him, especially in relation to Cyprus, where he signed a piece of paper that I could transferred out of his name at any time.
Okay, but you just said there was no contractual arrangement with him. I think when you're now saying there was a contractual arrangement with him.
Well, if you're talking about a contractual arrangement where I employed him on certain terms, no, we didn't have that type of arrangement.
Okay,
But certainly with respect to Cyprus, when things went into his name, he had to sign a piece of paper saying that he transferred at my request to wherever.
okay. So when you're saying Cyprus, you mean the holding structure with Kalemegdan and Coropi then?
Yeah.
Okay. We're now when talking 2005, right? When you first acquired Obnova. So that was before the Cyprus restructuring. So was there any document that would oblige Mr. Obradovic to follow your instructions? Or how did you actually control him?
Control was maybe the wrong word, but if he bought anything, we document the fact that I owned it and it was in his name and he transferred to my name when I wanted.
Okay, so there would be, just so that I get this right, so on an investment by investment basis, there would be some
Yeah.
document saying that it's actually your investment.
Yeah.
And he's only holding that on your behalf. Is that
Yeah,
correct?
yeah.
And we've been talking on a general level now, but now looking at Obnova, that means for Obnova, there should be a document showing that he bought Obnova on your behalf. Is that correct?
Yeah, there would be something somewhere, yeah. Might be just an email or a text message or whatever, but yeah, there'd be something somewhere.
It should exist, is what you're saying, but you don't know in what form.
No, that's right.
And what's the content of that document? Because we don't have the privilege of seeing it. It's not part of the record. So what does it say?
It would be just simple that I'm putting up all the money, it's gonna be in his name and I'm the beneficial owner and he'll transfer it to me whenever I ask. Something to that effect,
And who would have drafted that?
or do it myself.
You would have drafted that.
Yeah.
Would that be in the form then, to the extent that you recall, of course, is it a contract? Is it subject to any law? What are the obligations under that arrangement?
So we do any law? No, I mean, I signed an agreement with him. I don't know if I stipulated this was subject to BC law or subject to Serbian law or, no, I don't recall that. I don't know if it did specify the legal jurisdiction of it.
And would it be more in the form of an instructions letter, or what was it the kind of thing that we'd expect, that he'd say, we just follow your instructions at all times?
Yeah, basically.
That would be the content of it.
Yeah, and he testified at the BD Agro hearing that we had that I gave him instructions and he'd always followed my instructions and he was only the nominal owner and I was a beneficial owner. And he testified that, he always followed my instructions and he didn't own anything in his own name and whatever.
Okay, but it would be, as you said, on an investment by investment basis. So you would have something specifically for Obnova.
Yes.
And I hope you don't mind me asking, but why didn't you put this document on the record?
Wasn't asked to, so.
Okay. And it's just one document, or was it change? Was it an amendment to it or something of that sort?
I don't recall whether I had just an overarching letter that dealt with everything or whether I probably just had one overriding letter that said, whatever you have, I put up the money for it. If I put up the money for it, it's mine. Something to that effect. I mean, it wasn't very sophisticated, I must admit.
Okay. So just one second. Well, let's move on to the bit in time then. So we're still talking about Obnova. So you wanted to restructure then in 2012. And doing so, and you described that, and if you want to follow it in your first witness statement, paragraph 35.
So paragraph 35?
Yeah, 35.
Let me get 35.
So you described the restructuring there. So then the plan was to establish a new holding company that was Kalemegdan in Cyprus.
Yep. Yep.
And that's a pure holding company, is that correct?
Yeah.
Does Kalemegdan have an office?
Say that again.
Do they have an office? Kalemegdan? Do they have an office?
It would have had a Cypriot office.
Like an actual brick and mortar office that you can go to?
Yes.
Does it have any employees there?
The accounting firm provided all the administrative management services.
Okay, so the firm was running the administrative services for you, but there was an office, or there is an office still,
Yes,
I hope.
yes. Yep.
I mean, have you been there? Do you go there from time to time?
I've been there, but I wouldn't say I go there from time to time. No, I've been there once.
You've been there once. Does Kalemegdan have an office of its own, or is it just part of one of these?
It's part of a community office type thing.
So when you need some space, they make it available for you
Yes,
as a service.
yes.
Is that the kind of arrangement? Okay. But they do have a proper sign. They have a receptionist. Someone is answering the calls. Is that
Yes, yeah, absolutely, yeah.
okay? So you established Kalemegdan, and then you instructed Mr. Obradovic, I think that's in paragraph 40 of your witness statement, to contribute all of the shares in the Serbian companies, and that included Obnova, of course,
Yeah.
in Kalemegdan. And I think that's also, well, slightly later, April 2012. So Kalemegdan was then the owner of Obnova, but Kalemegdan was also owned by Mr. Obradovic. Is that correct?
He was the registered owner, yes.
Right. And do you recall whether Kalemegdan did pay anything to Mr. Obradovic as a purchase price for the shares?
I don't recall exactly what the number was.
Do you think that Kalemegdan did pay something?
Well, it would have had to contribute. It would have had to issue shares in compensation, sure. But there was
Okay.
no cash changing hands.
Okay, so issuance of shares, but no purchase price.
Right.
Is that what you're
Yeah.
saying? Okay. So in a way, in the corporate structure, then above Kalemegdan, you have Coropi, is that right?
Coropi, then Kalemegdan, yeah.
Yeah. What's the purpose of Coropi? When you wanted to have a structure, so using Cyprus for tax reasons, you say, but Kalemegdan did fit this box, right? So now you had Cyprus. What's the purpose of Coropi?
I don't know. The tax lawyers tell you to structure something that way and it makes sense to them, and so you do it. But could I have skipped one of those steps? Maybe, but if that's what they told me to do, that's what I did.
Okay, so you don't know what the specific purpose of that
No,
entity in
no,
the structure was?
Not particularly.
Okay. Is it right to say that you control Coropi?
Yes.
And is it also right to say that you controlled Kalemegdan?
Through Coropi, yes.
And there's also an agreement between you and Mr. Obradovic, right? So that Mr. Obradovic, when he was still around working for you,
Yeah.
was also follow your instructions, right?
Yes.
So you would also exercise control through Mr. Obradovic then?
Yes.
And if we go to paragraph 48 of your first witness statement. We'll discuss a bit or elaborate a bit on the practice of you your control over Kalemegdan and Coropi. You say, quote, "I've always controlled both Kalemegdan and Coropi, have been a director of Coropi since 2010. And Mr. Markicevic has been a director of both companies since 2013. And as a result, it was sufficient for me to discuss relevant matters directly with Mr. Markicevic and Broshko, and there was no need to formally convene meetings of the company's directors."
Yeah.
That's the way you exercise the control, is that correct?
Yes.
I mean, in all of this, in this setup, I mean, you have Coropi as the beneficial owner. You mentioned that earlier of Kalemegdan. That's correct, right?
Yes.
And then what's the basis of that beneficial ownership?
What do you mean? What the basis of it?
Is there an agreement? I mean, how have you put that beneficial ownership into place for Coropi over Kalemegdan?
Well, Coropi would own the shares of Kalemegdan, so presumably.
Well, it does today, but Mr. Obradovic was the owner of the shares of Kalemegdan until the end of 2023.
Okay.
And you say
So-
Coropi was a beneficial owner. So at the time when Mr. Obradovic was a registered
The
owner,
nominal owner, yeah.
yeah. So what was the basis for that beneficial ownership?
I don't know what you mean by the basis of it.
Well, it doesn't appear out of nothing. You need to create beneficial ownership, right? You need to put it
Well,
into
yeah.
place legally.
Yeah, well, George would have been the owner and he would have had a piece of paper saying that at my request, he'd transfer ownership to my name or whatever other name I wanted. He worked for me, I paid him and.
Okay, so there should be a document between Coropi and Mr. Obradovic.
Yeah, I'm sure there is.
Setting this out.
Yeah.
And there would be between you and Mr. Obradovic, is that correct? Or is it between
It'd
you,
be-
Coropi, and
it'd
Mr.
be-
Obradovic?
It'd be between, maybe all three of us, I'm not sure. I mean, the accountants in Cyprus would have done the paperwork on that.
But you're saying this is the basis of the beneficial ownership?
Yeah.
Okay. Do we know from when this document is? I mean, have you seen it?
No, I'm sure it's in the record somewhere, but do I recall off the top of my head? No, exactly, no.
This is a bit of our challenge because it's not on the record. That's why I'm asking you.
I don't know.
Okay.
I can certainly find out, I'm sure.
I mean, just maybe to make sure that we don't have a situation of ships passing in the night. I mean, you're talking about the trust deed with that document? Because there is a trust deed on the record.
In Cyprus, yes.
Shall we look at that then? Maybe if you say that's the document. That's C66.
66?
It's coming up on the screen. So that's a trust deed entered into 26th of April
Yeah.
between Coropi and Mr. Obradovic. Is that the document you were referring to?
Consideration is beneficially. I assume that's it, yes. I mean, yeah. I haven't seen the whole document, but.
Can we take a look at paragraph 40 of your first witness statement then? So want to make sure that we're clear on
40
this.
of my first one.
Yeah, it will
okay.
also come up on the screen. So that reads in furtherance of Coropi's beneficial ownership. I later instructed Mr. Obradovic to conclude two trust deeds with Coropi. This
Yeah.
statement, the way I read it, says there was beneficial ownership, and later you were concluding these two trust deeds, which is why my understanding was that trust deeds are not the documents that establish a beneficial ownership. So just putting this to you, just to make sure that you're aware of your statement here and just,
I
but-
don't quite follow it. Further as a group is beneficial ownership. I instructed to include two trust deals, right? April 12. Second trustee, a few months later in August. So what's the question, sorry?
Well, you just said that the trust deeds are the documents that establish the beneficial ownership.
Yes.
I just want to make sure that this is what you're saying that you wanted to say, because I read paragraph 40 of your witness statement to say there was beneficial ownership established by something, and then there is a later act, which is the two trust deeds. That's the way I read paragraph 40, but I'm putting it to you. I'm asking you what you want to say here. What's your statement?
I don't understand what you're asking.
Well, maybe let's
There was two trust deeds.
yes.
Okay, and what's
Well, was
It's
the
pretty
beneficial
straightforward.
ownership, did it exist before the trust deeds already?
sorry, say that?
Did the beneficial ownership of Coropi over the shares of Kalemegdan exist before these two trust deeds?
I guess there wasn't a formal trust arrangement, but George Obradovich knew that everything he bought was with my money and it was mine. And that's what we tried to get it down in writing and documented in Cyprus. Don't know what else I can say.
Okay, I mean, again, just to make sure that we get this right, you're saying the beneficial ownership did exist before the two trust deeds. Is that your answer?
Yes, yeah,
Okay.
yeah. Everything was, George had no money at all. Everything he bought, everything he did was with my funds, and he always understood at all times that it was in effect mine.
I understand that and appreciate that this was the arrangement, but I think we need to be precise here. You are not a claimant in this arbitration, Coropi is, and I'm asking about the beneficial ownership of Coropi
Yeah.
over the Kalemegdan shares. So it's not an arrangement between you and Mr. Obradovich. It's an arrangement between Coropi and Mr. Obradovich here that I'm asking about.
Okay.
So, because you just said, I mean, it was always your funds, it was all yours. The question is whether Coropi's beneficial ownership over Kalemegdan existed before these two trust deeds that we looked at, that you're describing here in your witness statement. If you don't know that, I mean,
I
you
don't
could
know.
just say.
I don't know. Yeah, I'm not sure. I would have assumed it was all done relatively at the same time, but I'm not sure.
Okay. Let's take another look at the trustee himself, but I'm not going to another topic here. There it is again, thank you. It says, unter whereas small a, the grantor for consideration given is beneficially interested and entitled and so forth, and then it refers to the shares here. Did you obtain any legal advice in relation to this trust arrangement, these trust deeds?
Yeah, for sure. Yeah. 2012, who would I have talked to? I'm not sure whether it was a lawyer in Vancouver or relying on the accountants in Cyprus, but I would have come to the conclusion that this is the way it should be structured, one way or another.
On the structure, you're saying you've received advice?
Yeah.
Okay. Did you also receive advice specifically on the trust and how to implement the trust?
Yes.
Do you recall what that advice was? What the practicalities?
You know, I got the advice to set up the trust. Like, what's the question then?
Did the advice include a statement saying that you actually have to pay consideration?
Yes, of course. Yeah.
Did the advice say anything about the amount of consideration?
No, I don't recall. No. I guess so.
Who would have given that advice? You said the accountants, would it be the firm HLB or who would it be?
I'm not sure. I just can't say. I don't know where I would have got the advice from. Could have come from any number of different sources. So I'm not sure. Probably just the accountants or my accountant. I've got a accountant that works for me in Vancouver that looks after a lot of my accounting stuff, and he's been with me for I don't know, 20 years now, and he looks after a lot of this stuff.
Do you know whether this consideration was actually paid?
If I'm not sure whether if technically you had to pay the 4,000 euros, I would have paid it for sure. Whether this required it or whether it was just a share exchange, and that's the way the shares were valued, that could have been too. So I have to look at this document more carefully if you wanted me to tell you which it was. But one way or another, it would have been either paid in cash or it would have been in shares valued at that amount. One or the
Okay.
other.
And would that have been documented or would there be correspondence about that payment?
Correspondence, no, it's not that complicated that you have to have much correspondence. It's just a number.
That's true, but you said it had to be paid. So it was a formal requirement, I take. So would that have been documented, that payment?
If I had to send money to Cyprus, it would have been documented, yeah.
Okay. Do you ever discuss that issue with Mr. Broshko?
I don't recall.
Okay. Just 1 second, please. Okay, then I think I don't have anything further. So thank you very much, Mr. Rand.
Yeah, thank you. We have no questions.
I should pack up and go.
No, not quite yet,
Sorry.
Mr. Rand. There are a couple of questions from the tribunal.
Okay.
I'll start off. I don't think that will detain you for very long.
It's okay.
And it's really just to clarify a number of things
Okay.
in our mind, both from your written evidence, but also from the oral testimony that you've given. With regards to the advice that you received from Mr. Jankovic as a former Minister of Justice.
Yep.
Did you consider his advice on zoning? You obviously did consider his advice on zoning to be reliable.
Yeah, I would say, yeah.
Can you tell us why? I mean, did you receive detailed written advice? Did you receive detailed oral advice? Or was it the fact that the Minister of Justice, the former Minister of Justice, was saying this is the position with regards to zoning?
It wasn't in writing. It would have been in a conversation.
So it might even have been a conversation over dinner. Mr.
Yeah.
Jankovic, what do you think about
Absolutely,
this?
yeah. In fact, most of our conversations were not in his office.
So would I be right in the understanding that the fact that Mr. Jankovic was Minister of Justice, a former Minister of Justice, carried a lot of weight with you?
Yes.
But you didn't either look behind his advice or seek further advice? Because I think you said in your testimony that you got advice from others in his law firm.
Yeah. I met a couple of lawyers in his office and had conversations with them, but most of my conversations were with him, I'll admit. I don't recall the names of the other lawyers in his office that I talked to.
Right. That's helpful to have that clarified. I think you've already answered this question in response to questions from Respondents' Council, but let me ask it again in a slightly different way, just to make sure that the position is clear. I mean, when you were briefed by Mr. Broshko, and we saw one example of the email, which was followed up by a Skype call the following day. But if it was on a significant, let's say, legal issue or planning issue in which there was documentation,
Yeah.
on those Skype calls, would Mr. Broshko typically talk you through a document or show you a document, or was it simply at a very high level?
I would say it's at a pretty high level. Yeah.
So you wouldn't focus on the detail, you would essentially trust in the advice or the guidance that Mr. Broshko was giving to you.
Yeah. Yeah, he's a lawyer, so yeah, he would have been better informed than me as to the details of what was going on. And you know, he went and lived there with his family for a number of months, and so he was more familiar with Serbia than even I was. I would.
You weren't, though, relying on him as a lawyer, were you? You were relying on him as your as well, eyes and ears.
Yeah, yeah, but he was a lawyer, so I knew that he would be careful about saying something that, you know, he'd have to be able to make sure it was correct as far as whatever the zoning was or legal issues or something like that. He wasn't going to just shoot from the hip in that regard. I know that.
Right. Let me perhaps in more colloquial language than Mr. Keller has been asking you about, but let me put to you a characterization of your investment in Obnova, and please don't take it as either complimentary or negative,
okay.
but I'd just like to invite your response. That in 2005, this was an entirely speculative investment, which you entered into with a prospect of some kind of long-term gain because you thought that the land may be developed for residential purposes. Ultimately, in the scheme of your property portfolio, this was a very small amount.
Yes.
With the potential for a significant windfall whenever that windfall might come. And therefore, you didn't focus on the detail, perhaps unlike some of your other property investments where you might have had a closer focus on the detail. You
Right.
didn't focus on the detail.
Yeah, it wasn't a significant amount of money. Get right down to it.
So without scripting a conversation that you might have had with Mr. Broshko, at least in my mind, it might have gone something like this. Erinn, you run it. I don't want to be bothered about the detail. Just keep me updated from time to time. Is that fair?
That's fair, totally fair. And
Okay.
it relates not only to that, but to a lot of other projects I'm involved in.
Right. So that would account for your responses and saying, I don't recall, or I understand. You weren't in the habit of following the detail or giving instructions on the basis of the detail. You essentially left it to
Right.
your colleague who was described as a managing director.
Right. As I got older, I've got less and less attention to, I pay less and less attention to detail, I'm afraid.
I'm looking forward to that.
When I was
happening to
younger,
me
I
as
was
well.
much more detail oriented.
Right. That's helpful to know. I'm interested just to explore very briefly your agreement with Mr. Broshko that he was to be badged as a managing director. And I wonder, I mean, you've seen his written witness statement as he has seen yours. So you will appreciate the evidence before us that this was something that the two of you discussed and you decided that you would badge him as a managing director.
Yeah.
And I suppose the question to you was, were you not ever concerned that that may be a little bit misleading to the people with whom he was engaging in Serbia? Because they may have thought that he had some formal decision-making, corporate decision-making authority within your business. But in fact, he hadn't. He was simply an agent who on occasion you gave delegated authorities to.
Right, that's right. But
So-
managing director is a term. I mean, Goldman Sachs has like 600 managing directors, but can they speak for Goldman Sachs? No, but they've got the title of managing director of Goldman Sachs. So I guess the term is sometimes misunderstood.
Well, you are a lawyer by background, and I'm sure that if a managing director of Goldman Sachs purported to speak for Goldman Sachs, that someone might very well say, Goldman Sachs, you're on the hook. So it's a question of,
Yeah.
when
I
Mr.
agree.
Broshko was speaking for you in Serbia and had his business card, or it's at the bottom of his email,
Right.
the C337, it says managing director. You didn't have any concern?
No, not at all. No.
Right, thank you. I think, Mr. Rand, those are all the questions that I have. Let me look to my colleagues.
I may have a couple. Mr. Ran.
Yep.
Good afternoon. I have two questions. The first one is related to the first one that Sir Daniel Bethlehem, the chair, asked you about how you manage the investment, or how the investment was managed in Serbia with respect to Obnova in relation to Mr. Broshko.
Yeah.
We discussed earlier today that this was not the only company that you bought, that you have at least other four, and I understand that also a sixth one.
Yeah.
So my question is, with respect to these other four that are not the milk company that we are aware of,
Yeah.
because of the other litigation, we saw that all these five investments or five companies together, they have an exchange value in 2012, or was value in 2012 in the exchange in the Kalemegdan, when Kalemegdan was created, of roughly 2 million euros. Is that a number that sounds about right to you? In total, the five.
Maybe would I sell all my interests in Serbia for 2 million euros? The answer is no, but
Yeah, I can show the document. It's just that I want to know if the number sound.
Yeah, it's. I mean, how accurate is the number? Is what you're asking?
Yeah, but it sounds in the ballpark more.
Yeah,
or
it's in the
less at
ballpark, I would say yes, but.
Okay. So my question.
I mean, it depends on your point of view. I think they're worth more than that, but a buyer might think.
No,
they're
it's a
not.
nominal value. To be fair with you, it's a nominal value that appear
Right.
in the. I just want to.
Yeah.
Because that takes me to my next question. My next question is: these five companies are not the milk company, Obnova and the others. I'm sorry, I don't recall the name.
Pester and et cetera. Yeah.
Exactly. Were managed in a similar way of to just characterize Obnova was managed or Obnova was handled by Mr. Broshko?
I would say
In response to the question of the president.
Well, Mr. Markicevic was the one that was on the site that sort of managed everything in more detail. And Erinn would talk to him on a regular basis. And once every couple of months or so, maybe we'd have a conference call. But basically, I relied on Igor to look after almost everything all the time. And if something came up, he'd talk to Erinn, and sometimes Erinn would talk to me. But yeah, it was Mr. Markicevic actually was there every day working on it, and that was his job, and that's what he did. And he kept very good track of everything that was going on, and he reported regularly to Erinn, and every once in a while they'd call me if there was a decision to be made. I mean, if it was just something that was happening that didn't require any decisions, they probably wouldn't talk to me, unless it was, going to destroy the value of something. But generally they were. I mean, did I follow maybe as closely as I should have? No, but that's my nature anyway. So.
Okay. My last question is that we were in the testimony of Mr. Broshko, we saw that he was hired to go in person at first. You hired him to go in person at first to Serbia,
Yep.
and he stayed there for 6 months, and at the, roughly
Yeah, with his
when he was-
family and kids and everything. Yep.
yeah. And when he was there, also Mr. Markicevic was hired as
He
well.
hired him.
So
Yeah.
my question to you is that you have this, you bought these companies to
Yeah.
Mr. Obradovic in 2005, but I see that in 2012 you send Mr. Broshko, you hire him, you send them there, also Mr. Markicevic. Can you give me a bit of a background of the context of that decision at the time? I don't know if you understand my question. No?
Yeah, no, I
have this
understand your
holding
question,
for
yeah,
some
but,
time, and then
When I was
obviously-
younger, I would go to Serbia like quite often because I went to Europe 5 or 6, 7 times a year on business. Then it's like, so I retired from the practice of law and I didn't have to go back some. And then I got off I was on a number of boards that had meetings in Europe, so I had to go over all the time. And I gradually didn't want to keep going over there all the time. So I got off the boards. And I wanted someone else I didn't want to keep going to Serbia very much. I mean, I haven't been there for, I don't know, 3 or 4 years because just don't want to tell you the truth. And so Erinn did a lot of that legwork for me, going back and forth, and he still flies around all over the place on my behalf, and I'm happy that I don't have to do it. But
Okay.
as I said, I am getting a bit lazier in my old age.
Thank you very much. That's all I have.
Mr. Wren, may I just come back to a small point in response to Mr. Janner's question? I was left with the impression that apart from the big decisions, Mr. Broshko essentially ran your Obnova investment together with Mr. Markicevic
Yes.
and perhaps others. Is that correct?
Yeah, that's absolutely correct.
Can I just take you to paragraph 32 of your first witness statement, which seems to suggest something different, and I'd just like to ask
Okay,
you
let me-
which is correct and if you would like to correct anything. You say Mr. Broshko has never managed my Serbian companies in his own name or on his own behalf. Maybe that's not incorrect. Maybe this is simply saying he never ran the companies purporting to run them for himself.
Yeah, it was always clear that I owned them, not he didn't own them.
So he was, for these purposes, your alter ego and ran these companies. And when and if there was a significant decision to take, he would brief you and you would say on the Skype call or on the email, yep, go with it or something like that.
Yeah, that's right. Yeah.
Thank you. I think there are no more questions from the tribunal, but let me just ask counsel for the respondent whether there's any comeback from you.
Nothing, thank you.
No questions?
Mr. Rand, you are the happy beneficiary of an early conclusion to your testimony.
Thank you very much.
So I will release you from that. But before I do, let me just admonish you in respect of one aspect, and that is Mr. Markicevic is coming on to give testimony. And under the rules, he's not to be aware of any testimony that you have given. So you won't have much of a chance to talk to him now, and we're going to move straight on to him now. But if he is sequestered overnight, of course, he won't be able to talk to anyone, but
Okay,
you are also under an injunction not to talk to him about your testimony, just
Okay.
as Mr. Birch.
so he can't come for dinner with us tonight.
No, if he's sequestered, we may finish with him very quickly.
Okay.
But thank you very much for
It's
your.
okay, I'm having
for
dinner
your-
with my wife tonight anyway, so.
Well, thank you.
Thank you very much.
Should we pause for 5 minutes? Let's pause for 5 minutes and then we will move on with the testimony of Mr. Markicevic. I'm asked whether the 5 minutes means 5 minutes and the 5 minutes means 5 minutes. Yeah.
I think Bill took the.
Okay, proceed. Thank you. I understand.
I think it's because of the disappointment that there's no more coffee.
Okay, let's go on the record again. Mr. Markicevic, welcome. I hope I'm pronouncing your name correctly or sufficiently correctly.
Sufficiently correctly.
correct.
I'm very happy with it. Yes.
Thank you very much. I appreciate that you perhaps were expecting to come on to give your evidence 2 hours ago, but there we are. We will see how we go today. I think we are scheduled to conclude in about an hour's time. Depending on how we go, we might overrun a little bit, simply because I would like to save you the burden of having to be sequestered and not speak to anyone overnight, but we will see how that goes. You have a witness oath in front of you. I'd be grateful if you could read that, please.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Package.
Thank you, Mr. Chairman. Good afternoon, Mr. Markicevic.
Good afternoon.
Mr. Markicevic, do you recall submitting 2 written witness statements in this arbitration?
Yes, I do.
Do you have their copies in front of you?
Yes.
Could you please go to the last page of each and confirm that it is your signature there?
Yes, I confirm.
Is there anything you would like to change in your witness statements?
No.
Thank you. We have no further questions.
Mr. Keller, over to you.
Thank you, Mr. President, and good afternoon, Mr. Markicevic. My name is Moritz Keller. I'm going to ask you a few questions. I'm counsel on behalf of Serbia, so I'm sure you figured out. Very, very happy that you keep your answers brief and concise. I'll try to ask my questions in the same way. So let's start with your background, really just establishing the basics for our discussion. You say in your first witness statement, it's paragraph 2 if you want to look at it, but I'm sure you know, that you worked in the real estate investment sector for roughly 2 years after your graduation in 2003. That's correct?
After I worked in the real estate sector about, so the one that you are marking says, well, this is a brokerage company. So after that, in 2005, for a year or 2, I was in the real estate sector.
In real estate, yes. Okay. And then, yes, you also worked for this brokerage company, as you mentioned there, for another 6 years or so. And then also in your first witness statement, then in paragraph 9, you said 2012, we're moving forward in time. You first met Mr. Broshko. He was looking for an experienced senior manager to oversee Mr. Rand's investment in Serbia.
I just didn't hear one part of the questions. Sorry, if you can repeat this, someone.
Sure. I mean, if you look at paragraph 9, what we're looking
Yeah,
at.
so paragraph, yes.
So it's summer 2012. You met Mr. Broshko and saying he was looking for an experienced senior manager to act as a representative of Mr. Rand.
Correct.
That's correct. In terms of your education, just to again make sure that we're not missing anything, you're an economist, right?
I'm an economist, yes.
You do not have any legal training, is that correct?
No.
And in 2012, you then started to work for Mr. Rand. Can I ask, how is that set up? I mean, you're an employee of what company, of Rand Investment or of one of the Serbian companies? How does that work?
So in 2012, when I met Mr. Rand, initially the engagement was arranged in a way that I have a consulting company in Serbia. So I was for the first a few months, I would say, a month or 2, providing consulting services to Mr. Rand. The agreement when we met was that we agreed on my engagement to manage his Serbian companies, and I asked for a few weeks or a month just to review to do some kind of due diligence of all his Serbian companies, just to make sure what we are talking about before we make the concrete arrangement. And after that, basically we had so he's been paying for my services through my Serbian company, and I was then, I think in August 2012 or September 2012, appointed as a director of Obnova, and also around that time I was appointed as a director of some other Mr. Rand's companies in Serbia. And then in May, I think 2013, I was appointed as a director of Kalemegdan and Coropi. So that's my former role in these companies.
Yeah, can I just clarify? So I think you said, I mean, at the beginning in 2012, when you started working for Mr. Rand, you're working as a consultant. So
This is just the period since we met until I was appointed as a director. So depending on which company we are talking
Okay.
about, but for example, with respect to Obnova, my appointment as a director is, I don't remember the exact date, it is in my witness statement, but I was formally appointed as a director and general manager of Obnova at that time. With respect to Cypriot companies, that my appointment as a director was in May, I think May 2013.
Right. Well, an appointment as a director is one thing, but I mean, the question I had is whether you're an employee of these companies. And I think that's what you wanted to say, then please clarify that you, as when you became director of the companies, you became an employee of these companies.
So I'm not employed in Kalemegdan, I'm not employed in Coropi, and I am currently employed in Obnova.
Obnova. So you're an employee of Obnova. Okay, thank you. You also say in your witness statement, I think that's paragraph 3, that your compensation depends on the profits of the Rand family's investment in Serbia. Is that correct?
It is partially dependent upon the profits, yes.
Yeah. And how big is this success-related part of your compensation in relation to the, well, let's call it ordinary part of your compensation or the base compensation? Is it significant?
We agree that this is in discretion of Mr. Rand, so we don't have agreed compensation in terms of bonus scheme percentages or some specific amounts. So we have agreement that from time to time, Mr. Rand makes a decision to give me a bonus if he seems, he deems fit.
Okay, so it's a discretionary arrangement, I take.
With respect to, yes, to that.
Okay, but would I be wrong to assume that if Mr. Rand, if the claimant side is successful in this arbitration and there's going to be a payout in the kind of amount that you're asking for here, that the claimant side is asking for, that there would be a significant uplift of your compensation then?
I have no such arrangement with Mr. Rand with respect to this arbitration. So this is with respect to Serbian companies and so their performance in Serbia, but not with respect to this arbitration. We don't have any arrangement like that.
But Obnova is covered by that, but not the arbitration.
Obnova pays my salary. I would say that's my arrangement with Obnova. Yes, and I don't have any other arrangement with respect to Obnova with Mr. Rand.
I think that's fair, but my question was more the success of Obnova is part of your compensation, because you say in your witness statement it's linked to the success of the Rand family's investment in Serbia, right?
It is what it says. It doesn't say anything more than that. So it's Mr. Rand's discretion. We don't have any specific arrangement with respect to this arbitration. That's
okay. No, I take that. You're saying it's discretionary, but you're also not saying that if there is a significant win here, that it would not be considered as a success of the Rand family's investment.
I think the discretion of Mr. Rand means that I cannot really answer that question. It may be 0 as well. So I can't answer it differently. It's a discretion of Mr. Rand, but there is nothing that we have on paper or in orally that he owes me with respect to this arbitration. I'm employed in Obnova. I get salary from Obnova every month.
Thank you. That's very clear. Let's go to paragraph 18 of your witness statements. Sorry, that's the first witness statement, of course. And timing-wise, I think you're addressing the time when you were taking up your position with Mr. Rand with Obnova, saying, I've been aware of all developments in Serbia related to Obnova, and that is since my appointment as a director in August 2012. That's correct?
Correct.
So your first days there, my understanding is that Mr. Obradovic was still Mr. Rand's guy on the ground in Serbia who had been running things, including Obnova, before you came in. Is that correct?
With respect to Obnova, no. Not at all.
Mr. Obradovic was not involved in Obnova?
Not involved in Obnova at all. Since I was appointed, I don't think that I ever spoke with Mr. Obradovic about Obnova.
Since your appointment in August 2012, you have not discussed Obnova with Mr. Obradovic. Is that what you're saying?
Yes, I have not discussed Obnova with Mr. Obradovic, maybe some minor issues with respect to employees if they contacted him and he referred them to me, but that would be it. He was not involved in Obnova. I mean, on that kind of involvement at all.
But he was the owner of Obnova, right?
My understanding is that he was the at the time that we are talking about, Obnova's shares were owned by Kalemegdan Cyprus, and when I met Mr. Erinn and Mr. Broshko, it was represented to me that Mr. Obradović is just the nominal owner of the shares, and that the ultimate owner is Mr. Erinn. And I've never had reason to discuss Obnova with Mr. Obradović.
You're saying, and you quite rightly pointing out that Kalemegdan was the owner of Obnova in August 2012, but Kalemegdan was also owned by Mr. Obradović.
So as I said, it was represented to me, Kalemegdan owned Obnova's shares at the time of my appointment, which is something that, you know, I would check in the Central Securities Depository. So this is public information, and it was represented to me that Kalemegdan is as a Cypriot company is nominally owned by Mr. Obradović, and that there is a trust arrangement between Mr. Obradović and another Cypriot company, Coropi, with respect that Coropi is beneficial owner. I mean, I'm not a lawyer, so I'm trying to put this correctly, but that Coropi is a beneficial owner of Kalemegdan, and through Kalemegdan, Obnova.
I understand. That's very clear. I mean, you're saying it was represented to you, and you say that in various places of the witness statement as well, saying I was advised to understand. So, who represented this to you? I mean, who would provide this sort of information? And we'll get to the other information later to you.
This would be first Mr. Broshko. So when I was introduced to Mr. Broshko by a friend of mine and former colleague, we had a lunch together. I had lunch with Mr. Broshko and his wife, and we talked about. He told me about Mr. Erinn's investments in Serbia and about the whole arrangement that he has in Serbia. And after that, we had another couple of meetings. I think this was June 2012. After a while, Mr. Erinn traveled to Belgrade, so I had a meeting with him and also a couple of conversations with him. So when I said this was represented to me, this is what I meant by Mr. Broshko and Mr. Erinn.
Okay.
Also, the documents that I've seen over time, seem to, confirm to be in line with what I was represented.
Thank you. Maybe to make it a bit more specific, I mean, let's take a look at paragraph 13 of your witness statement. So this is describing the situation at Kalemegdan and Mr. Obradović. And towards the end, it says, well, in the middle, it says, Mr. Broshko explained to me and so forth. And then at the end, it says, I was also told that. So when you're saying that, you've been told by Mr. Broshko about this, or Mr. Rand, as you just said. Is that correct?
Correct.
It also means, please correct me if I'm wrong, that you haven't seen any documents with the alleged agreement of Mr. Obradović to follow Mr. Rand's instructions and the like. So unless you refer to a document here, which you not.
I mean, I have seen various documents that confirm what was represented to me, but I can't now, point specific moment in time when I became aware of these documents. So I've been dealing with Mr. Rand and Mr. Broshko for 13 years now. So I don't remember exactly when, but I'm familiar with documents with respect to that ownership structure that Mr. Rand has in
Thank you.
Companies.
Well, let's make it specific. Maybe that's easier. So let's take a last sentence of paragraph 13. It says, I was also told that Mr. Obradović agreed to follow Mr. Rand's instructions related to Kalemegdan, and as a result, Mr. Rand had control over Kalemegdan. So you're not referring to any document here. I assume that there is no document, or at least you are not aware or have not seen a document.
At this time that I'm talking to, so I'm saying here that I was told this by Mr. That this was represented to me. I think this is what the statement says.
And just looking at a similar statement in paragraph 11, which says, before my appointment, so you're talking about yourself now, I agreed to always follow Mr. Rand's instructions in respect of these companies.
Yes.
Is that an arrangement that you formally entered into?
This is what we agreed on our meetings in Serbia, and I always acted in that way. And This is, yes, this was the arrangement from the beginning, from our first meetings, and Mr. Rand's decision to engage me.
Okay, but there's no written document where you're writing, dear Mr. Rand, I agree to always follow your instructions, whatever it would look like.
I would have to, refresh my memory with respect to Cypriot companies when I was appointed as a director, if I signed such a document. If I did, it's surely on the record. I just have to, I can't remember on the spot. In any event, I always acted in that way.
Okay. And similar point, and really just confirming in paragraph 13, when it says Mr. Broshko explained to me that Mrs. Rand and Obradovic had been long-term business partners, and Mr. Obradovic held the shares in Kalemegdan for the benefit of the Rand family. That is what Mr. Broshko told you. You haven't
Correct.
seen a document or anything which confirms this.
As I said, I've seen documents, but I don't know exactly at what point. But I'm here talking about my conversations with Mr. Broshko and how he represented this to me.
Okay, sorry, Mr. Mankiewicz, but just to be very clear, I mean, you said this is what Mr. Broshko told you, and then I've asked you whether you've seen a document, and I said you've seen documents. So do you have seen a document for this or not?
Just let me read exactly what you have.
So it's paragraph 13. It's Mr. Broshko explained to me that Mr. Obradovic held the shares in Kalemegdan for the benefit of the Rand family.
Yes. So I have, at that time or around that time, I would, yes, see the documents with respect to Cypriot companies and the arrangement between Coropi and Mr. Obradovic.
Okay, what document are you referring to? What does it look like? What does it say?
So I'm talking about trust deeds, and if I mean, I would rather have documents and comment in front of me than trying to do the memory test. But I remember that there is there are trust deeds. Please just let me finish the answer.
Let's put C66 up, because I think that's what you
so
probably mean.
This is one of the documents. Yes,
that's the document. Okay, was there any other document?
There is another trust deed.
Another trust deed, yes,
from August same year, and I remember there are letters. There is a letter from Coropi to Kalemegdan, always follow instructions, but I don't.
The letter of instructions.
I don't want to try to paraphrase the documents.
Can we put the letter of instruction up just to make sure we're talking about the same documents? It's C319, I think. Just 1 second, just so that we're clear that we're talking about the same thing here. Is that the document that you're referring to?
If you can just please.
Yeah, sure. Take your time.
Yes, this seems to be the document that I'm talking about. Is instructions to always follow instructions. Yes.
Okay. Very clear. Thank you. Staying in the same ballpark in terms of issues, but just want to run through a bit through the management structure here. Paragraph 11 of your witness statement, if we go back to this, please. Saying you appointed a board member of several of the companies, but it includes Obnova and also includes Kalemegdan then at the later stage, right?
Just to check what time I'm talking here
Yeah,
about.
sure.
Not Kalemegdan. It was not at the same time. So Obnova was earlier. So as I said, Obnova was August or around August 2012. Kalemegdan was later.
It was a bit later, yes. Okay, thank you. And we already discussed that you said, I mean, you would always follow Mr. Rand's instructions.
Correct.
And in this sense, and then we've also already discussed with Mr. Obradovic would also always follow Mr. Rand instructions.
Is that a question?
No, I mean, just we discussed it earlier. So then let's now go back perhaps to the exhibit that we just looked at. It's exhibit 319, I think we established, right? The letter of instructions. certain level of instructions, if you will. So you agreed to follow Mr. Rand's instructions. Mr. Obradovic agreed to follow Mr. Rand's instructions. And now we have this letter. Maybe if we scroll up so that we can see properly who is writing to whom here. So that is Coropi, and Coropi is writing to, correct me if I'm wrong, but the other directors of Kalemegdan.
I mean, this is document before I was engaged, so I'm not sure that I can help clarifying it
That's
much,
fair enough,
except for
and-
reading what is on the document.
Well, you can see it says directors, and you can see the names. Are these the directors of Kalemegdan? I mean, you're a director as well.
I was not director at the time of this letter, no.
But do you know these persons that are mentioned here?
I mean, I'm now thinking about, because directors changed over time, so I met and I worked with Christodoulos Michaelides. I think I worked with Xantos Sarantis and Petros, I'm not sure. So he was replaced with another director at some point, probably early. So I don't know if this was exactly after I was appointed or a little bit before that, but I was the most often in communication with Mr. Christodoulos Michaelides after I was appointed as a director. Yeah.
So you worked with the first two as directors of Kalemegdan, and the third one you were not entirely sure.
Yeah, I would have to refer. I mean, we can. The register of directors is on the file, and there are dates, specific dates where everyone was. So they changed over time. I cannot really now remember when exactly who was. Mr. Michaelides was there from the time that I was appointed, and for a long time after that. So I dealt with him the most.
Yeah, and just to be sure, because you said you don't know, but you in your witness statement, paragraph 14, you're saying that Coropi issued a letter of instructions to the Cypriot directors of Kalemegdan, right? So this is a letter that we're looking at.
I'm referring to this letter, yes.
So I assume it's correct that these are the directors at Kalemegdan at the time. That's at least your statement.
I think
here.
if compared with the register of directors of Coropi, which is on the file, that can be easily determined.
And this letter says, I mean, look at it, but also in your witness statement, you summarize this to saying that no decisions and resolutions shall be taken regarding Kalemegdan without obtaining permission from Coropi. You aware of that?
I mean, again, this is document from the time before I was appointed. So I would rather not, and I'm not a lawyer, so I can read if Serbian counsel insists what is written on the page, but I would rather not comment if I don't have to on a document from the time before my engagement.
Okay, I would normally have a lot of sympathy for that, but you addressed exactly that point in paragraph 14 of your witness statement. I've just read to you what you yourself said in that witness statement. So I assume you've read the letter before. And I
read the letter, yes, and I can read that sentence now. It's fine. I'm just saying I cannot interpret, and I would rather not interpret and analyze the letter from the time before I was.
Okay, well, let me put it differently, and I think that's what you say at paragraph 14 at the end. I mean, in practice, this letter was also followed, right? I mean, you say, to my knowledge, the directors have always acted accordingly and followed any
I can
instructions.
confirm that part that was followed, yes.
So it seems to be still in force. This is what I take from that. That's why I wanted to discuss it with you. Thank you, Mr. Markic. So there's these instructions that we discussed now between you and Mr. Rand, Mr. Obradovic, and Mr. Rand, and the directors of Kalemegdan and Coropi. And then in your witness statement, paragraph 15, if we just scroll a bit down here, you're saying that Coropi was and still is owned by the Ahola Family Trust. It's told that the beneficiaries are Mr. Rand's children and so forth. And then saying that the trustee of the Ahola Trust will also follow Mr. Rand instructions. So Mr. Rand controls Coropi, is that correct?
This is what was represented to me, yes, by everyone involved. I met Mr. Jennings. He also represented this to me. Mr. Rand and Mr. Broshko always represented it to me. So I never seen anything in documents or in behavior of Mr. Jennings that would suggest otherwise.
Okay. Let's talk a bit then about the Cypriot directors. you already referred to them. So Kalemegdan had 3 Cypriot directors. Is that correct? Or still has, I assume, 3 Cypriot directors?
It depends in what point of time we are talking about. So the number of directors and the persons who were appointed as directors changed over time. So if you are asking about specific point in time, then I think we will have to go to the register of directors to.
Yeah.
to
So
discuss.
what is the setup now? I mean, who's
With respect to Kalemegdan side.
yes, Kalemegdan.
There are 2 directors. One of them is myself, and the other one is a legal entity, Cypriot. A legal entity. I understand this is in accordance with Cyprus law that a legal entity is appointed as a director of another legal entity, and then basically I deal with the director of that legal entity. So when we make decisions with respect to Kalemegdan, I communicate with the director of that company.
And who's the legal entity?
The name is Salos Nominis Limited, if I pronounce Greek correctly.
And they have then people working for that entity who you're dealing with, essentially on the administrative tasks.
Yes.
Okay. And before that, if we go back to the time of the restructuring, which is 12, soon after you came in, who was the director then? Or who were the directors then, to be very precise?
So it's just to clarify, when I was appointed or before?
When you were appointed, when you came in.
When I came in 2013, it was Christodoulos, with respect to Kalemegdan Cyprus. So it was
talking about Kalemegdan, exactly.
Christodoulos, Michaelides, it was me, and it was one. So I dealt with Kyriakou, with Christina. It's Greek names are sometimes difficult to. Xantis, and I think there's another person. So I don't remember exactly. So I know that Christodoulos, Michaelides, and myself were directors, and there were another 2 Cypriot persons also as directors of Kalemegdan.
And then they were all from that company that back then assisted you in the management process, which HLB?
No. This is this company that I mentioned, this Salos nominees. This is when Mr. Christodoulos Michaelides retired about a year ago or so. Then this change happened. So until that time, it was always physical persons as directors. So at the time, it was 3 Cypriot citizens, nationals, and myself, who were directors of Kalemegdan.
Thanks for clarifying. No, that was I didn't want to imply that there was an entity before. I was just saying the 3 Cypriot directors earlier. I mean, how were they appointed? So who chose them?
How were they appointed?
Yeah, who chose them?
Well, they were appointed before me. I'm not sure how they were appointed because, at the time when I arrived, but now this is a legal question. I believe that the owner of the company appoints directors in Cyprus, but this is matter of Cypriot law, so I would rather.
Do you know whether they worked for HLB?
I don't know if they worked for HLB.
Okay. Well, let's take a look at your second witness statement. I think that's paragraph 16, where you talk about the management of the company. In particular, the involvement of management of the Cypriot directors. You say that this involvement included preparation of financial statements and tax returns. Is that correct?
Yeah, with respect to financial statements with Cypriot companies, that part of the work is done mostly by Cypriot directors. And I mean, I would not know how to prepare those financial statements, but we have discussions, and when they prepare drafts, they would send them to me. We would have a few rounds of discussions usually, and then financial statements would be filed, and then after that, tax returns would go through the similar process. But this is matter of Cypriot accounting rules and tax regulations. So I'm there just to ask for clarifications and to try to understand what is being filed.
And were the Cypriot directors in any way involved in the decision-making process, in particular also with Mr. Rand?
So in the particularly,
The decision-making process, including to the extent the decision-making process involved Mr. Rand and actually making decisions about, I don't know, starting court proceedings, choose any sort of management topic on the ground with in relation to Obnova.
Mr. Rand is not director of Kalemegdan in Cyprus, so he is not involved in the decision-making process with respect to Kalemegdan's decisions. And if it then go to Obnova and Kalemegdan making decisions with respect to Obnova, participating at shareholders meetings, that's not Mr. Rand is director of Coropi, but he's not director of Kalemegdan, and he's not involved in day-to-day management of the company. So I would not say so.
You said he's not involved in the decision-making process, but we just established a few minutes ago that he controls Coropi. Coropi controls the Kalemegdan directors by letter of instruction. So they were not allowed to do anything actually without permission from Coropi, which in turn was controlled by Mr. Rand.
I'm not a lawyer, but I make distinction between control and management. So you asked me about management, and I said
No, I asked about decision-making.
Decision-making is made both on management and control levels, I would say, as a non-lawyer. So what I was saying is about a decision-making process in the process of managing of the companies. And when I say that, I mean directors of the companies, management of the companies make those kinds of decisions. Just to make a few examples, for example, on level of Obnova, if I have to decide to pay electricity bills today or next week, that's a decision to be made, and I'm certainly not involving Mr. Rand in that kind of decision. And if we are discussing on some very strategic decisions, then Coropi, Mr. Rand is Coropi's director, and through that position, I believe that we can say he controls what Kalemegdan does. But I don't see that as a management process. I just can't conflate the two things.
Okay. In paragraph 21 of your second witness statement, you say that the Cypriot directors were also heavily involved with respect to commencement of this arbitration.
Sorry, which paragraph I missed it with?
It's so I thought it was 21. It might be 19. Let me just double check. Second witness statement. No, it's 19. 19 of your second witness statement. And then you're saying the Cypriot directors, so I'm paraphrasing, were heavily involved in respect to the commencement of the present arbitration.
Yes.
So what does heavily involved mean? What decision did they take when heavily involved in?
It means that they asked me to keep them in the loop, to discuss documents, basically they were involved in they wanted to know all the details basically of the claim that we are considering pursuing in the arbitration. And I had a lot of calls and emails exchanged with the Cypriot directors, the Kalemegdan directors, basically when I asked them that we need certain approvals and signatures to commence this arbitration, they were very, to say, put me under a lot of scrutiny. They wanted to understand all the details, what was being done before they agreed to give a green light.
So that's the document that we're referring to there. So it's 3 email chains, I think, C717,
As I said,
C718, and
also a
719.
lot of calls, video conferences, and so this is something that they were really, to say, really curious about, to know all the details before we make this decision.
Okay, you said you did discuss documents with them. Which documents did you discuss with them?
To what paragraph you're referring to?
No, it's something you just said 2 minutes ago. You said they wanted to discuss documents with you. They wanted to know all the details.
I mean, with respect, so we were talking about Obnova and Obnova's properties in Belgrade, and what happened over the last many years, and basically what kind of rights we think Obnova has, and how the whole arbitration process goes, and so basically all of that.
They asked you questions what the claim is about,
Of
essentially.
course,
Yeah.
yes, of course. I mean, in my capacity as a non-lawyer, that I was, able to explain to them. I'm not saying that we were discussing legal arguments that we have, from the arbitration, but the whole point is that we were going to pursue a claim in arbitration, and they wanted to know what is it about, what Obnova rights we claimed to have, and how this goes in arbitration, how much it costs, etc. So this is.
Is there any record of that discussion or of these questions?
But the record is several emails, I think, that are on the record, and as I said, many phone calls and video conferences that we have. I mean, it's not that we.
Okay, and who decided to initiate the arbitration?
On behalf of Kalemegdan, it's all directors of Kalemegdan. We agreed to approve this process, and whatever documents were needed to be signed were signed. And then on the level of Coropi, it was Mr. Rand and myself and the third director, who is also Cypriot director. So I understand both companies need to.
When you say
sign
it's
the
a
paperwork.
directive of Kalemegdan, we agreed to approve this process because the process was an instruction by Mr. Rand.
So, can you repeat the question?
No, you said just a minute that in response to my question, who decided to initiate the arbitration? You said on behalf of Kalemegdan, it's all the directors of Kalemegdan. We agreed was probably said who agreed to approve this process. So where was this coming from? It was coming from Mr. Rand or from Mr.
It was
Broshko,
coming-
perhaps?
Yes, ultimately, the decision is coming from Mr. Rand, but to say, formally on the management level, it is required that the directors sign the decision. So it's, for example, Mr. Rand could not have signed the decision on behalf of Kalemegdan to commence the arbitration procedure because he's not a director. So it was needed to be done by the Kalemegdan's directors.
I understand that, but we looked at the various instruction letters and confirmations to follow Mr. Rand's instructions. So would it have been possible for them to disagree? Say, I do not agree, I don't follow the instructions here?
I think that is a legal question, matter of Cypriot law. I cannot answer to that. If it's possible to, it's a legal question.
Okay. Let's take a look at the documents you say that on the record show the heavy involvement of the directors. So the first one is C717. That's an email chain between someone working at HLB and yourself, Mr. Markicevic. So if we go to page 5 of this PDF, just to see how it all starts. It's an email from you, December 2020, saying the arbitration lawyers request an excerpt from the register of companies for Kalemegdan and Coropi, considering that we have very limited time to prepare filing, what would be the quickest way to do this. And then we move up a bit. And that's HLB replying. Who's that person? Agati Giorgio? Who's responding to you here?
Legal associate of HLB.
So it's not a director.
It's not a director, so but this is also not the person that I addressed my email
Okay.
to.
No, fair enough. We're just establishing who we're looking at here.
I believe in their office, someone refers the email to someone to respond to me. That's I think that is
Okay, and
nothing
that is
unusual.
at HLB Cyprus, right? So that's a company providing these administrative services. Okay, if we move further up, perhaps. And again, you're asking, and I think this time it's the same person,
Yes, since she's-
for
yeah.
up-to-date corporate registers, right?
So I send email to one person, another person responds to me, then I respond to that email. So yes,
That's-
this is my, yeah.
5 months later, so a bit of back and forth obviously going on in the background. And let's just move up so that we have the full overview here. And here's the topic of discussion moves on a bit. This time it's POAs. You're asking for them to be executed.
Yeah, this is the correspondence that would follow the discussions that we have. So well, after we have calls and discussions about this, I would send them an email or their assistants or whoever person they appoint to deal with me on that matter. Then I send the documents that need to be signed. But discussions also go to the over phone call and the video conferences. Yeah. So
Okay.
this email chain follows the discussion, obviously, that about the documents that need to be signed.
Right. So, but I mean, you said earlier, I mean, there's documentation of the heavy involvement of the directors.
Mhm.
And what I see is a correspondence and exchange between the services firm and you about POAs, about formalizing things, about providing documents, but it's not documenting a discussion, a heavy involvement. That's why I'm putting this to you, because you said this is the documentation that exists.
But if I can comment, you showed me a couple of emails from an email chain, which I don't think is the only email chain that
Well,
I
we can look
provide.
at the others. We're very happy to. Do you want to look at the others? No, let's look at the other
I
other
don't.
email chains. That's 718 is the next one. And I think we should probably again start at the bottom. So say register of companies again. Maybe we can move up. Please say stop anytime. If there's anything particular you want to point
I
us
would
to.
just ask a little bit slower to get the chance. Is this the same?
That's 718. We've looked at 717 before.
So this is, for example, these emails are, I'm asking them for documents that that are needed for the arbitration process, get access
Exactly.
from the register, etc. So this is not exactly the decision making that I was referring to. This is.
But is
asking
there
for
anything in
documents.
there that you want to point us to, which would show the decision making?
If you're asking me to do a memory game, I can't do that. If you
It's
would-
your witness statement. It's your evidence, really.
If you can take me to my witness statement, I'm sure that I refer to a document that I.
Well, we've
that
just looked
I-
at it. We can look at it again. It's paragraph 19 of your witness statement.
Okay.
Sorry, the second one. Yes, thank you. So these are the documents that you refer to here. And if you go up to the witness statement again, so that Mr. Markicevic can see that, this is where the reference is
You
to
also
be
inquired
found.
about the cost of it. This is about the cost and.
Yeah, and
we
the
can-
paragraph with the heavy involvement is just above. It doesn't have a footnote. It doesn't refer
If
to
you can
any.
give me just a second to read.
Sure. Take your time.
Okay, I'm happy if you want to go through the emails that I referenced here. I'm happy to go through
So we could go back. So that's we've looked at 717. We were just looking at 718.
Mhm.
Scroll up again, but I'm very happy for you to point me to whether there is anything. It's a corporate register. it's a
Perhaps you
POA.
should just let the witness have a look in his own time. That it's quite a long email chain, if he would like to do so.
I mean, I wouldn't mind to go through the email chain and
If you
then comment.
just direct counsel as to when you're ready and read it from the bottom so
Okay.
that you're familiar with it.
Thank you.
Counsel, could you
But-
just make sure, counsel, could you make sure that the witness can read at his own speed this email, please?
Yes.
Starting from the bottom.
And we can start from the first email in the chain. I would suggest if this is okay with the tribunal that we go one by one and I can comment or to go through the chain.
Up to you how you'd like to respond to the questions. I just want to make sure that you have an opportunity to refamiliarize yourself with the email.
Okay, we can go to next. Okay, next. Okay, next. Okay, next. For example, this email says that they revised the powers of attorneys, and I remember we had that discussion, which went back and forth for a while let's say, have everyone agree, these Cypriot directors with our counseling in arbitration to agree on the text of the powers of attorneys. I don't know, remember, it was some legal terms that I cannot comment on, but this was one of the, to say, lengthy discussions that we had.
So this is one of the examples of the kind of.
This is one of the
Okay.
examples of those discussions.
Thank you.
But
Then
I understand that I'm supposed to go through the entire chain to answer completely to the
I
question.
think I would, in
that
the
is
interest
fair.
of time, like to move on. But of course, if there's more in the chain, I mean, I'm very happy for Clemens Counsel then to take you to that because I only have 30 minutes left.
That's a matter for you, Mr. Keller. If you want the witness to address this fully, then, you know, ask away on your time. It'll be a matter for Claimant's Counsel whether they want to redirect on this.
I mean, if I can comment, I feel that this question is not answered fully if we cut it off here, but I'm.
Okay, well, it's for Claimants Counsel to come back to that. I mean, we have a number of issues to cover on my time. So, because you were involved as essentially the man managing Obnova on the ground then, after you've been appointed to. And you said earlier when we were discussing Mr. Obradovic that you essentially had no significant contact with Mr. Obradovic in it because he was only normally
With
the
respect to
shareholder.
Obnova, yes.
And then you say in paragraph 18, we already looked at that, you've been aware of all developments and relevant information in Serbia related to Obnova. So how specifically did this happen? How did you make yourself aware of this? If it's not Mr. Obradovic, I mean, what happened so that you get full control of Obnova?
I'm not sure I understand what exactly. So you're asking me.
Well, you're
how-
hired by Mr. Broshko. You take up your job. You're saying it's not Mr. Obradovic who was briefing you, was running the show, but you were taking over. You're managing the company, right?
Mm-hmm.
So something must happen. You must have gone through the archives, spoken to people. So how did you inform yourself?
How did I inform myself? Okay. So as I said, when I met Mr. Rand and Mr. Broshko, I got certain amount of information about Obnova from them. But I also met with the lawyer. I think his name is Dragoljub Jankovic, who is a former Minister of Justice in Serbia, and I understand that he represented Mr. Rand and his companies in Serbia at that time. And I mean, I've heard about him before, but I was introduced to him by Mr. Broshko, I think. And I had a few meetings and conversations with him with respect to Obnova and other companies. So he was dealing with property issues, with litigations of these companies. And this is what he told me about specifically Obnova in these locations was in line with what I heard from Mr. Rand and Mr. Broshko. And then after that, I think some months after I was appointed, we engaged a woman, her name is Gordana Kostić, who is a very experienced person in Serbia who dealt a lot with property issues for some other companies that went through privatization process. And we tasked her with a very tedious task of going through various city archives and government archives and basically mining work, getting documents with respect to Obnova's property. So over time, more and more documents came in that say improved the knowledge and the view of this matter.
And this work with this Ms. Kostić that was going on then from some time after you came in?
It started sometime in 2013, I think, maybe first half of 2013, and went on for years.
But you were not provided when you took over with a set of documentation by Obnova, the company's archive, something like that. There was no documentation at the company?
There was documentation. So, I mean, now we have many documents on the file, and I don't remember exactly which document, when and where it came from, but there was definitely a certain amount of documents on the file when I got appointed, but also what I'm saying over time. So we got some other documents from the various archives that we didn't have. Also, there were some, for example, copies of certain documents. We didn't have originals. Then we went through the tedious process of getting certified copies from the archives of those documents. So in Serbia, it's a very lengthy and exhausting process, but this was done, and the goal was to say put and get as many pieces of the puzzle as possible and put them together.
Okay. I mean, did you find out yourself, or did someone tell you that at the time when you took over, the city was already registered as the owner of the plots that we're talking about here in this arbitration?
I don't remember when and how I exactly found that out. I can't recall.
Were you aware that?
I'm not even, so this is, I know that at some point government was appointed, Serbia was appointed, and city as the user, and then city as the owner of the, so I don't exactly remember the dates, and but I'm happy to discuss, to comment documents if you show them to me, but it's I cannot recall exact point in time when this was discussed.
Well, let's take a look at it. It's exhibit R54.
Mhm.
And see whether that's something that's you're familiar with. That's a decision. That's just to know that we have the dates right. So that's 12 September 2011.
If I can ask you just to show me the Serbian version
Sure.
first, and then we can go back and discuss. So it's easier for me to recognize.
Here
the
it is. Would you know this document? Would you have seen that, or would you have been
document.
told about it?
Scroll down, please, if I can.
Sure.
Is there anything with respect to Obnova's properties on this document? I don't. I mean, it looks like a certain cadaster's decision, but I will have to see exactly what, if you can refer me to the part that is
Okay. With respect to-
relevant for Obnova, I may remember it.
Well, there's a lot of parcels, of course, but I mean.
I mean, I see land plot cadastral numbers, which are something completely unrelated to Obnova.
Okay.
So it's a long list. So
It's a very long list.
Yeah, a long list of certain land plots, and none of them so far, what is on the screen at least, is Obnova.
Okay, but you don't remember seeing a decision saying that the city is registered as the owner, or maybe not the decision itself, but someone telling you that the city is actually registered as the owner of the plots? Whether it's towards the end of 11 or at some other point in time.
Yes, some around that time, I think city was the user. If I understand correctly, before that moment, Serbia was the owner, city was the user, and at some point, moment, and again, as a non-lawyer, I remember that in Serbia generally that some regulation changed, and that basically that that ownership right was moved from the government to the local authorities. But I cannot say that this document has anything to do with that unless I see.
Okay.
I mean, I'm just looking at the long list of cadastral land plots.
I appreciate that, but I think in your second witness statement, you say about the same point about registration was seen as a non-issue. You just said you yourself is not a lawyer. You're not a lawyer. So what brings you to saying it was a non-issue? So you manage to have a company, which is, as we've heard today, mainly the value of the company is in the real estate, allegedly. That company is not registered at all. But it's 2003, Serbia and the city of Belgrade, and this we looked at in 2011, it was a city that was registered as the owner. That seems to be an insignificant event for that company.
As someone who lives in Serbia and was born and raised in Serbia, again, I'm not a lawyer, but registration in the cadastre, I don't think that anyone in Serbia sees it as assigns it too much weight. So I have some personally in my family, some assets that are registered 5 or 10 years after the actual transaction happened. I worked in another Mr. Erenn's company where for decades some properties were wrongly registered on someone else's name. So this is generally, and I was advised this by lawyer Mr. Jankovic when I was talking to him about Obnova's properties, and I think it's a well-known fact in Serbia that unregistered ownership is something that is not uncommon in Serbia at all, and that the registration of Obnova's rights over the land and buildings are a matter of certain procedures. And
I take
this
that,
is
but
what-
you appreciate it's a bit of a different situation. It's not only that they're not registered, but that there's someone else is registered, and that was 2003, and then in 2011 they're actually confirmed as the owner.
But I'm responding exactly to that. I think I understood your question. So I'm not saying that the buildings are not existing in the land in the cadastre. I'm saying that the owner, that it is not uncommon situation that what the cadastre says about who the owner is. I mean,
And
someone purchases a property with the sale and purchase agreement, files for registration in the cadastre, and they wait for 10 years sometimes to be registered. So it's, and I understand, from discussions with lawyers that there are court decisions on very high level that say that unregistered ownership is very well recognized concept in Serbia. Again, as a
and you're saying,
non-lawyer.
sorry, you said, I think 2 minutes earlier, that this based on input from this Mr. Jankovic, is that correct?
Starting with my conversations with Mr. Jankovic, also, my lifelong knowledge and experience in dealing with the things in Serbia and reading news articles. And I mean, generally, I think this is very well-known fact, unfortunately, that cadastre is not very reliable.
And as a manager of the company, did you then decide to get any sort of legal opinion, advice on a strategy to make sure that the rights would be registered and that the situation would be resolved?
I don't remember getting a legal opinion. I had many conversations with Mr. Jankovic and later with other lawyers, but I don't remember having it in writing. But I'm not sure that there is a lot of strategy to talk about. It's you have certain documentation, and you are supposed to, if the government, if they do their job, they are supposed to acknowledge your rights and register your rights.
Well, they might need to know about it, right? So you might need to do something about it actively.
There's then again a legal question, and as I said, I don't remember getting it in writing, but what I can say that we did everything we could to move in that direction.
Okay, let's take a look perhaps at Exhibit C337. That's an email discussion.
Mhm.
Very precise. It's an email by Mr. Broshko to Mr. Rand, and it's copying you, September 2014. Do you know this email?
If you can
Sure.
scroll down a little bit. I think I do, but this first part of the email is not related to Obnova.
No,
so I
there's a
think, yeah.
smaller part. We can show you this.
If
the
you
part
can,
related
yeah,
to
show me the
Obnova. Can
part
you scroll
about
down,
Obnova.
please? I think that's the Obnova related part.
Yep.
Do you know the email?
Yes, yes.
Have you drafted that email?
Together with Mr. Broshko, I believe that I mean, it would be usual that if it's about Serbian matters, I would do the draft, and then we would have some back and forth revisions before we discuss it. And either Mr. Broshko or I would send this to Mr. Rand, or we would have a call about it, or we would have show it on the screen to Mr. Rand. So this would, I assume that I think I drafted this together with Mr. Broshko.
Thank you. Maybe if we start looking at the larger paragraph, which starts with large parcel, and then towards the end, It says, I read it out to you, but you can also read on the screen. Obnova has a number of ongoing lawsuits with creditors from the previous years. Most of them sooner or later end up in an attempt of foreclosure. When the creditors realize there's no registered property, they give up and stay in line on the blocked account. We could submit papers to register ownership, but there would be a significant risk that someone initiates the foreclosure as soon as the property is registered. The way I read it, but please correct me if I'm wrong, suggests to say if you were to register ownership now 2014, whoever drafted this, so you said that's you saying there's a real risk that immediately it would be seized by some of the creditors of the company. Is that correct?
Well, so we need to see the whole paragraph. So
Please.
the paragraph starts with, we have the building permits dated from the 40s and 50s, which are sufficient to register the ownership of the buildings. So I think this fairly represents what we had, what was our understanding at the time about Obnova's rights. And the land is owned by the city of Belgrade. Obnova has the right to use it. That was correct at the time. So Obnova had the right to use in 2014, and the land was owned by the city at that time. And with respect to the with the last part that is highlighted, this is giving. So if I'm correct, and document is on the record, we soon after this we filed for registration of the property. So this is giving Mr. Erinn basically heads up. Look, we are ready to file for registration. We expect that it will be registered. You may have to deal with the creditors once that happens, and that's the message that we were trying to convey here.
When did you file?
Sometime in 2015, if I'm not.
In 2015. You know that Mr. Erinn acquired the company in 2005?
Yes.
Is there any reason why he would wait 10 years?
Well, I cannot speak to the time before I was appointed, but as I said earlier, when I was appointed, we engaged a person basically to do the discovery of the document. Discovery, I don't know if that's the correct term, but basically to go to the archives and get everything. I know that we had some back and forth discussions with the legal department in Cadastre where they said, okay, you have only the copy of this document, we need original or certified copy. So that process took a while until we felt that we are ready to file, which was around this time or a little bit later. I think it was filed. So it's a process, and I see this paragraph in line with that.
Okay. And you say, I mean, you already referred to that at the beginning of that paragraph, saying the land is owned by the city of Belgrade, but Obnova has the right to use it. What was the basis for, if you drafted that, for your statement to say that Obnova has a right to use it?
This was the what was in my mind based on all discussions that I had with lawyers since I was engaged with Obnova. So,
but there's no
all the
particular...
time in my mind it was
Sorry,
presented to me that Obnova has the right to use, and this was continuously in my mind, including 2014.
And did they ever mention what the basis of this right is?
Legal question, but my understanding, I can just say my understanding is that it's based on the fact that Obnova built its buildings on the location. It was, if I understand, the person, the investor who builds the buildings has the permanent right to use over the land. That was the case for a long time before I was appointed.
Thank you, but that means you haven't seen any document or evidence that says by any authority or something like that, which says Obnova has the right to use the land.
My understanding is that this right is based on the fact that Obnova built the building.
Thank you. Let's move to another document, and that is R27. So that's a judgment of the commercial court in Belgrade, as you can see. It's dated 4 October 2012, so it's after you took charge of the company.
Yes.
Happy to go through. I think we need the English version for our benefit, but we can show you the Serbian version that you can see the document in its original form. Is that a document that you're familiar with?
I am familiar, yes, with this document.
So these are court proceedings between Luka Belgrade and Obnova on the basis of the lease agreements dating in 2006. And if we scroll down a bit, I mean.
Sorry, I didn't understand what the lease agreements.
So one step at a time, maybe show me. So it's
Can you show me that?
court proceedings between Luka Belgrade and Obnova. So this is what this relates to. And they're based on lease agreements from 2006.
I don't,
I think
where
we
is
can
that?
scroll, we can show you, I mean, if we scroll down. So I think here it is. So can we highlight that perhaps? It's easier to read.
I see agreement for providing and using portable warehousing services.
Yes, exactly. Agreements from 2006. And the
I'm
court
sorry,
found,
Mr. Keller, could you just draw attention to which page it is? So we will be able to find
I
it.
think
again.
it's still on page 1 of the PDF, or maybe we can scroll up. Yeah, it's on the bottom of page 1 of the PDF.
Thank you.
And the substance of these court proceedings was that Luka Belgrade demanded the payment of rent from Obnova.
That is not my understanding.
So we can, well, let's look at it. So we see from the content of the agreement, the court determined that the agreement was entered between the claimant and defendant, that the agreement parties covered mutual rights and obligations related to the use of warehousing space for storage. And so far as on the part of the cadastral parcel 47, the agreement stipulated a fee for using that space that was determined in the price list, and then you have square meters and euros. You're saying this is not rent?
This is not, it says fee and it's not, I mean, I've used warehousing services.
It's a fee for usage of a warehouse.
Of warehousing services, yes. It's
You
not a
wouldn't call
rent.
that rent.
I don't call that, definitely not a rent.
Okay, well, let's not be hung up on terminology, but they're using a warehouse and they're paying for it.
And that is not, so they are not using the entire, so just to give context, for example, I worked in agricultural company also owned by Mr. Rand. I think it was mentioned in this arbitration, BD Agro. And we produced thousands of tons of wheat and corn and soybeans, etc. We used storage services, like in this case, or warehouse silo services. We didn't rent the silo. So we use service, which means that when I deliver the wheat, silo needs to accept it and keep it for a while until I take it back. So warehousing is not, for me, I mean, I'm not giving legal analysis of this, just from my experience and doing business in Serbia, I think anywhere is the same. So warehousing means that a certain entity needs to provide to me a certain space when I need it to store goods. Today maybe here, tomorrow maybe in some other corner of their warehouse, but that's not renting the warehouse. It's using warehousing services. I mean, in my mind, this is very different than the rent.
Okay, well,
renting.
let's take a look at what we had in front of you, shall we? So, I mean, it says it's related to the use of commercial warehousing space for storage and yada yada. So you're saying that's wrong? It was not for the use of a warehouse?
I think I just explained. So you use, if there is a warehouse, the entity that provides warehousing space is obliged to when you need it, provide a certain amount of warehousing space. And it does, at one point in time, it can be in one part of the warehouse or another part of the warehouse, but I'm using warehousing services, which also include handling of the products or whatever is the subject of the agreement. Or maybe in our case, for example, in silo, when we stored wheat and corn, there was a service of drying if it's too wet, or the spraying with pesticides. So those were the kind of the agreements that looked pretty much similar to these agreements that I see between Luka Beograd and if I can add that it just, I think this needs to be put in the context. Where was Obnova located and where was Porto Belgrade located, and who had what kind of infrastructure and who was engaged in what kind of activities. So if Obnova at the time did the scrap metal business, Porto Belgrade was near. And it seems logical to me that Obnova used transport and port and handling services, transport services, open warehouse space, etc. And when I see these these agreements and how they are structured. They mentioned some infrastructure that is non-existent and never was existent on Obnova's facilities. So it just doesn't make sense to refer to it as a lease.
I think I've let this run on. I know that counsel for the claimant wanted to presumably make an objection.
Thank you, Mr. Chairman. I just wanted counsel for Serbia to establish, because several questions use the word warehouse. I don't find that word in the highlighted text.
Mr. Broshko, I think that, again, that's something for the witness to say to counsel. Could you please clarify? The rest of it is argument for you.
Okay.
Mr. Keller, once you finish this line of questioning, I'd just like to ask your views on timing, because we're
Of
running
course.
quite late.
So we meant, thank you for the explanation and your take on these agreements, Mr. Markicevic. And maybe that's was a good cue from the president on time. I wanted to discuss the 2013 DRP with you, which you address in paragraph 24 of your first witness statement.
I'm sorry, Mr. Keller, before you move to that, could you please give me an indication whether you think you are likely to end in the next 10 minutes or so, in which case we'll run on. But if it's going to go on much beyond that, then we will hold over until tomorrow morning.
I don't think so. Maybe not 10 or rather 15, I would say, would be my estimate, but it's not going to go on.
Let me look at all concerned, including the court reporter, if we run on for another. I mean, there will, of course, be redirect. There may be tribunal questions. So I don't want to find that we're sitting beyond sort of 7 o'clock and it's been a very long day for everyone.
Certainly not on my behalf.
Sorry?
Not on my behalf.
Okay, then please go ahead.
So, which I said why it was important to you now to move on to the 2013 DRP, which I wanted to discuss with you, Mr. Markicevic. So that's in paragraph 24 of your first witness statement, if I'm not mistaken. Let's go to that. Where you say the adoption came as an unpleasant surprise to me because I had not been aware of its preparation, correct?
That's correct.
So from that I take, but please confirm that no one told you about an exchange in 2008 between Obnova and the planning authority in relation to the bus loop.
I was aware of that exchange. If you're referring to the letter to Obnova it's probably better to have it on the screen if that's not a problem. I was aware of the letter from Obnova to the city saying something to the effect, please make sure that that we are here and that you have in mind that this is commercial residential area or something like that. But I would rather have a document.
So that was
On
the
the
letter I was asking you about, but also more generally, you're saying that I had not been aware of its preparation, but then now you said you were aware that there was a letter in 2008 about the bus loop. That's correct.
But those are two different things. So one question is, was I aware that in 2003, if I understand you correctly, in 2013 there was a plan, right? So
Yes,
was not.
whether you were aware that there was a plan in preparation before then.
I've seen the letter, and I think the letter actually confirms that there was no plan. This is why I would rather see it on the screen and discuss it like that than trying to paraphrase what the letter says.
Okay, so you were told there was some letter in 2018, but you were not aware that there was an ongoing process.
Is it possible to?
We
put
can
the
look at
letter
it,
on
but
the
my
screen?
question is not about the letter. So what would you
So
know about the process?
I was not aware before sometime in probably 2014 that the bus loop was going to be put on Obnova's land.
Okay, so that when essentially when you were taking office in August 2012 and or at some point thereafter, you tell me when you were told about the 2008 letter, there was not a matter of concern for you that there would be a bus loop on that. So there was a possibility, let me put it like
My
that.
understanding of the letter that I saw was, and I'm now commenting on this based on the memory, I would rather see it on screen, But my understanding of the letter was that in fact there was no plan to put the bus loop on Obnova's land.
Okay, and are you aware of any legal advice or other advice in relation to that issue? We're told that, I mean, because of this letter, someone before you, Mr. Obradovic, or someone else asked for legal advice from a law firm around the planning issue, about the planning process, anything of that sort?
No, what I'm saying is that the letter says that specifically.
That's a different question. Was there any legal advice around the planning process?
About the planning process.
Yes, whether the possibility that the plan would be changed, that there would be a bus loop, anything of that sort?
Not that I recall.
Okay. So then you say in, so going back where it is, it's 24 of your witness statement. It was an unpleasant surprise because I had not been aware of its preparation. But when did you actually become aware of the 2013 DOP?
I cannot pinpoint the exact time, but it was after the fact that the regulation plan was adopted. So it was probably sometime during 2014, but I cannot say specifically the date.
And how did you become aware of it?
I don't remember. It was probably told to me by someone, or I don't know how exactly I found out.
But then you did make some sort of inquiry, right? Because you then, about the process and all of this, or maybe you did not do that yourself, but you instructed someone to do an inquiry about the process, or how did you go about it? And after you learned,
So what?
but you learned about the plan.
After
Yes.
learning about the plan.
So did you then instruct someone to conduct a legal assessment, look into the process? What was your
I was
plan of
advised.
action?
Yes, I was advised by the brokers, but specifically by the lawyers. Specifically, but I was inquiring specifically about the procedure of adoption of the regulation plan. So how does procedure work? And I understand that it would be basically to revert the process, the option to revert the process, to say in those terms it would be to go, I think, to constitutional court, but that it was only limited to procedural matters, not to the substance of the plan. And my understanding was that there was no reason to go or much hope to go through that process to revert it.
And you received legal advice on that? That's legal advice that you received, but you just
I was told
summarized.
this by the lawyers, yes.
Okay.
This is not something that I would know.
And it's a written legal opinion?
Is it
Was it a written legal opinion that you received on the plan?
I don't think on that point that I have a legal opinion.
No
in
documents on that.
writing, yeah.
Okay. I think you'd all be very happy to hear that I don't have anything further.
Thank you very much. Redirect.
Mr. Markiewicz, you remember there was this one point where you said that you believe your answer was not complete with respect to the role of the Cypriot investors in connection with the initiation of this arbitration. I have like 6 documents to show, so it may make sense to switch the commands to our side. I was told that it should be done rather easily, but
If that's easily done, then yes, it would make sense for you to have control of the screen.
that was presented to me by a gentleman who is no longer here.
Well, let's use the
Yeah,
good
then I will,
offices
yeah.
of
Thank you.
Respondents Council.
Thank you. Yes. Mhm. Perfect. Thank you. Thank you very much. Just in time. Yeah. So
Let's just make sure that the screen works. Does the screen work?
no.
It was, there we are. Okay.
Yeah, so let's start exactly with this document. It's document C718. And this is one of the emails that you referred to in your witness statement, correct?
Correct.
So if we scroll down to the email which we had with the comments in red. And we will show you the entire email when you tell us that you have read the beginning of it.
Mhm. Okay. Okay. Okay.
Okay, so now having had the benefit of reading that email, could you please perhaps comment in greater detail
Mhm.
on the involvement of the Cypriot investors?
So this was one of the discussions that we had, for example, with respect to now this refreshes my memory that, for example, with respect to Serbian lawyers, they that represent claimants in this arbitration, they requested confirmation that there are no criminal charges against them in Serbia. Then we went through powers of attorney, we went through certain documents, and they revised the text of the documents that I asked them to that we discussed, etc. So yes, this is one of those discussions, and also there are also other over phone discussions with respect to these matters, but this email reflects what I was talking about.
Did the Cypriot investors act upon Mr. Rand's instruction when they were raising these issues?
No. Mr. Rand was not involved in these specific this correspondence with these are directors Kalemegdan, I believe, so he was not involved in that correspondence.
Do the Cypriot investors act upon Mr. Rand's instruction when you prepare and approve, among all of the directors, the financial statements of Kalemegdan?
On his instructions, no. So I would say that the process of preparation of financial statements is done by Cypriot directors. We have discussions about that, and with respect to Kalemegdan, I'm talking with respect to Kalemegdan Cyprus, then we file financial statements. With respect to Coropi's financial statements, we discussed this as well with Mr. Rand. Yes.
But does Mr. Rand instruct the directors, you must approve a number you are not comfortable with?
No, he never does that, and I'm pretty sure that Cypriot directors would not do something that they're not comfortable with, and neither would I. So, I mean, something that I would think is against the law.
Thank you. Now I'd like to show you document R027. This is the court decision which was on the screen a while ago. We should go to the paragraph, I believe it's on page 2, where the court provides its assessment of the warehousing services agreements. In the English version, it is the second paragraph from the bottom on the second page of the PDF, which starts with from the content of the agreement for providing and using port and warehousing services, number 1816, dated 16 March 2006. I would kindly ask you again to take your time and read the paragraph.
Okay, I read it. paragraph.
Does the court use the word warehouse there?
No, it uses warehousing space.
Does the court use the word lease there?
No,
Does the court use the word rent there?
no.
Thank you. We would, now I'd like you to go to document C 337, which was also shown to you. And this is the document which describes the status of Obnova's land as of September 2014.
Yep.
So first of all, one thing I would like to establish, did you prepare this report?
I drafted this report together with Mr. Broshko. Yes.
So if we look at the, what we say about the large parcel there,
Mhm.
is it your understanding that as of the date of drafting of that email in September 2014, Obnova had the right of use over the land?
That was my understanding and is my understanding, yes.
Now, and was that despite the issuance of the 2013 DRP?
Yes, I don't think the 2013 DRP affected Obnova's right of use. It affected only the, I would say, the scope of the use. So how Obnova can use the land, not if it can use it or if the Obnova has the right of use or not. For example, if it's okay, we can, so there is a part of the regulation plan which I think it's called implementation of the plan, which regulates how the plan is implemented. And I don't know if you can put that on the screen or.
Yes, we can. This is document C024.
So I think it's somewhere at the end of the plan. So one of the last matters is how the plan is implemented.
Yeah, so we, in English, we may go to page 32 of the PDF.
I just saw that paragraph on the screen. Just if that's the one.
And just to be clear, this is the DRP.
Correct.
This is the end of it.
Yeah, I didn't introduce the document we're pulling, but yes. This is
So this is a paragraph starting with until all existing and the whole paragraph. So this is the only, in my understanding, the only effect that 2013 plan had on Obnova's scope of use of the land, to say in those terms. Until all existing facilities planned for removal that are located within the borders of the plan on planned public development parcels have been confirmed to the designated use, they shall be kept in the existing condition. So no new construction or extension is permitted on them. Current maintenance of facilities and adaptation is permitted. So my understanding is this is the basically Obnova still has a right of use over the land, but we just can't build anything there. We cannot replace the existing buildings with the new buildings. We can basically paint the buildings and use them as they are and the land as well, but we cannot, anything that would require a construction permit or any kind of reconstruction permit would not be possible. So this is the limitation, how I understand the only limitation that in that respect plan made, but Obnova still remained the user of the land.
Now, at about 1813, you were asked a question, and I will quote, but that means you haven't seen any document or evidence that says by any authority or anything like that, which says Obnova has the right to use the land. To which you responded, my understanding is based on the fact that Obnova built the buildings, which maybe does not entirely answer the question. So have you seen any documents from the cadastre, for example, which confirm the existence of Obnova's rights?
So yes. I mean, my understanding of the question was there a legal analysis or something? But yeah, there are cadastral maps that were part of that process where we, as I mentioned, Ms. Gordana Kostic was engaged to do the mining part of getting documents. At some point in those some cadastral maps were basically they appeared where Obnova was basically shown as user of the land on both occasions, Dunavska 17 to 19 and then Dunavska 23. So these are official, as I understood it, official maps from the cadastre, and it appeared that cadastre recognized that Obnova is the user of the land.
Yeah, so could we show to you document C329, page 3?
This is, yes, this is one of the maps that I just referred to.
And there's more. In the interest of time, I will not be showing the witness all of them. We did that in the opening statement.
There are more, yes.
Well, thank you. That concludes my redirect.
Thank you. Just before coming to any questions to the from the tribunal, as there may be, just an observation to claimant's counsel. Just an observation to claimant's counsel, because this may just be a typographical error. Otherwise, if it's not, then there is an issue that will require sort of addressing. If you have a look at Mr. Broshko's first witness statement at paragraph 34, it has a reference to the DRP, and the footnote cited to begin with, the 213 DRP expressly prohibited any development on the land affected by the plan other than the envisaged bus loop. And I think this is exactly the point that the footnote refers to paragraph 6 of that. And I, for one, have struggled to make sense of that reference.
Yes, this is one of the reasons why we asked the question. I believe what happened is that there is a typo. It was supposed to refer to page 69, which is the page of the Serbian original. So that should have been converted to whatever the English equivalent is, but that is what the team had in mind when it prepared the footnote to Mr. Broshko's witness statement.
Thank you. So my reading was not in vain. In any event, I think that there are some very brief questions, as I understand it, from members of the tribunal. I'll turn first to Professor Douglas.
The hint that they need to be brief is well taken. Just a very general question to start with. I understand that you were the general manager for AB Agro and for the other, Mr. Erann's other companies in Serbia, also a director of those companies.
Not all of them, but some other companies, general manager, yes, a few other companies in Serbia.
What percentage of your time would you say that you were having to spend on Obnova, given those other responsibilities?
This is really hard to answer. It really depends on the times. For example, when I was in BD Agro from 2013 to the end of 2015 or so, I would say that took most of the time. But at some points in time, in some periods, Obnova took most of the time. Then there were other companies. It just depends on the matters that had to be dealt with.
Understood. And I recall an answer to one of Council's questions about the DRP. You said that you didn't find out about it contemporaneously. It took some time. Can I assume then that you didn't have lawyers instructed on your behalf or on behalf of Obnova to keep you abreast of any events or developments that may be relevant to Obnova?
That would be, normally they do bring to my attention any events that are with respect to the matters that lawyers are dealing with. But this is really, I would say, if I say that it wasn't a transparent process, it would be an understatement. And this is why, I mean, the whole process of adopting the 2013 regulation plan. And the reason why in my witness statement, I talked about protests that happened during COVID time. So this is central area in the city with, I think, several tens of thousands of people live there. So most of that area is residential. And the fact that people only realized that something was going on during COVID time, and during COVID time they went out to protest in streets. And so I believe that it was explained on the opening statements what the bus loop envisaged, that it's a way where the buses are going, but it's also those trolleys and electrical lines. So a part of preparations of that in another street, city started some construction works to change the position of those electrical lines, and that is what triggered people to go out and protest. And in the whole process of adoption of the 2013 regulation plan, there was only, I learned from looking into documents during this arbitration, there was only one person who filed an objection, which is, I understand, city that has no obligation to
This is answer. You might want to keep your answer short, because otherwise the president's going to kick me. I'm going to be blamed for
I apologize. So that is my point. It was very untransparent process.
Okay. But by December 2013, it had been officially published. So I imagine lawyers would probably know about it by then.
December 2013,
yeah.
It is when it was adopted. I'm not sure when it was published and where and how it was published. And my point was that if it was published, and it was in the way that to keep it as low profile as possible, which is why people found out only much later.
Okay. And you in answer to my question at the start, I think you said you did have lawyers that were monitoring events for you on behalf of Obnova.
Yes.
And when were those lawyers instructed, and who were they?
So sorry, when
were those lawyers instructed, and who were they?
So at the time, we were working with the company, with the law firm Slobodan Doklestic and Partners, or something like that. So I think we are now talking about 2013 and 14. I think they were in the picture at the time, and we had almost daily discussions. I was also in BD Agro at the time, so it was many matters to discuss. So any matter with respect to the Mr. Erinn's companies that they dealt with, they would of course bring to my attention if they found out first.
Were they instructed not long after you took up your position, or do you remember exactly when they were instructed?
When they were before I was engaged, Mr. Erinn and Mr. Broshko cooperated with the Karanović-Nikolić law firm, which is mentioned in the filing. So Mr. Slobodan Doklestic is one of the lawyers from Karanović-Nikolić who then left, and then I don't know exactly when this happened, but basically we followed, continued working with him when he left Karanović-Nikolić.
Okay. If we just bring up paragraph 34 of your witness statement, first one. It says here halfway down that you're advised that this new law governing legalizations, you're advised about something. Who advised you on that? Do you remember?
Give me please a second to read that. So we are talking about this. Obnova did so because...
Exactly, yeah.
Okay. This would be Slobodan Doklestic law firm and someone from his office who was
okay. Yeah. And so, on the basis of that advice, you filed that request for legalization on the 29th of January 2014. You see it referenced there. Yes, and that's a document that you signed and submitted. Yeah. Was that filed at that point in time? This is a month after the I always forget the abbreviation, the DRP. Was this something you did in response to the DRP coming up?
No, I think if I didn't explain here, so there was already a request for legalization at the time. So this is just continuation of our attempts to legalize the buildings.
But those applications date much earlier, don't they? They go back to 2003.
And I think there is 2010 and etc. So what I meant to say here is that there were many changes, I think 5 or 6 changes in these legalization laws. And every time a new change would be made, we would file again, even though it was by some people interpreted that you don't need to file again. It's considered that if you filed in 2003, basically your request for legalization survives all these changes, and but to be on the safe side, we file them just in case.
So there's no connection between you filing that in January 2014, the DRP coming up?
No connection, no.
And yet the firm that advised you to do that didn't mention the DRP in January 2014.
As I said, I don't remember. Sometime during 2014, I found out about the regulation plan. It may be January. I really don't remember when exactly what that happened. So I don't know if this was. It's more likely that I found out after this date about the regulation plan change. This is just a month after, and I don't even know now when the plan was published and made available to public.
And you would have known presumably then before you drafted that memo to Mr. Rand in September 2014.
Was I aware about
the DRP?
The DRP. I think I was aware at the time. Yes.
But you didn't communicate it to Mr. Rand at that point.
It's not mentioned. I mean, we in that email we talk about the Obnova's ownership rights over the buildings and right of use over the land, and we were talking about our progress with respect to registration of the rights. And as I mentioned earlier, just to give Mr. Rand heads up, we are going in this direction, and you may have to deal with the creditors soon if that happens.
Okay. Well, thanks very much. That's very helpful.
Before I hand the microphone to Mr. Janet, just let me follow up on one line of questioning from Professor Douglas. This email in C337, which we don't need to call up, it's of September 2014, where it says Obnova has the right to use it. From your response on redirect to Claimant's Counsel, it seems to be quite clear that you knew of the DRP by September 2014, certainly because your testimony appears to be that you formed a view of what the DRP did and didn't do, because we've just had our attention taken to page 32 of the English version of the DRP, and you've given us an interpretation. So I just want to be clear about the timing, that by September 2014, when that email was sent, which you had a hand in drafting, you were very well aware of the DRP, but you interpreted the DRP in a particular way.
I think this is most likely. I cannot pinpoint as I said, the date, but at that time, I think I knew about. I found out until that email about the DRP. Yes.
Right, because you're giving an explanation as to that language in the email,
yes,
and saying that it's based on this. So you were aware of it. But again, you didn't either in that email or in the subsequent Skype meeting that you and Mr. Broshko had with Mr. Rand, you didn't discuss the DRP with him. It's not referenced in the email at all.
It seems to be that this email is talking specifically about registration of ownership. I know that from the moment when I found out about DRP, we had many discussions about that, but This email is let's say part of the conversations that we had, and a specific matter that I addressed here, which is a registration of the ownership over the buildings, and this is mostly focused on heads up. You may have to deal with the creditors. I mean, this specific paragraph.
Thank you very much. And you just said once the DRP became known to you, I think your language was, we had many discussions about the DRP.
Yes.
This is not a question to you, but it's an observation to counsel on both sides. I think we would like to know what's in the record as regards those discussions, but that's something that we can come back to later on. Let me hand the microphone to Mr. Chair.
Sorry, I may be repetitive, but it's a bit late. I understand you are the general manager of Obnova, right?
Correct.
Since, the
2012.
Yeah, 2000, yeah, 2012. So you are the one that has the dealing with lawyers, I assume, right?
Yes, sometimes.
You hire them, for example?
Well, this is so lawyers are hired, let's say, as they do the work for the entire group, all Mr. Erenn's companies in Serbia. So Obnova specifically doesn't have a contract with lawyers, but they do deal with Obnova matters.
On the companies
and other companies from the group, yes.
But you dealt with them in discussing the
Yes.
2013 DRP, and we have seen in the record there have been a number of submissions to administrative authorities, to court. That's something that you have been overseeing.
With respect to I don't know specifically what filings in the court you would refer to, but as a non-lawyer, I like to be kept in the loop, but I cannot. Lawyers would usually draft a submission to the court, send it to me. I would revise if I have something to add, but it's
that's what I'm meaning exactly. Yeah. That you are, as let's say, the business person that you are dealing with.
Yes,
with
yes.
And the law firm has been the same or has been changed?
It changed over time. So today we are represented by Mr. Nenad Stankovic's office. So at the time of this email, it was Mr. Slobodan Dokleskić in his office, I believe.
And when you say that you have discussion around the 2013, the DRP, and the possibility of challenging or not these constitutional remedies, is with him that you are referring?
Yes, with Mr. Dokleskić and his lawyers from his office.
And you were the one, or one of them?
Yes. I mean, Mr. Broshko was involved as well, but I would say on day-to-day basis, especially at that time, since I was in BD Agro, we had many issues. I almost daily had conversations with them.
And one last question. We see in the record that Obnova at some point stopped being a scrap metal company, or stopped doing that business and move into the business of leasing the property. So
yes.
Can you give me a time? You were there already? Was before?
It stopped doing that before so when I got there in 2012, it was already so it was already stopped the scrap metal operations. So currently Obnova leases out all of these facilities in Dunavska 17 to 19 and 23. And from the documents that I try to also reconstruct what was going on. I think that, for example, the first lease agreements that I see that Obnova is leasing out to third parties, part of its premises is, I think, 2006. And then we see more and more of these agreements and less documentation with respect to the scrap metal business. I think from what I've seen, it's around 2010 when it stopped. And also it's, for me, it's one thing that really is like elephant in the room, that from the Port of Belgrade, Luka Beograd court litigations, it seems that the last invoices that were matter of subject of those litigations are around 2010, around the same time that Obnova stopped basically its scrap metal business. So it's this is why I refer to it. It all makes sense that this was actually some kind of providing services by the port to Obnova. Obnova after that was just leasing out its premises.
And the current situation as of today is that you are leased out the property.
Yes, both locations are fully leased out to third parties, they're paying rent.
Okay, thank you very much.
Just one last question from me, and then we will end for the day. And I don't think anything turns on this, but I just want to be absolutely clear because it goes to the line of redirect questions in relation to the directors of Kalemegdan and why they inquired as regards the investments and so on. I mean, you are a director of Kalemegdan and of Coropi.
Correct. Yeah.
Your first witness statement testifies to the circumstance, factual and legal circumstance, that if Mr. Rand so decides through Coropi, he can give directions to Kalemegdan.
Through Coropi, he can give, to the extent that, for example, Kalemegdan's directors are confident with that something is, against the regulations.
Yes, they are obliged to, in terms of the contractual or the trust arrangements or however it's described, to follow Coropi's directions.
This is my understanding. Yes.
And we've seen a document on the record. So let me put it to you like this, and you tell me whether I've got it wrong or whether you agree with this. That you and Mr. Broshko would keep Mr. Rand updated on developments in Serbia. If either you or Mr. Broshko thought that Coropi should give instructions to Kalemegdan, you would advise Mr. Rand to do so. And as we've heard from Mr. Rand, he's not so preoccupied with the detail. He would take your advice and he would give instructions to Kalemegdan under the authority that Coropi has vis-a-vis Kalemegdan. Is that accurate?
This is, there are not so many, both companies, Kalemegdan is a company that holds certain assets. So there is not a lot of decisions being made. The best example that I can give is commencing this arbitration. So this is one of the, so we did all the work, and then at the end of the day, everything was presented. The ultimate decision was Mr. Rand's decision to commence this arbitration. To execute that decision, then there is some procedure to be done, like Kalemegdan's directors adopting decision and signing the paperwork. But without Mr. Rand's ultimate decision to do this, this would not happen.
I understand, and my understanding, and you welcome either to comment on this or not, but my understanding is from your evidence that the directors of Kalemegdan, as a matter of due diligence, had to ask the various questions that they asked because issues around, for example, the criminal record of individuals had to be certified, and therefore this was a legal duty for them to ask. Is that correct?
That is my understanding.
Thank you very much. Any further?
I don't, but there's a reason we have all these Serbian lawyers on our team. So my colleague, Dr. Jeric, had one follow-up question.
Thank you. Please bear with me with a couple of more minutes. This is related to the exhibit R27. That is the Serbian court decision where Mr. Markicevic, Mr. Pekar asked you.
Sorry, I'm sorry, Mr. Jeric. I think that your questions now are limited to the tribunal's questions. These are not redirect on redirect. So if
we didn't have a chance to have a redirect after Mr. Pekar.
You don't get a redirect. You don't get a redirect after Mr. Pekar.
Okay.
I mean, the opportunity to ask questions now is in respect of anything that has arisen from the answers arising out of the tribunal's questions, but that alone.
Okay.
As I understand, there was actually a question related to the lease. So that is a follow-up question. And
If it is a follow-up question, then you can ask the question.
It is also related to lease. And we have really short question. Thank you.
Mr. Markicevic, in response to Mr. Yana's question, I think that he said that at about 2010, the port was providing certain services to Obnova, and he referred to the services agreement. And he said these were the port services. And now I would like just to refer him to R27. if you could do that, and that's the page 2 of the PDF, the second full paragraph. Yes, and it's the decision about one of those services agreements. And Mr. Markicevic, if you could read the first sentence of the second full paragraph, which starts with the words "in its objection on the ruling for enforcement." And if my colleague could highlight that part, I would be grateful.
I think the screen is a Claimants Council screen, so if you could.
Or the whole sentence, please. Or the whole paragraph. Thank you very much.
Can I please see the, I didn't see what document this is.
That is the document R27. You can see the.
Mr. Markicevic, let me perhaps try and assist counsel on this. This is the document which Claimants Council, Mr. Pekash, took you to and asked you to read a paragraph and then asked you some follow-up questions. Is warehouse referred to anywhere? Is lease referred to anywhere? And you said no. And Respondents Council is now taking you to exactly the same document and asking you to read 2 paragraphs higher up in that document.
I understand.
Yes. And Mr. Markicevic, if you have read, may I ask you, is this defendant that is Obnova, right? Can you confirm that?
I understand it.
Okay.
Yes.
And is the defendant in that sentence that you have read refer to the plaintiff's claim for rent?
Can you take me please to the Serbian version just to make sure that the same paragraph, if
Okay,
it is
sure.
not. Yeah.
That is the page 7 of the PDF. Again, the second full paragraph. First sentence starts with tuženi u prigovoru na rješenje istakao.
Yeah. Okay. Sorry, what is the question? We can go back to the English
So
version.
the question was whether Obnova is here reported as referring to the claim as a claim for rent.
I mean, I see the word rent there, but it's a court decision. I don't know if that's the interpretation of what is said in the.
Thank you.
Perhaps I can assist counsel for both parties on this point,
Yes.
because we've heard a lot about this. I think it's a matter for the tribunal's legal appreciation, where what the Respondents Council has classified as a lease agreement and what Claimants Council have classified an agreement amounts to an agreement which has got nothing to do with leasing, or is a lease agreement properly so called. This is not a matter of fact relating to a court judgment for the witness. This is a matter of our appreciation. We've heard submissions on the point. Now, I think that's the end of your redirect. Anything more from you? Thank you very much. Well, Mr. Markicevic, thank you very much indeed. We have been very much assisted by your testimony, and it's gone on a little bit later than we anticipated. But we are very grateful for that and for your close attention to the detail. And you have additionally clarified that one of the footnote references in the witness statements was incorrect, and therefore we know where to find the various references. So thank you very much indeed. And I think for the 3 fact witnesses who are here in the room, subject to the caveat that I addressed to both counsel when none of you were in the room, that we would like to reserve the possibility that the tribunal, if we have questions, inquire of you further about these issues of fact on Friday. Subject to that, you are all released from your testimony and you are not sequestered. You can talk to each other.
Thank you.
That's a matter for you. Your counsel will not have any time to drink wine.
That is good
Um,
news.
So I very much appreciate that. My last observation is going to be that while we have made some progress in catching up, we are perhaps 50 minutes or so behind. I propose, I have not consulted my colleagues, so I may get, yes, I propose that we start at 9 o'clock tomorrow morning just to see if we can make up a little bit of time. Any objections? Let the record show that there were no objections. And I think, Mr. Anway, you have a last word.
Yeah, just a personal matter. Unfortunately, I have to leave Paris tomorrow. Obviously, you in good hands, but I wanted to just note that for the record and to thank you again for the opportunity and honor to be before you.
Thank you. I think Mr. Rand is the one who's going to be feeling vulnerable, seeing as you led him in his examination. If he's called again on Friday, he's going to be without his lawyer. So thank you very much. Have a good evening and see you tomorrow at 9 o'clock.
Thank you.